Welcome, everybody. Welcome everybody to the Arkansas Oil and Gas Commission special hearing for the lithium royalty. We're a division of Arkansas E&E, and now I turn it over to our director, Larry Bingle.
Thank you, Chairman. Thank you, Chairman. We have a lot of folks here today. That means there's a lot of cell phones. So if you would all silence your cell phones so we don't have those ringing and going off during the proceedings, it would be greatly appreciated. For the commissioners and the applicants, these are very directional mics. So make sure that you speak directly into them so that everyone can hear, especially the court reporter. Also, this proceeding will be broadcast through the E&E department's YouTube. So once again, have to speak into the microphone so that those watching can hear the proceedings. Thank you. Turn it over now to the hearing officer.
Thank you, Director. Thank you, Mr. Chairman. This is styled before the Arkansas Oil and Gas Commission. The order reference number 050-2024-09 in the matter of the joint application of Albemarle Corp. et al. For the determination of fair and equitable compensation. I think for everybody's benefit, it would help to have introductions. So we'll start with the commissioners. Commissioner Welford, could we start with you and we'll just move on down the line? Would you be so kind as to identify yourself?
My name is Charles Wolford. I'm from Fort Smith. I'm by profession a petroleum engineer.
I'm Commissioner Mark Thomas from Magnolia, Arkansas.
Name's Robert Liner. I'm from Fort Smith, petroleum geologist.
My name is Benny Westfall from Fort Smith, and I'm a businessman in the oil and gas bit.
I'm from Fort Smith, Arkansas, petroleum geologist.
I'm Philip Norville. I'm from Fayetteville, Arkansas. I am a retired law professor.
Ryan Stacks, an attorney, Damascus, Arkansas.
Jim Phillips. I'm an independent oil operator, Smackover, Arkansas.
And I'm Jerry Langley. I'm an oil and gas operator out of Smackover, Arkansas, and I'm the chairman of the board.
The commissioners. Mr. Daly, we'll start with you. Oh, Ms. Clegg, start with you. I'm sorry.
Arkansas, and I'm attorney for Saltworks.
Ms. Clegg, I don't think your microphone was on, or if it was, we didn't hear you.
Try that. Better? No.
Yeah.
My name is Carolyn Clegg. I'm from Magnolia, Arkansas. I'm attorney for Saltworks.
I'm Daly. I'm an attorney from Fort Smith, representing all of the co-applicants.
Bob Honey, representing SWA Lithium.
Alan Perkins, I'm an attorney from Little Rock representing the South Arkansas Minerals Association.
Forrest Stowball, attorney from Little Rock, along with Jim Rankin. I'm representing a large conglomeration of mineral owners in South Arkansas. And I'm happy to identify all those right now if you want me to, Judge.
Let's go. Jakey.
You want to go ahead?
Yes, my name is Patrick Hickey, and I am representing Simmons Bank in its capacity as trustee over various trusts that own minerals throughout this formation. I'm also representing an individual named Mr. Wayne Weathersby. I'm also representing a family that I've referred to in my pleadings as the Edie family. It's various trusts and individuals. And finally, I'm also representing a family limited partnership named M. Johnson Family Limited Partnership. Thank you.
Thank you, sir. Thank you, counsel. All right, how about opening statements?
Can you hear me?
Can now.
Mr. Honey, Ms. Clegg, and I are here on behalf of 5 companies that are competitors of one another, but have a common need for this commission to approve their joint proposal for compensation method for royalties when they begin to profitably extract lithium.
Mr. Daly, could you pull the microphone just a little bit closer to yourself?
I'll do what I can.
Yep.
Well,
Thank you. Even better. Thank you, sir.
okay, how's this?
Perfect.
Okay, if I don't create any feedback.
Yeah.
Okay, I'll start again. Mr. Honey, Ms. Clegg, and I are here on behalf of 5 companies, all competitors of one another, but have a common need for you to approve their joint proposal for compensation method for royalties when they begin to profitably extract lithium from the Smackover brine. The reason why the commission's involved is because the Arkansas Brine Conservation Act requires that compensation be determined here and paid to royalty owners when profitable extraction begins. And the co-applicants expect and believe that that extraction will be profitable. And if they didn't believe that, they wouldn't be here. So why are they asking it to be determined now? The answer is simple. They need to know whether they can make the enormous capital investments in these projects. And this royalty increment is a major piece of that. The brine business is a bit complicated. You need to understand a little bit of history, I think, in order to really understand what we're talking about. 3 exhibits, which were pre-filed, C, D, and E, are separate published accounts, papers written by 2 by an attorney, 1 by Margie Blair, who you know is a very, very capable executive and landman, explaining the history surrounding the early days of the brine business. And when you read those, you read that this is sort of like deja vu all over again. Very much of what they write is what's going on again here today. In 1955, Smackover brine was analyzed and found to have abnormally high concentrations of bromide salts, giving rise to a brine industry which is actively operating in Union and Columbia counties today. And here's how it works in the field. We're going to refer to the underground brine as virgin brine, which is the way that some in the industry refer to it. And the virgin brine is produced from down in the Smackover, 2 miles down about, by production wells that look a lot like oil wells, but they're bigger. They're bigger in diameter, and they have substantial electric pumps at the bottom to very rapidly lift large quantities of the brine. And when it's at the surface, it's combined with brine from other production wells and is transported by pipeline to a processing plant where bromine is currently extracted by a chemical process. And then what we call now tail brine, T-A-I-L brine, is piped back into the field and re-injected back into the Smackover. That re-injection both disposes of the tail brine without any environmental damage and maintains the Smackover's reservoir pressure. Both are important. Also, the effect of the injected tail brine is to sweep additional virgin brine as a water flood toward the production wells, causing the underground virgin brine in between to ultimately be replaced by tail brine, hopefully after a long time. 2 Arkansas court decisions in the 1970s found that to do that resulted in a trespass as to unleashed tracts in between the injection and production, which, because of the water flood effect, had their virgin brine ultimately diluted and maybe ultimately replaced by tail brine. And because of that litigation and the potential for trespass damages, which would shut down the industry, the Arkansas legislature got in the act and enacted the Brine Conservation Act. The Brine Conservation Act regulates now brine production and disposal in the field. What the Brine Conservation Act does not do is regulate the extraction of chemicals at the plant after they leave the field, nor does it regulate the manufacture of products after bromine and other substances have been extracted. It merely regulates what goes on in the field. And it contains an integration provision, which is like the integration provisions that you're all familiar with in oil and gas. And in that, an uncommitted owner at the time of unitization, an uncommitted owner is afforded options. And those options include the option to participate, to pay his or her share of well costs in the field, both production and disposal. And if a owner elects to participate, and we have participants today, and I predict we'll be having participants in the future. If the unleased owner elects to participate, the unleased owner then has options. And one of those options is to take their share of the brine, go off and process it however they want to. They're only required to bring it back so that it can be re-injected back into the smackover, which is a requirement. Obviously, if it is a producer, that's the election that they would probably make. But if an ordinary citizen decides to participate, that ordinary citizen is unlikely to have the facilities to process brine and take out bromine, lithium, whatever. So that ordinary citizen, if it elects to participate, has another option, and that is to sell his or her share of the brine back to the operator. And then the statute goes on to explain how that price is determined. And there's a plan A and a plan B. Plan A is that the price is the average price at which brine at the wellhead has been bought and sold in the same unit. Well, you probably figured out that plan A doesn't work because nobody buys and sells brine at the wellhead. So plan B is very simple. You take the average royalty in the unit and you multiply it by 8. 8 times the royalty equals the price that is paid to a participant. So the bottom line of that is that you're not only setting a royalty, but you're setting a participant value, which is going to be 8 times that. The Brine Conservation Act also sets this minimum royalty, and it sets a minimum royalty for substances commercially extracted prior to January 1, 1979, which is a really long way of saying bromine, because it's the only such substance. Originally set it at $25 per acre per year. In 1995, that was amended to $32, and the legislative wisdom, and it was wise, in 1995 was to then tie that $32 to a government inflation index, so that each year, if the cost of living increases, what we used to call the producer price index, which is a wholesale index, will cause the statutory minimum royalty to increase by that amount, although it can never go below $32, again, according to the statute. Today, it's $65 and a nickel. $65 per acre per year for the privilege of moving brine from the Smackover to the wellhead. What you do with it doesn't matter. You still pay the $65. But the statute goes on to say that if you ever extract anything that was not commercially extracted on or before January 1, 1979, once again, that's bromine, then you must make a fair and equitable accounting for that additional substance. And that's why we're here. We're here because these co-applicants propose to extract lithium in the form of lithium chloride solution from brine, ultimately, probably within a fairly short number of years. Well, this is not the first time this has happened. This is exactly what happened in 2007, actually. Tetra Technologies sought to utilize some of the tail brine in the West plant operated by, now operated by Lanxess Corporation, which at that time was Great Lakes Chemical Corporation, and extract 3 salts: sodium chloride, calcium chloride, magnesium hydroxide. And just as today, Tetra needed to know how much additional royalty would be required before it committed to spend hundreds of millions of dollars to build the plant to make that happen. And the commission agreed, and in its order number 173, 2007-04, it set a royalty for the salts. And the methodology that it used is the exact same methodology that these co-applicants are proposing to use today for lithium. It was fair and equitable then, the commission so found, and we believe it is fair and equitable today. One more thing. We need to be clear about what's being valued in this royalty process. Both the Brine Conservation Act and the cases which preceded it are very clear that the substance that you are valuing for royalty purposes is brine. It is not something removed from the brine, nor is it some down the road end product made out of that something removed. It is the increase in the value of the brine at the wellhead that is occasioned by the ability to extract, in this case, lithium. There are objections which somewhat confuse this issue. They want you to apply an oil and gas-like royalty on final products manufactured from lithium that aren't even all lithium. And that simply won't work. And when you take that and multiply it by 8, you realize how badly off it is. It's sort of like trying to value crude oil at 100% of the value of jet fuel or unleaded gasoline. And additionally, they want to invade the co-applicants' proprietary data as though the co-applicants were a regulated public utility in order to determine and regulate the co-applicants' profits. In so doing, they would make trade secrets public, exposed to customers and competitors. And the fact is that the co-applicants are not utilities. They're competitors of one another and competitors of any other producers who come into the business. Utility, by definition, is a monopoly. A utility doesn't have competitively sensitive proprietary data because it doesn't have any competitors to protect against. And importantly, a utility is guaranteed to make a profit. If it fails to make a profit in a given period, it gets to raise its rates to make up the shortfall. There's just no similarity. In summary, we believe that we've designed a lithium royalty methodology which is not only fair, but also will be transparent, workable, and avoid the obvious problems of trying to track direct costs, capital costs, intellectual property value, all those things. I'm not going to get into it because we're going to explain it over the course of the morning and perhaps into the afternoon with a number of witnesses who will do it piece by piece. That concludes my statement, sir.
Thank you. Thank you, Mr. Daly. Before I hear from other council opening statements, I have one comment card that's been filled out and handed to me. I do not know if folks filled out comment cards, and we will get to public comment shortly after we get through a couple of other procedural issues. But if anyone has filled out a card, but they're holding on to it, would you be so kind as to pass them down to the center aisle? Because the folks that want to make a public comment, we'd appreciate you filling out a card.
Moulton, do you want us to introduce our exhibits and swear witnesses?
We'll get through that when we get through the comment, through the recommendation. So a few more procedural hurdles before we get there.
I'm fine with that. I just wanted to know.
Understood. Ms. Clegg, do you have an opening?
That was for all the co-applicants.
Thank you, ma'am. Mr. Honey?
I'm speaking for all of it.
Thank you, sir. Mr. Perkins?
Yes, thank you, Judge Moulton. And we're going to use a PowerPoint in opening. So I'm looking at Cole back there. Are we connected with our computer here?
Hopefully we'll be able to read it on the iPad so we don't have to turn around.
Is it up? It should come up on the screen. He's got to figure out which computer here.
We're working it.
Yeah.
Fine, anyway. Well, while you were working on your logistics there, Mr. Stovall, do you have something that you would like to open with?
Yes, Judge.
Please proceed.
As I indicated earlier, Mr. Rankin and myself represent a large conglomeration of South Arkansas mineral owners. Specifically, our clients are Robin Cheatham, Pat Cheatham, Tyree Sherman Jr., Robbie Sherman, Elizabeth Burrell, Janice Bradford, Joyce Martin, James Bradford, Olivia Sherman, Wanda Williams, Emma Jackson, Terry Williams, Dorothy Jordan, Thurman Story, ST Crone Limited, Indaba Investments, Pan Am Energy Inc., Anthony Energy Limited, Janice Weatherspoon, Gary Wallace, Leonard Wallace, Gregory Wallace, Lloyd Parker, Rebecca Boatman, Terry Reagan, Jenny Crone, Patricia Nelson, Herman Parker and the Corbin and Bell families, Mary Spencer Depper, Diana Spencer, Frederick S. Spencer, Billy Pierce, Antoine McLean Jr., Evelyn F. McLean, Sandra Mitchell, Wilfred Robinson, and Thomas Robinson. Collectively, our clients own about 26,000 acres of minerals. Their minerals are across all of what the applicants have referred to as the referenced counties. So that would be Union, Columbia, Lafayette, and Miller. Our clients own anywhere from as few as 2 mineral acres to about 14,500 mineral acres. And they have brine under lease from each of the co-applicants as well as some unleased acreage. So that they kind of represent a wide cross section of everyone, all the stakeholders on the mineral owner side of this issue. For the sake of brevity, our clients are very similarly situated to Mr. Perkins' client, the South Arkansas Minerals Association. And we would echo and adopt the argument and evidence and authority that he sets out here today.
All right, thank you, sir.
Good morning. Like I said, my name is Patrick Hickey. I'm originally from El Dorado, and I live up in Fayetteville, and I represent various different clients that I listed off earlier. I'm gonna try to keep this as short as possible because I know y'all have a lot of information to digest today, and it's gonna be really dense. I filed objections on behalf of the clients that I listed off, and I listed off various issues within those written objections that my clients objected to. I think it would be good to just kind of take a pause and back up at 40,000 feet for just a minute and think about this situation. Many of you are oil and gas producers, and you know that brine has been an issue with oil and gas production for years and years before the brine industry came along and started to be able to pull this stuff out and monetize that. And luckily, the brine that we have down here in South Arkansas has valuable stuff in it. Okay. And I know I'm not telling you guys, the commissioners and the judge, anything that you do not know. Okay. But some of the things that I'd like to kind of point to and harp on is that when these brine leases were taken and when the act was passed, like Mr. Daly said, it mirrors much of the Oil and Gas Act. So it's there to protect the correlative rights of the landowners and discourage waste and encourage the production of these natural resources that we're lucky to have. Okay. And when the successors to the producers started producing this brine, the only thing that they could pull from that brine is bromine. And they would use this bromine in the chemical processes within their facilities. And it's created jobs, it's created infrastructure investment. It's been great for our community, okay? But there wasn't a secondary market where they could sell this stuff. They used it in fire retardant materials, additives in gasoline, and their chemical companies. And because there was not a place that they could turn around and sell this, rightfully so, the legislature decided that they need to pay the mineral owners. And they couldn't figure out a good way to do it. And so they came up with, in some cases, they call it a rent in lieu of royalty or an in lieu of royalty. And they pay that based off of a mineral acreage basis. And it's paid yearly or quarterly, depending on how large those payments are, okay? And throughout the Brine Conservation Act and the Oil and Gas Conservation Act, in fostering the protection of the correlative rights, transparency is underlying throughout all of this, okay? And you had folks that had this waste product, and then all of a sudden somebody wanted to give them some money for it. And that was great, right? It helped the oil and gas producers, it helped the chemical companies, it created these jobs, and it put a little bit of money in landowners' pockets, everyone from large landowners to the small people that took these checks and paid their property taxes or were able to buy a Christmas gift, okay? And then you move along, and the laws have shaped and shifted a little bit and tried to create a situation that was reflective of the reality of the situation, okay? Like Mr. Daly said, in 2007, they discovered they could pull something else out of the brine, salts. And they went through a process that I don't believe from reading the pleadings that there was much resistance to that because there wasn't a large monetary value with that and there wasn't a secondary market. And that went through and they did that for a while at the locally what we call the Tetra plant around here. That eventually folded up and they no longer produced that. And then 7 years ago, maybe even longer, they discovered not only that we have lithium, I think that we knew that before, but all of a sudden the world landscape shifted and we've moved to trying to produce things that would store energy, whether it be in cars or larger massive solar projects that we're starting to see in this area. I mean, that's what they're using this stuff for. And with that, then we were fortunate to have this regulatory process, the infrastructure in the ground, the plants that can process this, and that has driven people to come here and think about investing in our community, and it's great. And the majority of the people that I talk to don't want to stop the lithium production. Okay? My clients and the majority of the public that are concerns, parties in interest to this, they're mineral owners that own this lithium, first ask the first question, what are they going to do with my lithium? The next question that they ask is, I got some lithium down here and I want to get paid the fair price for it. And we have a regulatory structure and a statutory structure that I think may allow us to do that. But I think it would behoove everyone to take a pause and think about this as a larger situation. And so I won't reiterate the point by point in the objections that I filed. They're there in the record. There was a brief filed in support of that as well. But I think the one thing that I would say with regard to the nitty-gritty detail of all of this is if you go through that act and you look at it, and specifically 315C 1, 2, and 3, you will see that producers of the brine that can pull something else out other than bromine have to pay the mineral owners their fair and equitable share. How do they do that? When they start producing it and they can prove that it's profitably extracted, they must come to you all and seek a determination of profitable extraction. They have admitted they have not profitably extracted. I would argue that I think that money has changed hands to be able to access this brine, and maybe it is commercially extracted because you've got to secure the right to get a hold of that brine. Several of these co-applicants are the lessees, but some of them are not. They have joint operating agreements. They have warrants or options within these projects. And if you look at that, I think there's two ways that trigger this paying of these mineral owners. And one is this profitable extraction coming to you all and asking for y'all to determine that that's the case. And how do they do that? If you look at it clearly, you're supposed to net the cost against the revenues, just like an accounting action in a probate court here in Union County. The other way is a demand for an accounting by the landowners. The process is the same. They open up their books and they show their cost. They show their revenues. And thus far, I have not, I think the closest thing that we saw was in the last docket matter with the pilot plant and then moving forward with the request to have a determination of profitable extraction and to set this royalty rate. And when they showed their numbers and all of the people looked at them and the good folks over at PPGMR hired an economist from Houston to look at this and reverse engineer it, they showed that not only that they were profitable, but they could pay a 1/8 royalty, which is also provided by the statutes. If I own minerals and I refuse to lease, it states there that I've got a right to get 1/8. And Mr. Daly said, well, you get 1/8 at the wellhead. Well, these are suspended minerals within this brine solution. And I would make the argument, and I would hope y'all would hear, that you get 1/8 of that mineral too. They're not adding additional value and they're not combining products to make it something of greater value. They're extracting a mineral through a mining process. It's similar to several of you oil and gas operators that pump a stripper well out and put it in a battery tank and let it separate. And guess what? You still get 1/8 of the sweet crude, you get 1/8 of the heavy crude, and so forth and so on. And I would urge each of you to review the objections that I filed in this matter and the brief in support of that. Thank you for your time.
Thank you, Mr. Hickey. Just for the record, that was the chair. Mr. Perkins?
There we go. Thank you, Judge Moulton. I would just add, do you all have the presentation on your iPads? No? Is that something we can fix? I thought that was the idea.
I don't see it on mine, Mr. Perkins. It's a pretty blank screen, but
I believe you. I was just, is that something that can be fixed?
No, sir.
Or
turn around.
or you can turn around and look at the screen if
Yes,
you'd
sir.
like. But
Actually, there's a screen right in front of us as well. So
okay. All right. Well, good morning, commissioners. I'm very glad to be here. Seems like it's been a long road to get to this day. My name is Alan Perkins, as you all know. I represent the South Arkansas Minerals Association. We have been involved in this process since the time that Standard Lithium and Lanxess first filed the pilot plant application, and we've been involved every step of the way. The South Arkansas Minerals Association is actually it's a not-for-profit corporation that was formed under the laws of the state of Arkansas. There are a number of members of that, generally large mineral owners in the Smackover. And they were created for the purpose of educating, promoting, developing, and encouraging best practices and standards in the mineral resources industry, and to interact with relevant governmental agencies such as yourself to further that purpose. We're going to take a little bit of a 40,000 acre view, as Mr. Hickey put it. This is the Smackover. You're all very familiar with it. It's a prolific geological formation that runs from the panhandle of Florida all the way down into Texas, across the states in between, including Arkansas. This is an old Oil and Gas Commission slide that's been around for a long time that shows the oil production associated with the Smackover. Next slide. A very recent, just a few weeks ago, released study from the U.S. Geological Survey in connection with notably Scott Osbrooks, our state geologist, where they were reviewing the lithium content in the Smackover brine. The Arkansas, the hashed area there in Arkansas was the primary focus, but they also included samples from other areas. And next slide, please. What we found from that, and would you focus in on the bottom portion and there you go. What you can see from this, it's very, very clear that the counties that we're talking about, and the reason these 5 publicly traded companies are here today wanting to build projects in the Smackover in Arkansas, is not random. I mean, they didn't go to Florida, they didn't go to Texas or Louisiana or Mississippi. They're in the sweet spot in South Arkansas, and the samples of lithium content bear that out. So as you can see on this graphic from the USGS study, the majority of the very high lithium content areas are located in that sweet spot. And it does extend over into the very northeastern portion of Texas. And it is, of course, one continuous formation. Next slide. So this is, again, this is a graphic that has been before the commission before. This shows where the current and proposed operations generally are located. The blue portion, the blue boundary areas to the right of the slide, those are the Lanxess units, the Lanxess South, Central, and West units. And then the yellow is the Albemarle production area, which is not a unit, although they do have two very small units within that area. The smaller rectangle, roughly a rectangle that's kind of a little darker purple, between the purple and green is the location of the Tetra Evergreen unit that you all created last year. The larger purple area there is shown as Tetra, but those are leaseholds that have been assigned to or will be assigned to Standard Lithium for development under a memorandum or some sort of contractual agreement that they have, and we'll talk some more about that later. The green hashed area is the ExxonMobil Saltworks development area as it has been presented in the past. I feel sure that's been expanded since this slide was created and actually extends to some degree all the way to the Texas border and on into Texas. Next slide. As was already mentioned, there's been one previous application for a lithium royalty rate that went to hearing, and that was last year, as you all recall. It went forward for hearing on December 5th. The proposed lithium royalty rate in that case was equal to approximately 1.33%, although it changed depending on the price of lithium, but that was the bottom. I think it was 1.33 to 1.6 or something, depending on how their scheme worked with the price of lithium. At that hearing, as you know, we had produced by Standard Lithium a definitive feasibility study that presented a fairly robust economic projection for this project, as well as engineering and geological information. And that was thoroughly discussed. You will recall we brought an expert economist, Eric Krause, who came in and both presented a report and testified that based on the economic modeling in their own feasibility report, that a 12.5% royalty would be fair and equitable based on their economic numbers, and that it would ensure the applicants, based on their own numbers, minimum 20% internal rate of return. The commission carefully listened to that, reviewed it all, and then, as I recall, based on the suggestion of Commissioner Wolford, there had been mention of another contract between Standard Lithium and Lanxess that contained some unspecified financial payment related to bromine, and the commission, having heard that and asking the applicants if they were going to disclose that, determined that you could not move forward to determine a royalty rate because the financial information was incomplete. The hearing was continued to January and then later to April, and before the April hearing occurred, the applicants simply withdrew their application without submitting any additional information. So then what happened? We had a little bit of a pause and then enter the big five. So Standard Lithium, Lanxess, and Tetra, and Albemarle ganged up with ExxonMobil in the middle to bring the application that you have today. And what does the Big Five application ask for? It asks for a 1.82% lithium royalty rate for all existing brine units and any potential brine production by any of them within the Smackover Formation in Columbia, Union, Lafayette, and Miller counties, with or without a brine unit. Next slide. And what financial economic information did they provide regarding any specific unit or production area? Zero. No definitive feasibility study, no economics like we had from Standard Lithium and Tetra last year. They simply asked the commission to trust them, that they know what is best, and that even though they don't have units created yet for much of the area, they need to know this number. And if you don't give it to them, they're going to take their ball and go home. which just isn't true. As you notice, they can't take the resource with them. And Arkansas is in the best place for this to happen. So what is our objection? What is the South Arkansas Minerals Association objecting to? Well, first, the Brine Act requires the commission to first determine that lithium would be profitably extracted, and the Big Five didn't provide any evidence about that. Mr. Daly, and you'll hear over and over, they're willing to stipulate that they're going to be profitable, but that's not evidence. The Arkansas Brine Act requires that a royalty rate on additional substances, which is what lithium is in this instance, be determined on a unit-by-unit basis. The Big Five application doesn't focus on any units. It simply asks for a royalty rate across the board, inside or outside of units, including in areas where they may or may not ever create a unit. The additional substances royalty provision of the Arkansas Brine Act applies only to units. Albemarle, as I mentioned earlier, operates a voluntarily pooled production area and has no legal basis to request the relief recited in the Big Five application. And then if in fact the commission gets to the meat of the issue and decides that it must decide something, their proposed rate is simply ridiculously low and it lacks any economic basis. The highest and best lithium royalty rates on brine leases being taken on the open market in the brine developed target area are more than 5 times as high as the 1.82% rate proposed by the Big Five application. At the last hearing last December, Commissioner Thomas made a specific request that we try to go out and identify some leases that would represent that highest and best rate. And we did that. Those leases with 10% cost-free royalty rates are attached to our application. We encountered, though, a lot of problems trying to do that. Virtually all of the leases that actually stipulate a royalty rate for lithium are not being recorded. They're being recorded only by memoranda under confidentiality agreements. Just another method that the Big Five are using to try to prevent you from learning what is actually going on out there in the real world. The financial data that was previously disclosed, though, by Standard Lithium and Lanxess demonstrates that lithium production would generate sufficient profits to support a much higher royalty rate than that proposed in the Big Five application. And we will be presenting to you some numbers today from another Standard Lithium report. Before this hearing today, this public hearing today, the lawyers had a pre-hearing session with Judge Moulton where he ruled on a number of legal issues that were raised by the applicants in opposition to our objections, claiming that they should be disposed of in advance. And I think it's 20 pages or so long. I don't remember exactly. I'm not going to try to go through it all. But at the end, Judge Moulton sort of summarizes his rulings, and here they are. The co-applicant's application does not violate the Arkansas Administrative Procedures Act. Number 2, the Brine Act requires that a royalty rate on additional substances be determined on a brine unit basis, but multiple brine units can be consolidated into one application and docket. Number 3, if the commission determines that a brine unit, quote unquote, is synonymous with a brine operational area, such as Albemarle has, then the hearing...
Can I just stop you right there? I'm concerned in terms of your opening statement that I understand what you're getting into, but I don't want to get into argument back and forth about what the recommendation was. I would respectfully ask you to skip over this part if you could, because I'm going to be taking it up. And I you can wrap it up very quickly.
Well, I mean, with all due respect, Judge Moulton, you didn't give us a time limit, and I've prepared this presentation for open. I'll pass. I'll move on from your rulings on legal issues.
Okay, go ahead, sir.
Thank you, Judge. Even though the applicants didn't provide it to you, there is additional published economic data for Standard Lithium projects. So you see over to the right, The right hand of the slide is the Lanxess South unit. That's the application you heard last fall. All the way on the left side of this graphic, the Standard Lithium Southwest Arkansas SWA development project also has in existence a preliminary feasibility study that has been published last year on September 18, 2023. And here are the highlights of that. The base case production based on their numbers was 30,000 metric tons a year. The net present value after tax was $3.1 billion. And the internal rate of return after tax was 32.8%. And this does not include any royalty because they didn't know what a royalty would be, and it's not included in those numbers. So what we did was we took the analysis that Eric Krauss, the expert economist, did last year in the hearing on the first application, and we input the information from the feasibility study for the SWA project. And here's the result. Here, this shows the sensitivity of their supposed economic projections for their own project using their own numbers if we apply different royalty rates. The first 1.82%, which is what the applicants are proposing here, continues to have a 32.2% internal rate of return and a royalty per ton of $546. Then you can go through up, I don't need to read through all these, 6.25%, 10, 12.5, 20 are just illustrations to show you the sensitivity of their economic projections to different royalty rates. Notably, even here with the Southwest Arkansas project, which is considerably more profitable than the Lanxess project, even a 20% royalty rate would result in a 26.1% internal rate of return after tax to the applicants and a $6,000 royalties per ton. Now, Mr. Daly has mentioned and argued in advance that you shouldn't listen to any information about Texas leases because they were completely irrelevant. Here's what he says in his brief. Further, royalty terms for jurisdictions where lithium is not currently produced, which of course would include Arkansas, such as Texas, is not probative of the market value of lithium rights in comparison to relevant benchmarks of lithium royalties for currently producing jurisdictions. The fact that a lease taken in a non-producing or speculative area under certain terms does not evidence that such terms are conducive to actual production of lithium. On the other hand, comparable benchmarks for actual current lithium production in other areas such as Australia and Argentina are substantially more germane in that they evidence a large sample of market-based and market-tested terms that encourage development and production and are fair to all parties. And I'm sure that you're going to see extensive data from other countries around the world. And if you think that those are more germane than a lease taken in Texas 1 foot across the line from Miller County, then so be it. So I wanted to try to find out what I could find out about such things. And I ran across this article, lower royalty rates give lithium producers a lifeline. First, it's hard to read, but this was published on April 24th of 2024 and updated on May 31st. This article presents sort of the dilemma that lithium producers find themselves in because the great fall in the price of lithium since its peak a year or so ago. So this is data from Standard & Poor's Global Market Intelligence. And you can see at the end of this, at the time of this article, the price was about $15,050 per metric ton. But here's what the article had to say about that. Royalty structures for lithium extraction vary across major producing countries, with most employing variable systems that adjust with market price. In Argentina, royalties fluctuate by province but are capped at 3%. Meanwhile, Western Australia and Zimbabwe set theirs at 5% with options for partial payment in minerals. And then this is interesting. Chile, home to significant lithium reserves, implements a unique royalty system through its production development agency, Corfo. Operators like SQM and Albemarle, major players in a Salar de Atacama, face variable royalty rates ranging from 6.8% to 40%, linked to market prices. This approach aims to support miners during price fluctuations. Despite Chile's comparatively high royalty rates, investments in lithium projects there and in Argentina remain attractive. In fact, most projects in these countries maintain profitability even amid current price levels. Chile is the second largest lithium producer, while Argentina takes the 4th spot. And so this is a graphic that was in that article that shows the relative production of countries around the world, China being the highest, Australia being the highest, and then Chile, and then China, and the others on down the line. Well, you can find anything on the internet, and I was skeptical. So I did a little further, go ahead and go to the next one, research, and I found this. This is a document filed with the Securities and Exchange Commission on behalf of Albemarle. And this, in fact, demonstrates what the actual royalty rates are under Albemarle's contract with Chile. And you'll see on the left is for lithium carbonate, on the right is for lithium hydroxide. And there is a sliding scale, but when you get to $10,000 US dollars per ton, the royalty rate is 40%. And the same for lithium hydroxide when the price is over $11,000. So if in fact those prices around the world are more probative than a lease taken in Texas, here's a good example for you to use. What should the commission do? What does SAMA, what does the South Arkansas Minerals Association recommend? Well, first of all, we don't think that the applicants have or will today present you with sufficient unit-specific financial information on which you can adequately make a rational decision on what is a fair and equitable royalty rate, which is what the statute requires, in our opinion. So we believe that the commission should deny the Big Five application and describe very clearly what the commission expects in the future when this comes back up. Any future application should specify the particular unit and provide unit-specific economic data to determine what royalty rate is fair and equitable. The Arkansas Brine Act requires that a royalty rate on additional substances be determined on a unit-by-unit basis. An application should include sufficient economic information to reasonably determine the impact of a proposed royalty rate on profitability of a specific unit. Applicants should provide testimony about the highest and best brine lease terms being offered in the smackover. Alternatively, if the commission in fact thinks that it must set a rate today, here are some benchmarks that you should carefully consider. The 12.5% that was established by expert economic testimony in docket number 083-2023-10, which was heard last December, which of course that unit is included in what the applicants are here asking for today. A 20% based on the sensitivity analysis of the SWA project economics that I pointed to earlier. 10% as the highest rate in the lease examples that are before the commission that we have presented to the commission and will present, or 6.8 to 40% if you like going outside the country. We'll be happy to. We can stop this right now if you want to stipulate to 6.8 to 40% on the same basis that Albemarle contracted with Chile. With that, I want to just state that the South Arkansas Minerals Association owns approximately 16,000 acres of minerals. Its members do. But I went through the objections, and there may have been a few filed after I stopped looking very late last week. And some of those objectors state what their acreage is that they own. Many of them did not, but based on those numbers and the numbers of the other parties that my partners, Forrest Stovall and Jim Rankin represent, there's a total of 176,477 acres of mineral owners represented in these objections. That's a very significant percentage of the community that your ruling will affect today. Thank you, Commissioners.
Thank you, Mr. Parkins. Mr. Pilkington, I think I overlooked you during council introductions. Would you be so kind as to introduce yourself for the record? You're on the second row back there.
Check, check. Hey, hey.
Yeah.
Mic check. 1, 2.
Yep.
Hey, hey. Get.
Operator.
Thank you.
Thank you. I'm Daniel Pilkington. I'm an attorney here with the Arkansas Oil and Gas Commission.
Pilkington, do you want to give an opening statement?
Not at all. Thank you, though.
All right.
I'm just glad the microphone's working.
Thank you, sir. All right, Commissioners, based on the opening statements, do you have any questions for council? All right, if not, next item we have is what Mr. Perkins alluded to previously, which is the fact that on October 11th, I did conduct a 4-hour preliminary hearing for the benefit of the commission. Yep, yeah, that recommendation is found at tab 23 in your book. So if I could somewhat set the table for the commission. I don't want to open it up in terms of argument because that would essentially defeat the purpose of having the pre-hearing conference that we held in the first place. But I will tell the commission that they need to make a motion and vote. You have a few alternatives in terms of how you would like to do that. Obviously, you can accept or reject any of the recommendations that are contained in this memo. But for clarity's sake, Commissioners, at a minimum, I think you need to take up the Albemarle issue separately, because what I provided you with in the memo was an alternative. And again, I don't want to gravitate too much into it, but during the argument, Albemarle's interest in this was described a variety of different ways. Initially, it was they have an interest, Albemarle has an interest because it has leases. Then during the argument, I was told that it has a operational area, which was also described as a production area, which was also described as a production field. And then in the last pleading that was filed, it's been described as a voluntary unit. I don't know whether or not any of those, which one of those descriptions is accurate. But if this commission believes that whatever it is that Albemarle has and whatever it is they're doing in terms of the production meets the requirements of the Bryan Act, then certainly keep them in this case. The concern that I had was they were so different compared to the other co-applicants that if you lump them all together, whatever decision the commission make on that might taint the remainder of the cases. So that's why I try to provide you with an option. So, Mr. Chairman, I'm not certain how you would like to proceed. I guess I can ask, is there a motion from the commission or are there questions from the commission that I can answer prior to you making a motion? Commissioner Wolford?
Just on 2 items.
Yes, sir.
One as it relates to the additional substances. So it's your determination that you have to be in a unit for us to determine
that's what the Bryan Act seems to indicate to me. You have to be unitized in order for that to apply.
In trying to think through Albemarle's circumstance, The statute says that you may come before the commission and establish a unit. So presumably, if you had a circumstance where there was no need to integrate, what would the purpose of a unitization hearing be at that point? What would it be determinative of? And
Well, if you look at the act, if you look at all four corners of the act, there are aspects of that act that are inextricably tied to the existence of a unit. So if you don't have the unit, some of those provisions in the act disappear as I read it. So the premise of having a unit is to be in conformance with the act itself. I don't know if I'm answering your question. I mean, and you're right, Commissioner, there are two ways you can create a unit, as I understand in the act. You can voluntarily come in and ask the commission to establish one, or the commission can do it on its own. Those are the two ways. But until you get that unit established, theoretically, you're not supposed to be producing brine.
so through the 40-odd years that have transpired since the Bryan Act was established, we as a commission have treated Albemarle as a operator. I don't know that we had ever established them as a unit operator, which would be one piece of the, I don't know if at any point we've established the area that the unit would encompass, but I assume that some of the part of the amended application includes now a description of Albemarle's voluntary unit, as far as we know.
I didn't see a description at all.
Okay.
Unless you saw one, Commissioner. Oh,
In the amendment.
yeah, in the amended application, you're correct.
So if you were a party that had a unit that did not need to be integrated, your need to have a unit formed largely involves the ability to establish a subsequent royalty on subsequent products, to have the area established, have a unit operator established.
Right.
I'm trying to think of any other reasons. You wouldn't need the economics because you've already got every interest covered at that point.
It's possible. So even in terms of the amended application, this entire process has been somewhat fluid. So initially it was they wanted a royalty established on the entire Smackover limestone formation. I don't think that's the intent of the Bryan Act at all. I asked them to include specific units and geographic areas in their amended application, which they did. But if you look at the amended application as well, they also want a royalty on future potential units, which again, the concern is you are opening up Pandora's box a little bit. I'm just looking at it from the four corners of what the act says. I don't know what this commission did prior to my involvement with it as it relates to Albemarle. That's the concern that I had, was they're doing something. I just don't know what.
Is it your opinion that number one, do we have enough notice to establish a unit for Albemarle at this point?
I don't think you do. I mean, I think it would be fundamentally unfair to everyone present if all of a sudden you decided at this stage of the game to establish a unit for Albemarle. So, and frankly, Albemarle hasn't asked for it. I don't know why. To me, it makes no sense, but belt and suspenders, I would have been doing it a long time ago.
And at this point, they now have the trigger that would likely bring them to want to establish a unit.
And again, the concern that I have is if you fold them into this proceeding, the applicants that actually have units established, it could just basically, potentially from a legal perspective, mess everything up.
Okay.
That's the concern I have. Now the director may have a different opinion entirely, so maybe you want to ask him.
And just one other thought. The thing that keeps me up on this one is that Bill Wynn was our hearing officer for a long period of time and was one of the authors of the Bryan Act. And I just can't get past why he never would have thought to have them appear. And it's a unknown, but,
I can't answer that question, Commissioner Wolford. I really can't. And maybe the director can. And to be honest with you, this was the most difficult aspect in terms of trying to grasp it and write a recommendation for this page, for this body that I had, because obviously Albemarle is doing something. I just don't know whether it's consistent with what the act says they're supposed to be doing. Yeah. Any other commissioners?
I've got one question. Do we know for sure that Albemarle's area is completely leased, or are there open leases in there that we would integrate under if we made a unit?
I don't know the answer to that. I just don't.
Yeah, I mean, that'd be my problem with it.
Mr. Pilkington, apparently the director says you have a comment on this particular issue. Not to put you on the spot, sir, but come on up and see if you would like to weigh in, and maybe you can answer some of the commissioners' questions about this facet.
Will do my best. Can you hear me? That's half the battle here. Your question is whether or not the entirety of the area is leased. I'm not 100% sure that Albemarle is.
Albemarle's recognition by the commission as a party.
Can I have a second to talk to the director?
Director?
As far as I've been here for 20 years, the commission has always accepted Albemarle as a regulatory entity or producing brine. There have been several hearings designating that to be the case. I would ask the commission to continue that process at this point in time, as we've accepted it for the last 50 years.
For clarification, I'm not sure if they have all the leases, but there is a record of commission actions through hearings where it appears they have allowed them to permit wells and they allowed them to operate a pilot plant. As far as defining what area it is and whether or not it's called a unit by you, the commission, that's conjecture.
In my experience, leasing an area that big, there's going to be people that don't sign somewhere in there. How are they being treated? I just don't understand how it could work.
Yeah, the best I can tell you is from the history that we have through looking at the previous dockets. Albemarle has come before you to ask for authorization for some of their wells and to operate a pilot plant, to operate basically without a finding of profitable extraction. I don't recall them going specifically into the leased aspect in those dockets.
Right.
I'm sorry, hopefully that answers your question.
within a determination, can we simply determine them as a regulated entity and thus make them an interested party?
In all honesty, Commissioner, you can do whatever you want. If you're asking me whether it's legal or not, that's another thing entirely. I don't know whether or not a regulated, regulated entities are as broad as a battleship, I would surmise. And again, I understand the commission struggling. I struggled with it as well in terms of, obviously the commission has done something vis-a-vis Albemarle. There's a 2017 docket that talks about the establishment of an operational area. That's the verbiage that it uses. But an operational area is not defined in the Brine Act. That's the conundrum I had.
Thank you.
Charlie. Do we want to call Albemarle a person and ask them to testify on that subject? It's a large operated area, but it's not unitized.
You can certainly do that, Mr. Chairman. The concern that I've got is here's the concern that I've got. if you do that, it really kind of, to a certain extent, defeats the purpose of me holding the 4-hour hearing. Because if you call a witness, then we are going to be off to the races in terms of having everybody argue the merits of whether or not Albemarle is in or out of this docket.
You know, my personal feeling is that at some point in our history, we accepted that operating area as a unit. And it's better to have folks regulated than unregulated. And for the protection of the correlative rights, to have all those royalty owners treated the same as we're going to treat everybody else are some of the criteria. But there's a hole as big as a battleship.
And Commissioner, that may very well be, that may be what the commission did. But when I specifically asked during the hearing, does Albemarle have a unit? The answer was no. So, I mean, there's a record made on that.
Okay.
It is problematic.
Yeah, Mr. Daly's raising his hand. I don't know if you want to talk to him or not.
Commissioner?
Well, I agree with Charlie. I mean, that's the way we've always treated it since I've been on here. You know, we've had these discussions in the past and we've always recognized them as that way. So I don't have an issue with it.
So as for what we need to decide now, we have your other recommendations.
Right. Yep. No. Hello?
Yeah.
That is correct, Commissioner. You have the other aspects of that recommendation. You can make a motion on those. And if the commission's ready to entertain one, I'll ask. Is there a motion from the commission on the other facets of the October 15th recommendation?
I would prefer just make a motion, it's all, with a motion that we include Albemarle based on commission history and past dockets that we've handled.
Okay, so Commissioner Wolford, is your motion to accept the recommendation as a whole with Albemarle included in this docket?
Yes, sir.
Motion by Commissioner Wolford, second by Commissioner Langley. All in favor, show of hands. Oh, I'm sorry, Commissioner Phillips seconded. Show of hands. Motion passes unanimously. All right. Next, I have public comments, and I would respectfully request that we have had a number of written comments. I'm going to go through the names. I would like to give everybody 2 minutes to make their comment. If you have provided a written comment, however, would you be so kind as to let the commission know that you have provided a written comment? And then I'll give you an opportunity to, or not, and then I'll give you an opportunity to address the commission. First card I have is Adam Clark. Yes, sir. Would you be so kind as to identify yourself for the record and let the commission know whether or not you've already made a written comment?
Yes, sir. My name is Adam Clark, and I did write a objection to this.
Thank you. Go ahead, sir.
Yes, sir. Good morning, commissioners. My name is Adam Clark, and I'm a regional manager with Natural Resource Partners, LP, owner of BRP, LLC. First and foremost, I want to say thank you to both commissioners and the people here in this room. There's a lot of good things happening in Southwest Arkansas, and it's great to see so many people engaged in something that I truly care about. As I mentioned, I work for Natural Resource Partners, LP, owner of BRP, LLC, and I'm here today from Huntington, West Virginia to voice my company's objection to the co-applicant's request for the royalty determination on lithium. To best describe NRP, we are a mineral royalty company owning over 13 million acres of mineral and mineral rights across the United States. NRP's primary business is leasing and managing in the development of its reserve mineral and mineral rights to mining companies, oil and gas operators, natural resource developers across the energy and non-energy commodity spaces. BRP owns 1.3 million gross acres in the state of Arkansas. Currently, we have leased over 41,000 net mineral acres across the southwest Arkansas for the development of lithium. As to why we object, as we note in our letter, BRP believes that the 1.82% rate fails to adequately provide fair and equitable compensation for its reserve minerals. BRP has executed leases in the Smackover with royalty rates many times greater than that has been proposed. In our experience, operators can pay a fair and equitable royalty rates higher than the proposed rate while generating a fair return for their project. Further, BRP disagrees that the 2007 order referenced in the application is a comparable order providing for the proper lithium royalty rate, seeing the extreme differences in LCE versus the minerals listed. Number two, we believe that the co-applicants are requesting a blanket royalty rate for multiple ununitized areas, and we believe that this is against Arkansas code. Third, the co-applicants fail to provide any financial and economic support that indicates the projects are profitable, a clear violation of Arkansas code. We support the current requirement evaluating individual projects to determine a fair and equitable royalty rate, and we fully expect that individual projects will encounter different levels of profitability, and their rates will change accordingly. By maintaining the current standard, the individual project review basis on the economic project, the mineral owners can ensure that they are being paid on an equitable basis. Lastly, for the reasons, I strongly oppose the co-applicants' submission, and I request that the commission deny. BRP looks forward to working with the AOGC and the operators and the people of Southwest Arkansas to develop this world-class asset. Thank you.
Thank you, sir. Next card I have is Mike Davis.
Excuse me, Judge. I apologize
Oh,
for
I'm sorry.
interrupting. I believe there are additional comment cards in the audience. How would you like those collected?
Well, thanks, sir. Mike Davis?
Good morning.
Yes, sir.
For 18 years, I had the privilege and the responsibility to sit where the 9 of you sat this morning.
Mr. Davis, can I stop you for a second? Have you filed a written comment as well?
No, sir.
All right. Thank you, sir. Go ahead.
As a young person with a family that was involved in the oil business, I've had the privilege to witness 3 booms, 2 in Michigan, 1 in Illinois. And I'm beginning to see the beginnings of a boom in Southwest Arkansas that certainly needs it. As all of y'all know, in the phases of any boom, you have the leasing process comes first, the discovery, the exploration, the completions, and then the productions. Most of what I'm seeing in Southwest Arkansas right now are contractors from out of state that aren't residents of the state of Arkansas. What I'm seeing is this is great locally for motels, restaurants, other facilities. But in the long run, as each one of y'all know, when the drilling rigs are gone, when the completion process is complete, you've got 2 things left. You have the maintenance and you have the royalty income. For the majority of the citizens of the state of Arkansas and for the state of Arkansas itself, the real benefit to the mineral owners and royalty owners and citizens of the state of Arkansas will be the royalty that you gentlemen determine. And I know the majority of you, and I know you're always fair, and I know you're always equitable. 2 things I always tried to do as a commissioner is I tried to leave my friendships on the outside of the hearing chamber and hope and pray I could pick them back up when I walked out of the chamber. And in most cases, I was always able to. The second thing I always tried to do was to be a voice for the people that felt like they didn't have a voice. And I know several of y'all sitting up there today feel that very same way. Thank you for your time.
Thank you, sir. Next card I have is A.L. Turner.
First of all, I would like to say good morning to all, to Judge Newton.
I'm sorry.
Good morning.
Yep, a little bit better.
Yes, sir. Okay. Good morning to all.
Mr. Turner, have you also filed a written comment?
Yes, I filed a written comment. Well, I didn't actually put the comment. I just filed the card.
Go ahead, sir.
Okay. I want to say thank you for allowing me to speak on behalf of my family. I'm a common sense kind of guy. So basically what my comment is that once these wells are dug and the integrity of the ground is displaced and you got what you're going to get out of it, what are the conditions of the land, of the acreage that's going to be left still viable for we as the people to continue to utilize that land, if at all. I did my research and found out that in the rural area that the acreage is $2,000 to $4,000 an acre. In the residential areas, there's only, it can start at $80,000 and upward. The thing of it is the royalties that's being offered for the acreage does not match what the acre of the land itself is valued, which basically leaves it unequitable in its whole calculation. My concern is, and my objection is that basically that what has been offered to the people is certainly not equitable or profitable to the people at large. In Mr. Allen's presentation, I really enjoyed and appreciate what he had to bring to the forefront and to our hearts. It sounds more equitable that Albermeyer, or what if I'm saying it wrong, the company that he talked about last with the 6% to the 40% slide, is more equitable to the people of Arkansas and to our ancestors. I am an inheritor of land along with my family. So we are not on board with what our co-applicants are trying to offer us, which are pennies, in compared to what actually the profit is going to be on the market. I know that lithium, which is the end state, is on the market for $10,159 per metric ton. You have to start somewhere. If we don't have a place to start with the brine, then how can we get to the lithium? So you have to have a place to start. So therefore, even in your cell phones, if you don't have certain transmitters and diodes in your phone, you're not talking. So everything is important to get to the place called there, where you want to develop the lithium and have these electric vehicles and continue to escalate our economy. So we need to really consider what's going to help lift this economy up in its entirety. So that's my point. And if you can answer this, how much already have been extracted from the lands that are the test pilot programs off of each well that's already identified on the map?
Thank you, Mr. Turner. You're out of time. Thank you, sir. Next card I have is Antoine Anderson. Ma'am? I can't hear you, ma'am. Come on up.
Parham, it should be up there.
Go ahead, ma'am.
My name is Mary Parham. I'm from Little Rock. I'm from El Dorado, actually. but I live in Little Rock, Arkansas, and I'm here to speak on my ancestors as well as our siblings regarding the land we have in Three Creeks. I'm like Mr. Brown, is that what his name was? But I have my thoughts are the same as his. Our ancestors built and they cultivated that land. We get a minimum check once a year for $320. That's pennies. I want to know what are the plans for after all the extraction and after all the wells and all of the tractors and whatever has been gone through that land. We have 39 acres. I want to know, it's right on the highway of Three Creeks, once on Highway 15. Right now, it's beautiful going down through there. But after you extract our mineral, tear up our land, what are your plans for that? And I'm speaking for three other siblings that's not here. And and all of my ancestors that's gone before me. And I am the oldest now to speak on our behalf. And I also would not like to know, when we got notice that the meeting was canceled, do you not know how many people traveled, got up at 6 o'clock, 5 o'clock to travel here to find out that meeting was canceled? I am a business owner in Little Rock for 25 years. If you ever bought a lottery ticket, it came through my call center. I've been running it for 25 years, running the business for 25 years. I've been running the lottery from 2009. I have to cancel a meeting 5 or 6 weeks before in order for the people who are traveling to the meeting from all over the counties know that the meeting is canceled. We are intelligent people here. We need to know if a meeting is canceled, and we need to know the primary reason why we're here. You all was talking English, I don't know, some other language other than what I do, because I couldn't understand anything you said. We have no idea. I don't have an agenda. I don't have anything to tell me what you are going to be talking about. And I don't feel like that is very professional, even though I'm a commissioner on several boards in Little Rock. That is not how it works. Thank you.
Thank you, ma'am. All right, Antoine Anderson. Mac Hogan. Thank you, Mr. Hogan. Ernest Green. Ms. Green, how are you this morning?
I'm very blessed, Your Honor.
Have you provided a written comment?
No, I haven't.
All right. Thank you, sir.
Okay, I'm here today first of all, I want to say thank you guys for getting up and attempting to take on this task. But I'm very concerned about the whole process, as well as a lot of us have voiced their opinion. The world is watching Arkansas, and we're moving in a very fast pace. The world is moving, constantly changing. We're right here in the middle of the election. And Mule Lane said something in the boxing ring. He said, protect yourself at all times. And I believe that's what we need to do. Everybody want to do good business. I believe in overpaying instead of underpaying. And that made me a very successful man because of that mindset. So if you want to get something done, let's not mess around with pennies and cents. Let's go on and pay the people. And I'm just here to say that the state of Arkansas and whoever's on the commission, just take that in mind. Be fair. God bless. My rest.
Thank you, sir. Roland Jamerson. M. Justin Ackley. Morning, Mr. Ackley. Have you provided a written comment?
I have not, Judge.
All right, thank you, sir.
Mr. Chairman, Commissioners, Judge Moulton, and Director Bangle, thank you for being here this morning. My name is M. Justin Ackley. I'm a Senior Director for Government Affairs and Regulatory Affairs for Equinor, and I'm here to express our support for the co-applicants in this matter. By way of background, Equinor is an international energy company with operations across the globe, including Texas, Arkansas, formerly Ohio, Pennsylvania. We have held interest in the United States for the past 37 years. Our knowledge and expertise in the energy industry is unparalleled, enabling us to navigate complex challenges and drive sustainable solutions. We are an industry leader in environmental responsibility and energy development and production. Equinor is a joint partner with Standard Lithium and believes that approving this application will, one, provide significant economic benefits beyond just the royalty to the state of Arkansas. Two, increase the industrial competitiveness of Arkansas on a global scale and the associated local industries that would be involved in the lithium business. And three, have expansive benefits for the United States national security and our domestic critical mineral supply chain. Equinor and Standard Lithium are committed to playing a part in realizing these outcomes for the community and the state of Arkansas. I appreciate the opportunity to be heard here today and look forward to hearing the rest of your comments.
Thank you, sir. My apologies, I'm having problems reading this one a little bit. Mary Moore Artane? Oh, all right. Sorry about that. Eugene Moore. Mr. Moore, have you provided a written comment?
Got it in front of you.
All right, thank you, sir.
My name is Eugene Moore and my sister, Mary Pound. We would like to know, like she said, we got land down there on Highway 31. And we would like to know, how do y'all determine how much lithium that you're taking out of the ground and what is what? Like she said, our ancestors had land down there for almost older than I am. And like the other gentleman said, we are getting cheated. We are getting violated. And we're not getting our money's worth what y'all getting out the ground. And I don't think that's fair. A lot of people, like she said, a lot of people drove hundreds of miles last month to come down here and to speak to you all, and y'all didn't show up. No, I don't think that's right. If y'all don't show up, why don't y'all send us notices? See, we are poor people. Y'all got money because y'all sitting up there on the board. So therefore, what about us? When are y'all gonna recognize that we need some of that money that y'all put in y'all pockets? You know what I'm saying? Because like I said, we poor. We ain't got nothing. Y'all got it all. So when are y'all gonna recognize all these black folks and all these white folks in here that we need some of that money for ourselves? We got children that we need to send to college so they can make a living. The cost of living ain't what it ought to be, but I'm not here to discuss the cost of living. I'm here so I can get some of that money that y'all pocketed off us. Y'all living off us and living better than us. So when are y'all gonna recognize just like this lithium that y'all talking about? Now, if y'all start paying back some of those royalties from years ago, we'll be living better than y'all will. Because y'all putting all that money in y'all pocket and we ain't getting a dime. No, I don't think that's right. When are y'all gonna start being fair to us black folks? And when are y'all gonna start paying us what we deserve? I feel like this slavery. Y'all getting our money and putting it in y'all pocket and we ain't getting a dime. Now that's not right. See, my mama was poor. She raised 4 kids. She was a maid. Now here I am, I worked at Tyson Foods all my life. They trained me to be the best. So therefore I figured that what she put in me, what she had in her. But my grandmother, Mary Moe, she lived down here on Highway 31. And all the land, the 28 acres or the 39 acres that we have, I don't feel like y'all are being fair when y'all go in there and tear up our land, get what you want, and y'all gone. I feel like we've been raped. Y'all been doing it all along.
I'm sorry, Mr. Moore, you're out of time, but thank you
Thank
so much for your comment. All right, that finishes up the comment cards that I have. Commissioners, do you need to take a small break before we get into the merits? All right, why don't we go ahead and go off the record for 10 minutes, or off the record for 10 minutes?
Hey, hey, mic check, 1, 2. Mic check, 1, 2. Hey, hey. Mic check. Mic check, 1, 2. Hey, hey. Hey, hey, mic check, 1, 2. Hey, hey. Whatever you're doing, just mic in, you can ask her out. What? Check, 1, 2. Hey, hey. Hey, hey. Mic check, 1, 2. Hey, hey.
6 up in there, right, on the panel?
Oop. Hey, hey. Mic check. Mic check, 1, 2. Hey, hey. Let me just get. Hey, hey, mic check, 1, 2. Hey, hey. Hey, hey, check, check. Check, check. Hey, hey. Hey, hey, check, check. Hey, hey, check, check. Mic check. Hey, hey. You getting it now? Hey, hey, mic check, 1, 2. Hey, hey. Hey, hey, mic check. Hey, hey. Hey, hey, mic check. Mic check. Mic check. Mic check. Mic check. Hey, hey. Hey, hey. Hey, hey. Check, check. Hey, hey, check 1, 2. Hey, hey. Hey, hey, check, check. Hey, hey. Mic check. Mic check. Omni 3, mix 1. Yeah. Hey, hey, mic check. Hey, hey. Hey, hey. Check, check. Hey, hey, mic check. Hey, hey. Hey, hey, mic check. Hey, hey. Mic check 1, 2. Hey, hey. Hey, hey. Hey, hey. Mic check. Check. Mic check. Mic check. You can get any louder than that, my guy. Mic check. Hey, hey, mic check. Hey, hey. Mic check. Mic check. Mic check. Hey, hey. Hey, hey. Mic check. Mic check. Hey, hey. Hey, hey. Down a lot. Mic check. Hey, hey. Hey, hey. Just a little bit. Hey, hey. Mic check. Hey, hey. Hey, hey. Hey, hey. Mic check. Mic check. Can you guys hear me up here now? Everybody able to hear themselves speaking?
Attention. Attention. Please find your seat.
My commissioners, are you ready to proceed? We're back on the record. Mr. Daly, housekeeping matters. I know we've got a number of exhibits that we have to introduce.
As follows. Exhibit A is an LCE, that's lithium carbonate equivalent conversion chart. Exhibit B is an illustrative royalty calculation. Exhibit C is a paper authorized or authored by Mr. Joe D. Woodward, presented to the 77 Natural Resources Law Institute on the history of the bromine industry and the Bromine Act. Exhibit D is a similar paper authored by Mr. William Wynn, who many of you knew well, likewise on the same subject. And Exhibit E is a paper that Ms. Margie Blair, formerly land manager of Albemarle Corporation, delivered to a meeting of American Association of Petroleum Landmen, all on the subject of the history of the brine industry and the Brine Act. Exhibit F1 through F7 are legal descriptions of existing and proposed future unit areas. Exhibit G is a study of benchmark lithium royalties across the globe, prepared by Ernst & Young LLP. Exhibit H is the PowerPoint presentation which will accompany our witness's testimony today. Exhibit I is the resume of Dr. Robert F. Ilagan, and that's spelled Y-L-A-G-A-N, as an expert economist. Exhibit J is newspaper proofs of publication of the notice of this hearing, both for its earlier date and then for today's date. And Exhibit K is a collection of affidavits that the similar notice was mailed to all those parties we could identify as interested parties. We move the introduction of those exhibits.
Thank you, Mr. Daly. Your motion is granted. Those exhibits are part of the record. Mr. Daly, you also provided the commission with some thumb drives. We have the iPads that can't be plugged in. You want me to go ahead and pass those out to the commission?
Yes, if you would. They're available for any commissioner who wants to not carry off a box full of paper, because it's also on the thumb drives. But we made them. They're done. So yes, please take them.
All right. Thank you, sir.
We move the incorporation by reference of all documents, including the transcripts, within the following commission matters, they being number 173-2007-04, 070-2017-06, and 040-2024-07.
Motion is granted. Those dockets are incorporated by reference in their entirety.
I have a number of witnesses, not as many as I suggested I might have when we had our little call, but I think I have a total of 1, 2, 3, for 6 witnesses. I would suggest that they all stand and be sworn at the same time and save that time.
That's fine, Mr. Daly. Would Mr. Daly's witnesses please stand, and I will go ahead and swear you all in. Which would you be so kind as to raise your right hands? Do you swear or affirm the testimony you're about to give in this hearing is going to be the truth, the whole truth, and nothing but the truth? All right, thank you all very much. By my count, Mr. Daly, I saw 7 people stand, so.
Mr. Day stood up, and it's certainly possible that we'll ask him to testify. But he's not on my current schedule.
All right. Please proceed.
As we've also discussed, we believe the most logical way to present this, both from the standpoint of our presentation and the other attorney's ability to focus cross-examination if they want, is to divide it into segments. And we have identified 4 discrete segments. The first being a lithium overview and an explanation of the design of the proposed royalty. Our first witness in that regard is Mr. Remy Loiseau, pronounced spelled Loiseau.
The court reporter appreciates it.
And I knew that she would, and I told Remy he was going to have to spell his own name, but then I did it for him, so he doesn't have to.
All right, before you gravitate into the examination of your witness, Mr. Daly, let me just go ahead and remind the commission of what the process is going to be. So Mr. Daly will conduct his direct. I'm sure Mr. Parkins is going to have some cross. I don't know if anybody else is going to have some. Mr. Pinkleton may also have some questions as well. Once the examination from the council is done, we'll turn the witness over to the commission for questions. And as typical, once the commission is done with their questions, if council has any follow-up for the witness to get some clarity from the commission's line of questions, I'll allow that as well. I'm going to just caution everybody, because of the logistics of this room, just make certain that it's just one at a time that are speaking. It's difficult enough just to hear everybody, and hopefully we'll get through this without too much issue.
I have a question. Are the commissioners' iPads now working so that you see the PowerPoint?
There's something up, Mr. Daly, but it says lithium royalty hearing, AOGC hearing.
That's it.
Okay.
All right.
Here's they are. All right, please proceed.
Please state your name.
Good morning. My name is Remy Loiseau, and I'm here today representing Saltworks, and a wholly owned ExxonMobil affiliate.
I already see a problem that's going to happen, Mr. Daly, because you're going to need to go on microphone. It's not going to be picked up.
Is this lavalier working? And can I put that on? No. That's for you.
We're going to need,
down there.
yeah, we're going to need 2 microphones while you're doing this.
And I heard a little echo feedback also that I don't.
It's not as extreme as it once was. I'm sorry, Mr. Daly, I interrupted you.
I'm an old guy with bad ears, and
I'm right behind you. Go ahead, Mr. Daly. I'm sorry.
All right. Again, please state your name and your employment.
So good morning. As I said, my name is Remy Loiseau. Mr. Daly spelled so kindly for me there. I'm here today representing Saltworks, a wholly owned affiliate of ExxonMobil. I'm the lithium area manager for our emerging lithium business in Arkansas. And over my 18 years with ExxonMobil, my experience has been in building and developing projects, from early concepts to the ultimate steel and facilities in the ground. And here in Arkansas, my job continues in this theme of building foundations, building a first of its kind business through the projects, operations, jobs, and suppliers that may benefit, each contributing towards the broader community growth and potential for the Southwest Arkansas region and the lithium business. It is in fact Arkansas's history of brine production and the statutes and regulations which govern it that has led us to evaluate the development of brine from the Smackover Formation for lithium. Arkansas's unique regulatory framework and precedents give it some of the key ingredients to become a leader in the global lithium industry. Today, we're here to progress that required next step to move forward Arkansas's lithium industry. The AOGC establishment of a fair and equitable lithium royalty to be paid to mineral owners. Establishing clarity on the royalty is one of the several important factors needed by developers to further evaluate any potential for project investment in the region. I would like to help frame that conversation with the introduction of a lithium overview, as well as the introduction of our royalty design. If you could proceed to the next slide, please. As Mr. Daly highlighted, we have multiple representatives here from multiple companies who were just introduced, and they will continue to introduce themselves as we proceed. Next slide. Throughout today and throughout myself and the witnesses who you heard, we're going to discuss several main topics. So you can view this as a bit of an agenda and a bit of an overview of the variety of takeaways to have from our conversation today. The first, which we'll cover, is a key understanding of what is lithium. Lithium being a diverse global resource and a variety of different products and markets that exist all over the world. But a clear distinction in understanding that will be a differentiation in lithium and brines and lithium specialty products, which are not the same thing. We'll talk through the principles that we considered when bringing forward our proposal for a lithium royalty structure and the ultimate design, and how that looks to value contributions and risks fairly and equitably as a totality, as well as ensuring that mineral owners benefit from both the resource that they contribute and the markets in which and the upside potential for those that those resources contribute into. We'll talk about our royalty basis, how Arkansas's own statutes and precedents set that foundation for what it is to be the extraction of substances from minerals and brine. And we'll provide a global contextualization that looks at the competitiveness and development potential of a variety of resources for the development of lithium and the royalty systems under which they operate. I would be remiss if I didn't comment and provide a foundational overview of how royalties fit into a broader aspect of industry and development. And it was a topic we heard in several of the comments made by the public as well, and is certainly of interest to many involved. Mineral extraction industries, as identified by the World Bank, have the opportunity to create 2 to 5 times economic benefit multipliers across their local communities. And that doesn't just come from royalty payments. That comes from the potential jobs, infrastructure developments, educational partnerships like one might execute with universities and school systems to develop workforce training and ultimate suppliers and benefits and the other types of long-term operational construction opportunities that exist. It creates tax revenues. It creates community services and other philanthropy that industries and operators like ourselves view as a fundamental requirement and benefit to bring to when we operate in a region. So I want to highlight these today to just identify that there are numerous foundations that an industry and development potential can bring. And certainly royalty payments is one of those and an important one that we're here to discuss today. So let us start with one of the most basics. And this is a question that I get very, very often around what is lithium? And oftentimes that term is actually used very generically and interchangeably for a variety of different situations. And that's an area of clarity that I think is required and necessary to make a fundamental differentiation within. But let's start with the first. Lithium, element number 3 on the periodic table, is an ion or an element. It's found in trace amounts of water in the oceans today, in brines, and in hard rocks. In the smack over here, it's in the brines that are deep underground below the oil and gas layers. And in a typical barrel of smack over brine, the lithium itself appears in very low concentrations. It makes up just 0.04% of the overall barrel of brine. That is the brine mineral that we've discussed before, and the lithium ions and the element that exists within it. The term lithium is also used to describe potential lithium goods or lithium products, such as lithium carbonate, lithium hydroxide, lithium oxide. These can all be brought together or compared by something that's known as a lithium carbonate equivalent, which we'll discuss further in detail later. But the important distinction to make is that these products are not just lithium. They are made up of a variety of other materials and constructs, and they are manufactured products and goods and compounds. And the a combination of different raw materials and refining and processing through a very complicated process leads to those markets and products that many see and many transition into ultimately manufactured goods, goods that benefit a variety of industries, whether that be those in batteries or EVs, pharmaceuticals, agricultural industries, and many more today. So what I want to leave you with as an important takeaway on this front is that it's important when we say the term lithium that we do make the distinction between lithium as an element or an ion as it contributes to a resource as it exists deep underground in the Smackover, or lithium products and lithium manufactured goods that are made up through complex refining processes that do much more than just filter out the lithium in the water and that progress through a complex refining process in order to generate these additional products. I'd like to take a little bit of time to talk a little bit more about the global lithium supply industry. Lithium today exists in three primary resources. The first are in shallow brines, which make up about 30% of the global production and share today. Those shallow brines are typically developed through an evaporation process that produces those shallow brines to the surface, spreads them out across large areas and acreage, and uses the sun's power to evaporate the salts. Subsequently, those salts and the lithium progresses through a complex refining process, as I mentioned previously, to ultimately generate specialty lithium products, whether that be something like lithium carbonate or lithium hydroxide. Lithium, as I mentioned previously, beyond brines or ocean waters or other areas, also exists in hard rock. This is more akin to a traditional mining industry, a mining extracted industry. And in those same areas, which make up about 65% of the world's production today, that hard rock is mined and the mineral ores extracted. And again, it goes through a large and complex refining process in order to ultimately make potential lithium products like lithium carbonate, lithium hydroxide, and other derivatives. The resource we're talking about here today is a deep brine. And a deep brine that requires the use of a technology known as direct lithium extraction in order to realize the potential of this development. It's not a hard rock, so we can't utilize mining. It's not an evaporative pond development methodology because here in Arkansas, as I'm sure we're all familiar, it rains a lot. We're not in the desert. So this unique technology provides the opportunity to uniquely develop the Smackover, and it is likely one of the only development methodologies to enable this type of resource. But I think it's important to recognize and differentiate both some of the similarities and the differences with that extraction methodology. These brines will require very deep wells into the ground to begin the first step of extraction of lithium. They'll then require separation technology and treatment prior to heading into what's known as direct lithium extraction or the first extraction technology. But then they will also follow with those lithium chlorides and others, a complex refining process to ultimately convert those into specialty products. Arkansas's resource will need to compete with every one of these other resources. It will need to develop itself and have the opportunity to recognize both its similarities and differences. The similarities in that all of these resources or lithium originate as a resource or a mineral and ions in some form or fashion, whether it's in brines and hard rocks, and resources that ultimately through some form of development and production go through an extraction process, processing requirements, as well as refining steps. Each of these is a similar aspect of what it takes to go from, again, lithium or lithium ions or lithium resources and develop them ultimately into specialty goods and products. That overall process is something we often refer to as value chains. And so we hear sometimes comparative examples that are drawn between a variety of value chains. And I'd like to offer this simple pictorial as a way to understand where those types of similar equivalencies and others really compare to other types of industries. In the timber industry, You hear about logging and other areas. You hear about royalties as stumpage fees paid on dollars per ton. Ultimately, you get to first level products, whether that be 2x4s or OSB or other areas, and into very specialized products where other things are combined with that timber or lumber, such as an engineered wood product. In the oil industry, which exists today, crude oil as well is a mineral that's extracted and brought forward, and royalties are paid on the production of that oil. There are other refining businesses that take those types of oils and products and take them whether to some of their more basic forms, such as gasoline, or some of their more specialized forms, such as jet fuel or petrochemical products. And for the brine or the lithium industry together, we originate as a brine produced out of the wet wellhead, very similar to oil and the resource that exists there with the lithium ions within it. There are intermediate products such as lithium chloride that start to combine that with other materials like fresh water to create solutions. And ultimately, you can end up with a variety of different products, as I mentioned before, that can be quantified and evaluated based off their proportionate share of lithium within them that are known as lithium carbonate equivalencies. Those, again, include things like lithium carbonate, lithium hydroxide. So as everyone is well familiar, there are various portions of a value chain or the progression that any type of product may go through from resource into ultimately manufactured goods or products. But I want to highlight one unique differentiation that exists here today for the brine industry and into the lithium industry. As you can see in some of the examples that I've presented here, there exist markets. And by markets, I mean known prices and transactions and points of sale that allow for the establishment of valuations, whether that be the timber on a dollar per ton stumpage type fee, whether it be crude oil based off its transacted revenues at the wellhead and its termination. But that does not exist for brine. That does not exist for lithium chloride. That only exists the markets today, and we'll talk about further in the specialty goods and products. And so this is one of the challenges that we've had to face as we've looked to establish how do you establish a royalty for a resource and for a mineral like brine with lithium ions? And how do you create the potential for mineral owners to benefit in the upside potential of direct market connection and have the realization of when their mineral is contributing to products and goods and such, which may realize growth and the other dynamic aspects of markets? How do you create a royalty construct and design which affords mineral owners those benefits while also recognizing the distinct differentiation between those? That challenge is one that we'll talk through a lot more, and the solution as well as we've brought forward in our proposal. So let's take a little bit of a closer look at an example on that comparative basis. As I mentioned, in the oil and gas world, the royalty is valued at the wellhead on the mineral, on the product, as it's produced out of an oil and gas well, and the hydrocarbon exists there. It also becomes the point of sale or the point of transaction because of the established market and indices and contracts and availability that provide a pricing basis and a valuation basis with a direct market connection. Things like WTI or Brent indexes. In oil and gas, those types of resources and goods do progress on through a variety of separate businesses and models that lead to ultimately specialty products, whether that be jet fuel, petrochemical products, gasolines, or other areas. But those are in that industry entirely separate businesses. In direct lithium extraction, we see a fairly similar value chain as it progresses, but one distinct differentiation is I highlighted. The royalty, to be focused on the mineral with a brine with lithium ions within it, exists at a location where there are no points of sale or established markets or transactions. Those only exist at specialty goods and products that require the combination of many additional substances and unique refining processes in order to establish them. So while minerals should be valued based off of their ultimate contribution in other areas, and oil and gas markets have that directly available to them at the wellhead and transaction point, lithium has no market until you ultimately get to the specialty chemical products. Next slide, please. So what does it take to get from one step to the next? The extraction industry, as many here are very familiar with, is a long-established process for drilling and production. It's seen today in its development and support of bromine industries and other areas. And it draws upon many experiences and decades of experience as well from the adjacent oil and gas industry and the development of wells and the evaluation of subsurface and long-term reservoir management to ensure the appropriate and most economically and most thorough development of a resource. But when progressing and developing a lithium brine to ultimately turn it into specialty products, the majority of the cost, expertise, technical know-how, risk is involved in converting those lithium ions from brine into specialty lithium products. That significant amount of operational and development capital and hundreds of millions to billions of dollars invested by operators on risk solely borne by their capital investment. It requires significant engineering, execution, and operational capabilities to build what in many other industries that I highlighted is a completely independent business. But because of the nature of brine resources, from two factors. One, in the lack of establishment of markets anywhere for intermediate products of the resources, right? But two, the scale and the dilute nature of brine resources creates this interconnect of these businesses and brings them all into one in a typical project development, like many that are being considered here in Arkansas. And it does that because brine requires scale. Brine requires significant investment because it's a very dilute resource. Without that scale, without that then significant investment potential, the products and minerals that would be developed today would have limited value to ultimate markets. It is only once you're able to establish a significant amount of investment and a combination of those products together and ultimately convert them into the products that customers and ultimately manufactured goods are seeking, do they arrive at a location where there are markets established and where there's the capability to take a very dilute resource, bring it together, develop an entire project and value chain that involves refining and development of the resource, combining it with additional raw materials and technology and other intellectual property to create those products, and end with a specialty product for sale. So I set these as foundations to help understand, again, the challenge that exists before us in recognizing how do you value the substances and how do you recognize the products. In attempting to value the raw mineral and the substance, one can look to things like the historical dollar per acre or dollar per barrel type recognitions that would establish a value for the raw mineral and the substances within it. But the challenge being that there is no market. There's no market to give us a view of what that is worth. There's no market to establish dynamic upsides and benefits to mineral owners and from a direct connection if we were to do it at that point. We could look to value it entirely off of the refined product and in a direct proportion to that. But at this point in time, while there is a market for these products, you'd be valuing something entirely different from the mineral and the resource itself. You'd be looking at something that, in this example, like a lithium carbonate equivalent, only 18.8% of the ultimate product is actually made up of lithium itself. So the solution we're trying to find is how do you value a substance with the equivalency of products and products market prices that then fairly values each of those contributions, that fairly addresses the risks that are born, that fairly looks at where the value add and various other substances come into play in developing ultimate products. To help contextualize that type of example, I often get asked the question, and I think it's important to understand in our royalty design, which we'll discuss later, when we say it's a 1.82% royalty, of what is the question that presents itself. To help create a simple and transparent model, and one that is directly connected to products and ultimate markets that allow us to guide a potential valuation, our royalty rate is proposed as an LCE equivalent, or on the entire product percentage that comes through there. So the royalty on a lithium carbonate product equivalent. If one were to simplistically look at lithium's overall contributions into that product, or the lithium substance in lithium carbonate, an equivalent royalty would actually be close to the 10% royalty on the lithium itself is contributed. In other words, the portion of the product that does come from the brine and does come from the resource. So I present this simplistically to help, again, provide us an example of the differentiation that we started with as we look to this conversation. Lithium minerals and lithium and brine and the elements that exist are very different from lithium products. But when one understands that concept and is able to use it, and one understands the overall royalty construct that we will present here today, that provides an opportunity for both transparency and consistency in the way ultimately a lithium product and substance can be valued proportionately and equivalently in their overall contributions. So I'll set the foundations today with a bit of an overview of our overall royalty design. And then I will ask several of my colleagues to step forward and present details behind each of these elements. As I mentioned, the challenge that was presented to ourselves in developing this requires a total view of a royalty design. Each of these elements plays a key portion of the overall royalty construct. Each of these elements cannot be viewed in isolation. They work together to consider all of the complexities that I mentioned previously and to provide benefits to mineral owners, as well as fairly and equitably value the contributions and risks borne by all those involved. In order to establish this, we draw upon a variety of core principles. First, as in line with statute, it must be fair and equitable for everyone. It must afford the ability to develop resources and foster Arkansas's lithium development, or position itself for the resources development and entry into the global markets. It must be simple, transparent, and broadly applicable. And by broadly applicable, we mean it must be able to provide a consistent basis so that no matter what types of products and developments or other areas, no matter what types of resources and qualities and other areas, that every mineral owner is equitably treated, no matter who their developer is, no matter what project is developed, for the actual resource that they are contributing to those developments. It must have long-term stability and alignment. The investments that companies like ourselves are considering making, we do so based off of a variety of foundations. Whether that foundation consider both the resource that has been here and known for a long period of time, but as well as the fiscals or royalty systems or tax systems and other guiding regulations and principles that allow us to make these long-term investments. I think it's important for me to highlight longevity of these potential investments and what it would take to ultimately develop these projects. With brine and a dilute resource and the levels of capital to be invested today, potential project developments and other opportunities that exist with it here could proceed in 20, 30-year type developments. And that's based upon the level of capital that's required to be invested to afford the entire value chain necessary to take a lithium brine and ultimately convert it into specialty products, and as well manage the aspects of the dilute nature of this resource and the scale and other aspects required to justify those investments. These core principles are areas that we then look to our ultimate royalty design and bring several elements together that I'll highlight. And as I said, my colleagues will highlight and we'll walk through each in a moment. The first portion of our royalty design focuses on the quantity or the resource itself. We create that as an LCE equivalent to ensure that the variety of different products that may ultimately variance are fairly and equitably treated back to the resource owner. In each of these instances, that LCE produced stays directly proportional to the mineral extracted. Now, what do I simplistically mean by that? If the resource produced doubles in quantity, then the mineral owner's compensation will double in quantity. If the mineral continues to be produced over a long period of time, throughout all of those times and whatever the ultimate scale and contributions and total quantities developed of the resource, the mineral owner will be directly compensated for those proportionally. So by doing this and understanding the direct proportionality of how lithium and its elements may ultimately end up in a variety of differentiated products, it affords us a common basis to ensure, one, that these variety of potential developments can come up with a consistent standard for all minerals and the resources within them, and two, that ensures that mineral owners are proportionally compensated, whether it be based on the quality or the scale or the ultimate quantity and volumetric contributions of their resource. The second is price or market. When I think about the time that I've spent with many mineral owners that are very interested in having their resources developed, they focus on the first, which we just talked about, and ensuring that as their resources developed, that they are directly compensated for the proportional basis of how they're contributing into that. And the second is that they would like to see a direct connection to some form of market. In other words, they recognize the dynamic nature of markets and businesses that go through sometimes potential upsides and sometimes potential downsides. But it is those potential upsides, I believe, that many mineral owners are focused on and want to ensure that should lithium markets develop or evolve from today into the future, or as they move through the ups and downs and dynamics of any market that exists today, that they have the opportunity to realize in the benefits of that potential market and how their lithium resource may contribute to that. And by connecting the pricing basis that we utilize in our formula directly to those markets, we provide that opportunity to mineral owners as well. Again, simplistically said, if the lithium index market prices double, the compensation to a mineral owner doubles as well. We then get to the royalty rate, which we'll spend much time discussing in subsequent sessions, to offer a consistent, fair, and equitable value based off the various principles that I talked about previously. And we need to ensure that we also have an allocation methodology that aligns with the statutes and the brine ownerships, and simplistically said, based off the acreage and proportionality of mineral owners' contributions. All of these come together to provide the additional lithium royalty or the additional substances compensation as dictated by the statute for consideration. But it's also important to recognize that mineral owners are also still paid a brine royalty that any time a barrel of brine is developed is paid to the mineral owner at this point in time on a $1 per acre basis at $65 an acre. So I'd like to thank the commissioners for allowing me to provide a bit of an overview and foundational that I think is very important for everyone to consider as we move into the next steps of definition of what our overall construct is. But if you afford me a reminder back to our very beginning and the overall flow today, I'd like to ensure that everybody remembers that we're here today to understand how to value a mineral and the resource. And we're here today to understand how to afford mineral owners a fair and equitable basis in the contributions of that resource's development. But as well at the same time to recognize the significant values and risk and contributions of developers and ultimately transitioning that resource into specialty products that are much differentiated. Thank you.
Ask the witness, Mr. Daly.
Yes, sir. That concludes our presentation on topic number 1.
All right. Thank you, sir. I'll ask counsel, any cross-examination? Mr. Hickey.
Yes, Judge Jenkins. Thank you. So you mentioned that your specialty or job is about building out the infrastructure for all of this. Is that correct?
My job is our overarching lithium business. I have experience in both project development as well as business development and a variety of industries.
Okay. Are you aware that the in lieu payments on the brine account for the lifting costs and the transportation costs to transport the lithium and the brine to the facilities?
Yes, I am.
Did you know that lithium is recognized in the state of Arkansas by the government and the federal government as a mineral separate and apart from brine?
I'm not here to make a legal determination, and I'd be happy to have my counsel provide a summary of that.
No further questions.
Thank you, Mr. Hickey. Mr. Stolba? Mr. Perkins?
No questions, Your Honor.
Thank you, Mr. Perkins. Pilkington? No? All right, Mr. Daly. Let me ask the commissioners, any questions? Sure.
Remy, market area, what kind of is it several different markets on this lithium, or is it just one market? And what is the professional name of the market?
So we'll probably better answer that in the next section we're about to cover as we get into the royalty design. Our proposal looks to the lithium carbonate technical grade market as represented by Fast Markets Index as a representative edition of the first product that is typically developed from brines or many other resources before you get into all the other types of derivatives. But when you talk about lithium carbonate equivalent, that is a lithium carbonate market. And thereby, when you do a proportional basis of volume, you also end up with a similar market for that proportion.
Thank you, sir.
Okay. Yeah, of course. When you strip the lithium out, can you hear me? When you strip the lithium out, are you stripping 100% and the brine that's returned is zero lithium, or is it just partial stripping?
There will always be some level of extraction efficiency depending on the technologies and the capabilities of the operations. And I would say 100% extraction is very, very unlikely in those scenarios. Each of our technologies would often attempt to extract it the most amount possible to ensure we're developing the resource to its maximum potential, but that would never be 100%.
And then you're returning it, pulling it out, essentially pulling it out again at the other end. Do you have some time frame as to how long it would take before it'd be depleted?
So as I mentioned, these potential types of project developments will need to account for a variety of factors, whether it be the scale of that project, the ultimate resources deliverability, the concentration that exists within it, and ultimately the long-term expertise in reservoir management that these operators will need to bring to ensure that you can manage both the production of the resource as well as the reinjection of the resource. The reinjection of that resource, just like the brine industry today, is a key component of that for a couple of factors. One, it creates an environmentally sound solution for the development of very salty brines that are brought up to the surface, of which you're only extracting a portion of the product. As I mentioned, 0.04% of the ultimate barrel is what the lithium is within that. The second of the aspect is actually reservoir management. So without returning that brine, or that tail brine as it's often called, under which a substance has been extracted, whether that's the bromine that exists today in certain fields or lithium potential in future fields, without returning that back into the resource, you'd be on what's known in the oil and gas industry upstream businesses as on primary depletion. And the lifetime and expectancy and the ultimate ability to develop a resource to its maximum potential would be severely compromised, because you would not have the pressure support and maintenance and movement of water. And that is the value and contribution of ejection wells and the return of the tail brine into the resource itself, as it allows for the continued pressure and reservoir management maintenance and the ultimate expertise operators will need to work within to ensure that producer-injector interaction and overall resource development is done to the maximum effect and benefit of the resource itself.
And when you build this plant, are you going to strip bromine too, or is it just lithium that you're after?
That's an ultimate decision for every operator based off their ultimate development plans.
So you haven't decided yet?
Our current focus for ExxonMobil is lithium development.
Okay, thanks.
So, in your equation, just to clarify, under the price, that is for the lithium carbonate.
That is a lithium.
Not lithium.
No, that is a lithium carbonate product.
Okay.
And we have some colleagues here who will talk a lot more through the definition of that.
But there's not a market for just the pure lithium when it's just
not as it appears as an element or an ion in a brine.
Right. So all right. And then the 1.82% is of whatever lithium carbonate that you've created.
The ultimate specialty product that is created.
Which is what percent is just lithium that's in the carbonate?
If you were to make carbonate, only approximately 18.8% of that ultimate product would be lithium itself.
All right. So the stuff that you have to put with it to make the carbonate does not come from the brine.
That is correct. Those are mostly procured other goods and solutions, as well as other impurities that are further removed to create the ultimate product.
So the only thing that goes into the carbonate that you're getting from the brine water is the lithium, which is 18.8% of the carbonate, which is what the price is set by.
Correct.
Okay, thank you.
Any other commissioners? Yes, sir.
To go a little further to his question, can you back your slide up where you broke down? That's it right there. So when you have the equivalent royalty of 9.68% of lithium, it's not really true, right? Because you're not paying for lithium, but you're paying for a carbon equivalent based upon your royalty rate.
Yeah, so again, this is just a simplistic example to help provide that contextualization of if you were to design a royalty construct that just looked at lithium's contribution and percentage into an ultimate product, that would be the equivalent royalty rate of if in comparison to our proposed construct, which recognizes the entire product and thereby the royalty rate.
Okay. But I guess what I'm asking, it's a little misleading because if you were paying based on lithium, once you split that for easy math, we'll call it 5 ways, then that would still be the equivalent of almost a 10% royalty, right? But since you're paying on a carbon equivalent, you're still only paying the 1.82.
No, because in this scenario, and the reason I draw the equivalency is in neither scenario does the price change. So the price is always based off a lithium carbonate product price. And so in order to have the same equivalency when the pricing basis that you utilize for value would be the same, this is simplistically the royalty percentage that would be utilized dependent upon the quantity that you choose to represent in the quantity portion of a formula.
But you really can't compare them. I mean, because you're talking about the issue there, if I understand it, is just that there's not a market for lithium ions.
That's correct. So we simply provide this as a contextualization to help represent, a challenge that many feel when they look to a number and what it may feel like as a percentage basis as a low single digits. But instead, because of that need to connect to markets and where those markets exist, we've utilized the total lithium carbonate product that includes many things that do not come from the resource itself to then create a more direct connection to then the pricing and the markets and the basis under which we design this formula.
Let me ask you this and tell me if I'm jumping ahead and you're going to further explain, but of that lithium carbonate equivalent, what would you say? I mean, do y'all have any information? Are you going to present anything on the value of the carbonate plus other versus the value of the lithium?
So if we go back to the slide that talks about everything it takes to ultimately get from one end to the direct, while there are a variety of direct costs, if you just looked at the procurement of certain materials and other areas, there are also the entirety of everything else that it takes to ultimately go through various value chain and other business potential segments that exist, whether that be the capital and the risk for the development of the ultimate processing and manufacturing capabilities to develop those products, whether that be all of the operational costs in other areas, whether that's the not easily quantifiable capabilities, intellectual property, and other areas that a developer contributes into the overarching process. So we highlight these because while there are direct costs that can be contributed, there are also a significant amount of indirects, whether that be the value contributions of the developer themselves, or as well as the risk that they bear and the capital that they risk in this overall process.
Okay, last question. Once you extract your initial extraction of the lithium, you can determine an amount, right? We're not talking about LCE, but you can determine lithium ions, which is that correct? In your initial extraction, whatever that would be, you can quantify what you've extracted.
There's a concentration in the brine that you could look at, as I mentioned, makes up if in a 350 part per million example is highlighted in our opening slide, that makes up 0.04% of the barrel of brine that exists there today.
Okay, thank you.
Any other commissioners? Council, based on the line of questions from the commission, any follow-up, Mr. Daly?
We're ready to move on.
All right. Mr. Perkins, any questions? Stovall, Mr. Hickey? Everything? All right. Next witness, please.
Edmondson. Please state your name and how you are employed, Jesse.
Yes, sir. Yeah, good morning to the commissioners and all those in attendance. My name is Jesse Edmondson. I'm an Arkansas native, born and raised in Fort Smith, Arkansas. Proud graduate of the University of Arkansas in Fayetteville, where I received my bachelor's and master's degree in geology. I've worked in the critical mineral and battery materials industry now for over 13 years. I've been honored to support Standard Lithium as their Director of Government Relations for the past 2 years. I'm here today representing SWA Lithium, which is a joint partnership between Standard Lithium and Equinor, as well as Standard Lithium's interest in the Lanxess brine units. Wanted to mention that I heard the comments that started us off today, and wanted to ensure that Standard Lithium is dedicated to uplifting our local communities, and we're also focused on hiring from our local communities. A couple other clarifications. To date, with our demonstration plant that's at the El Dorado South unit, all of that brine has been returned, as well as the lithium minus a couple of kilograms that we've used for testing and for sending to samples have all been returned directly to the Smackover formation. There have been no sales to date of lithium from that demonstration plant. Standard Lithium to date has made no profit. In fact, we've invested approximately $100 million into developing our company, building our team, and developing these projects in Arkansas, but have not made a single dollar to date. However, what we have done is we've hired over 30 locals from our surrounding community that are operating that demonstration plant. We've done that now for over 4 years. We're very proud of the local team that we've built, and we would put them up against any DLE team on the planet. So, speaking to the royalty formula, let's discuss the first variable in our proposed royalty formula, which accounts for the quantity of lithium that is being extracted. Note that we are basing the royalty on the quantity of lithium extracted instead of the quantity sold. This guarantees consistent and reliable royalty payments to mineral owners and assures that mineral owners are not reliant on producers to sell all of the material before they are paid their royalty. Next slide, please. As Remy mentioned, when we say lithium, we need to be specific to what form of lithium we are describing. Lithium ions that are dissolved in brine have no immediate defined market value. That value begins to become unlocked with direct lithium extraction. The first typical product that is derived from direct lithium extraction is lithium chloride. This is an unrefined lithium salt, which also has no established market. If we want to connect the lithium royalty for Arkansas Smackover mineral owners directly to a market price, the lithium chloride has to be further refined to the first sellable product, which would be technical grade lithium carbonate. So for our proposed royalty formula, we believe the quantity should be calculated based on what the industry refers to as lithium carbonate equivalent, commonly referred to as LCE. Lithium carbonate equivalent is the amount of lithium in 1 ton of lithium carbonate and is the global industry standard for reporting and comparing quantities of lithium across different projects. So this means the differing amounts of lithium in brine or between various refined specialty lithium products like lithium carbonate, lithium hydroxide, and lithium oxide can all be directly compared by normalizing each to lithium carbonate equivalent. This ability to convert between compounds is exact and is based on the fundamental laws of chemistry. Therefore, this calculation can be utilized across all Smackover lithium projects for all of time and for all production scenarios. A conversion table has been included as Exhibit A in our application package. Next slide, please. Here you see an example calculation using the information from Standard Lithium's pre-feasibility study for the SWA project, where it contemplated production of 30,000 tons per year of lithium hydroxide. So if we wanted to convert the quantity produced from lithium hydroxide to lithium carbonate equivalent, one would simply multiply the amount of hydroxide by the conversion factor of 0.88 to calculate the equivalent quantity of lithium carbonate. So again, you can see in this example, 30,000 tons per year multiplied by the conversion factor would be the equivalent of 26,430 tons per year of lithium carbonate equivalent. Next slide, please. The next variable we would like to discuss is the direct connection to a market price. Basing the royalty payments on a published index price protects the confidential agreements that producers have with their customers while also ensuring that mineral owners are paid a royalty based on the current fair market value of lithium. Again, it is critical that the contracts we have with our customers remain confidential. This provides fairness and consistency by tying all payments to one market-based price, as well as provides validation from a third party. Price reporting agencies like Fast Markets provide objective third-party pricing data for lithium products that are utilized by producers, consumers, and investors for providing transparency on current market conditions. As previously described, technical grade lithium carbonate is the closest product to the wellhead for which third-party pricing data has been established. Fast Markets is a well-respected global price reporting agency whose lithium price reporting has become a global standard for the lithium industry. Fast Markets currently provides a pure North American lithium index. This is US plus Canada, which we have determined to be the most appropriate and accurate index representing the sales of specialty lithium chemicals in America, where any potential price premium for made in USA lithium should be captured. It is my pleasure to now introduce Grace Asanoff from Fast Markets, who will provide a more detailed overview of her company and how the lithium indices work. Thank you.
Thank you, sir. Hold on a second. We might have some examination of you. Mr. Hickey, any questions?
Yes, Judge. I have one question. Good afternoon. Are you familiar with the statute that all of this cues off of with regard to profitable extraction and determining a value?
Yes, sir, I am.
Are you aware that it requires that you show all cost of producing?
That's not mine.
Objection. This calls for a legal conclusion, an incorrect legal conclusion, by the way, from a lay witness.
Mr. Hickey, what's your response?
My response is I'm reading straight from the statute.
Yeah. I'm not overrule your objection, Mr. Daly, because he said he was familiar with the statute. Can you answer that question, sir?
Can you repeat the question?
Yes. You said you're familiar with the statute. Are you aware that it requires that, are you aware that it requires that any party that asks for the commission to determine that it can be profitably extracted must show all cost of producing such additional substance?
Can you please read that part of the statute?
Yes. In addition to any other amounts due and owing by the producer or producers of any unit to the owners therein, the producer or producers shall account separately and on a fair and equitable basis to each owner in the unit for all substances which are found by the commission to be profitably extracted from the brine by a producer and which were not extracted by a producer on January 1st, 1979. Then it goes down to say whether or not any such substance is extracted profitably shall be determined by the commission on the basis of the value at the time of extraction. Let me stop right there. Have you or any of the other co-applicants profitably extracted any lithium from this brine?
No, sir. I thought I made that clear in my opening statement.
Then it goes on to say the value of the brine without interest, the value of extraction without interest after deducting all cost of producing and recovering the same. So my question to you is, have you applied for a determination of profitable extraction?
I want to object again for a slightly different reason. The commission earlier this morning approved Judge Moulton's recommendations with the exception of the Albemarle matter. Judge Moulton has recommended, and the commission has approved, that the applicant needs to establish that it can profitably extract lithium, not that it has, not that it can. If Mr. Hickey would like to ask if Albemarle or if Standard Lithium can profitably extract lithium, that would be a proper question.
Well, I'm not even certain about that, Mr. Daly, because I think it's outside the scope of his presentation a little bit. Mr. Hickey, can you clarify for that?
Well, yes, sir. The way I read your memorandum was that you stated that you believed it was a prerequisite to determine profitable extraction before we can have these royalty conversations. Is that not correct?
I think that's what Mr. Daly agreed to, that it can be profitably extracting, not that it, I think your question was, has it been?
It was,
Okay.
yes. And so in reading the statute, it appears to me that the producers must account at that time and pay when it has been profitably extraction. So my question is, have you profitably extracted? And I believe the witness said.
The witness said no.
No. Okay. And have you produced all of the cost of producing and recovering the same?
Can you answer the question, or can you ask the question again?
Yes, sir. Have the co-applicants produced all of the cost of extracting and producing the lithium?
So I can only speak on behalf of Standard Lithium. Okay, we have published technical reports that contemplate and try to do a best determination of what that would look like, but we're not in commercial production yet, so I do not have a crystal ball into the future.
Okay, thank you.
Thank you, Mr. Hickey. Mr. Stolba? Mr. Perkins?
Yes, Judge, I have a couple of questions. Mr. Edmondson, you started out introducing yourself and said you'd been in the critical minerals and battery materials industry the last 13 years. Did I write that? I tried to write it down quickly. Did I get that right?
Yes, sir.
Can you explain what you mean by that?
Yes, sir. I've been a geologist by training, the finest university in the country, trained by some of the finest geologists that have ever stepped foot in the state. My first introduction to critical minerals was with graphite in the state of Alabama. I've worked as a geologist on early stage mineral exploration projects. Over the last 5 to 7 years, I've become an expert on other critical mineral supply chains, particularly battery material supply chains. I've provided business development and government relations consulting to a number of companies ranging from large multi-billion-dollar chemical companies to state governments. I've attended critical mineral conferences, battery material conferences for the last 7 years. Do you need further clarification than that?
No, that's good, but your presentation didn't really have anything to do with geology. So I'm really trying to figure out why you were sworn in as a witness on this. Did you prepare that presentation, or did someone else prepare it for you and give you a script to read?
I wrote my own script. Thank you very much. This is a group application, so there's been some collaboration to make sure that we're presenting a thorough representation of our industry and the opportunity for Arkansas.
Hello? Okay. 3 years ago in Alabama, you were
Hey,
found.
Judge, before Mr. Perkins we have a sidebar. I believe Mr. Perkins is about to get into something that is not admissible in any court in the country. And
It sure is. Goes to credibility. It's a conviction.
what's that? I'm sorry.
I don't know if you can,
Well,
Mr. Honey, I don't think you can do a sidebar in an administrative hearing. I've never heard of that.
then maybe we
before.
have a recess.
All right, we can have a recess.
You're the judge.
Uh-oh, the chair is just telling me that it's a good time to break for lunch. Is that right? All right. Mr. Chairman, how long does the commission need for lunch? Do you need 30 minutes?
Got 300 people.
What do you want? We're going to break an hour for lunch. So it is 12:06. We will reconvene at 1:06 for off the record.
Come on, JC.
Please find a seat.
Commissioners, are you ready to proceed? All right, we're back on the record. Mr. Perkins, you were in the middle of your cross-examination. Mr. Honey had an objection. I have read the document in question, and I have conferred with counsel off the record. But for the record, I'm going to overrule Mr. Honey's objection and ask Mr. Perkins to please proceed. Go ahead.
Mike, okay. Thank you, Judge Moulton. I was asking Mr. Edmondson about his experience in the critical minerals for the last 13 years. And then I was proceeding to ask him about whether he was cited by the Alabama Securities Commission for the unlawful sale of equity interest in a gold mine in Alabama in 2021. Is that accurate, Mr. Edmondson?
Hello. All right. The matter in question, sir, was in the 2012 to 2014 timeframe. The issue was resolved in 2021.
Okay, so and I have copies for all the commissioners and the court reporter, but I'm gonna.
Close to.
Okay, is that better? I said I have copies for all of the commissioners and the court reporter if we need to pass them out, but I'm going to read a finding there. It says, whereas Edmondson admits that he was not registered as an agent or broker dealer in the state of Alabama, and that in ignorance of the law, he attempted to facilitate the purchase of a security in the state of Alabama. Edmondson avers that his employers encouraged him to solicit potential investors for the projects and never informed him that his actions were unlawful or otherwise improper. Do you recall that portion of the order, Mr. Edmondson?
Yes, sir.
That's all I have.
Mr. Daly? Mr. Honey?
There we go. No further questions of this witness.
Right. Commissioners, any questions? Oh, I'm sorry.
Jesse, does Standard Lithium intend to profitably exercise or profitably extract lithium? You need to say it again after.
Can you repeat your answer, Mr. Edmondson?
Yes, sir. We believe that we can profitably extract.
That's all.
Thank you, Mr. Daly. Commissioners, any questions? All right, Mr. Daly, your next witness, Mr. Honey.
Yeah, I'm going to take the next witness, Grace Asenov. Have you got a mic, Grace?
And ma'am, if you would be so kind as to spell your last name as well for the record. Could you spell your name for the record, please?
Good afternoon. Yeah, my name is Grace Asenov, and that's Asenov. Can you hear me okay?
Grace, how are you employed?
I'm employed by Fast Markets
And how long have you been with Fast Markets?
for 10 years.
Okay. What's that? I can't, yeah, I'm having trouble hearing you, Grace.
Okay. Can you
Speak very
get a little
directly
bit
and
closer? Is that better?
yeah, that's better. Well, please tell us about Fast Markets.
Thank you. I'd like to speak for about 10 minutes to introduce you to Fast Markets, which is the company reporting on the lithium price that would be used in this proposed royalties formula. So Fast Markets is a price reporting agency, or a PRA for short, that specializes in providing independent and transparent spot price assessments for commodity markets like lithium. We also publish news and analysis and host events for these markets. Spot prices for commodities are not always readily available on a central exchange like they are today for oil and gas. So Fast Markets steps in to bring clarity to these markets by gathering data from a broad range of sources, analyzing it with rigor, and publishing unbiased price assessments that market participants can rely on for business decisions. We bring transparency to markets that would otherwise remain opaque. Our definition of a price assessment is the prevailing level at which money and a commodity of a stated specification have or could be expected to have changed hands over a defined period of time based on information reported to us by buyers, sellers, and traders. We refer to this information that we collect from market participants as inputs, meaning the bids, offers, assessments, and transactions that represent a spot market. And please change the slide. Our price assessments ensure fairness, promote market stability, and help businesses manage risk. Whether a company is setting contracts, evaluating investments, or simply trying to understand market trends, they need reliable, impartial data. And you can see from this slide here that Fast Markets is producing more than 6,500 price assessments with more than 650 employees in locations all over the world. Next slide, please. So now we've established what Fast Markets does, and I'd like to talk about who benefits from these services. Our customer base spans multiple industries that we can break up into 4 sectors. Number 1 is metals and mining, which includes companies involved in the extraction, refining, and trading of metals like copper, aluminum, and steel, and end markets such as automotive, aerospace, and electronics, just to give you a few examples. Number 2 is agriculture. So farmers and food processors rely on Fast Markets for prices on grains, oilseeds, sugar, and other agricultural commodities. And a typical end user would be a food and beverage company. Number 3 is forestry products, including mills for paper, container board, and tissue paper, just to name a few, with customers including some of the largest retailers in the US. Number 4 is the energy transition sector, which is where lithium sits. And a typical customer would actually be an oil and gas company. Even though we don't price oil directly, we do focus on sustainability products, including biofuels, hydrogen, and other emerging energy sources. And outside of these physical markets, there are also 3 groups that commonly use our data, including financial institutions like banks, analysts and researchers, and government and regulatory bodies. We have more than 15,000 customers worldwide, including a significant number of Fortune 500 companies and other household names, with physical contracts tied to our prices representing hundreds of billions of dollars in transactions. These Fast Markets customers subscribe to our data because they want to reference our prices in long-term contracts, understand inventory value, track purchasing and sales success, and understand market trends and directions. Next slide, please. So how do you know that Fast Markets lithium price is reliable? When people talk about the price of lithium, they're talking about the Fast Markets price. Our lithium prices are listed on the 3 of the largest cash-settled metals exchanges in the world, including Chicago Mercantile Exchange, or the CME Group, London Metal Exchange, and Singapore Exchange. And we're the only PRA in the world to set the foundation for futures and options trading in the battery raw materials supply chain. Our lithium prices are used in Bloomberg's commodity benchmarks, which is another formal vote of confidence from a major financial institution. Fast Markets founded and still hosts the largest lithium conference in the world right here in the US every June. This past year, we hosted our 16th annual conference with 1,500 attendees in Las Vegas. Last but not least, we also adhere to strict compliance standards. We're voluntarily audited every single year by a Big 4 accounting firm to prove that we're meeting regulatory guidelines for price reporting agencies, that are defined by the International Organization of Securities Commissions, which is a globally recognized interagency body. Our team of reporters is trained, our sources are vetted, and our prices are published via a peer review process. Fast Markets has built a reputation over the last 150 years for reliability and integrity in price reporting and analysis. And the Fast Markets brand was created by bringing together historic industry trade publications, including American Metal Market, Metal Bulletin, and Industrial Minerals. We routinely invest in our pricing systems, maintain an open methodology that adheres to international standards, and regularly engage with the market. And as a result, we have the trust of the markets we serve. Next slide, please. So now I'd like to talk specifically about technical grade lithium carbonate. Fast Markets has been pricing lithium in various forms since the 1960s, and specifically carbonate for the US market since 2017. We were the first price reporting agency in the world to launch lithium prices for the US. The word technical refers to the grade of lithium that is traditionally bought by the ceramics and lubricants sectors. The first saleable product with a spot market that we can assess in North America is technical grade carbonate. We've captured the highs and lows in this market in the last 5 years, as you can see in this chart, with prices ranging from $6 all the way up to $73 per kilogram. Prices in 2019 were relatively high at the time due to rising interest in electric vehicles, but slowly declined over the next 2 years due to oversupply and customer destocking, as well as the end of a subsidy program for EVs in China. During the pandemic, prices spiked on higher production costs amid inflation and rising demand for EVs and energy storage. We saw rapid capital inflow at that time into the lithium industry on these high prices, which accelerated project development. That quickly led to a massive oversupply, which has now driven prices lower in the last 2 years. And who has contributed to this oversupply? China is currently the largest processor of lithium in the world, and they're expected to keep this status for the next decade. Africa is another region that has somewhat unexpectedly emerged as a significant supplier of lithium in recent years and also contributed to this oversupply. And as a result, the US needs to compete versus other world players, and our lithium prices and operating costs need to be competitive in comparison. Next slide, please. So this is showing this is the same chart, but just in the last 6 months. The green line on top is the US, the purple line is Europe, and blue is Asia. The US market right now is the highest in the world. This is not really because of stronger demand, but because of tariffs versus Chinese lithium and EVs that have discouraged the domestic US supply chain from sourcing from there, and as a result has just limited the number of available sources. Moving forward, thanks to the Inflation Reduction Act, this US premium is expected to remain in place for some time because the market is willing to pay more for IRA compliant material that they can receive tax credits on. Next slide, please. So if you're wondering how many inputs are reflected in our price and how many people we're talking to, up until April of this year, the US market was priced in a joint assessment with Europe, really as an ex-China lithium market. And so what you see here are the number of inputs that we've collected during that time, and we relied on many multiple data points to set our prices, with the last quarter, the second quarter of this year, representing 55 inputs. Next slide, please. The domestic market is predicted to grow rapidly in the next 10 years. North America is expected to add around 180,000 tons of lithium carbonate equivalent capacity in the next decade. And that means the number of inputs behind Fast Markets assessment is expected to grow too. So we plan to collect more and more transactions even in the next year. Next slide, please. We collect inputs only from active market participants, and the price we publish reflects those prices as illustrated in this chart, which is maybe a little bit hard to see, but the dots are the inputs that we've collected and the purple line is the price that we published. And so you can see that the price we've published reflects the inputs that we collected. And how do you know that we're publishing a fair price? Number one, we vet all of our sources. I don't favor buyers or sellers, and we make sure that we're talking to both sides of the market. Number two, when assessing inputs, we consider the significance of the information, which are deals are favored over bids and offers, for example. And we also consider the confidence that we have in the information. So can a deal be corroborated? Can they prove a transaction by showing us a purchase order? And how well do we know the source? And number three, without an explanation for why an input is much higher or lower than others, it is discarded. So we're not influenced by a single piece of information. Next slide, please. And this is my last slide. I just wanted to show you an example of the certified letter that we plan to provide to this commission and also the applicant producers, which shows our quarterly average. Thank you.
Thank you, Mr. Honey. Mr. Hickey?
So science wasn't my strongest class, so I got a couple questions for you. So does your business or the commodities exchange track the spot price of lithium, lithium?
Yes.
Okay, why isn't that do you know why that's not being used here?
We're tracking lithium carbonate and hydroxide prices.
Does your business or the commodities exchange track the hydrogen or the lithium hydrogen prices or the lithium oxide prices or the lithium straight carbonate prices?
If you're talking about the upstream products, which would in this case be lithium chloride, we do not track that anywhere in the world.
Okay. No further questions. Thank you.
Thank you, Mr. Hickey. Mr. Stoba? Mr. Perkins?
Yes, Your Honor. Thank you. Ms. Asanoff, I have a few questions. First of all, the Exxon and the other big five in this case are claiming they can't tell anyone about their actual sales prices when they sell a commodity. So if they were to go into business under the way they want to, you wouldn't have any of their information, right?
They could contribute their transactions to us.
So in your opinion, they can disclose the actual sales price?
Yes.
Okay. Your tracking is an index. I mean, in essence, you are gathering information from all of these sources around the world in order to predict what the sales price was on a certain date or during a certain period of time. Is that fair to say?
I wouldn't use the word predict, but yes.
What word would you use?
Assess the current spot market today.
Okay, but if we compare that method with knowing the actual sales price of lithium carbonate or lithium hydroxide from a specific project, that would in fact be the best indication of what that number is. You'd have to agree with that, wouldn't you?
I wouldn't speculate on that.
Well, it's not really a question of speculation. I'm asking you, if you knew the actual sales price from project X, that would be more accurate than depending upon your index to try to estimate what that price is. Don't you agree with that?
It depends who you are in the market, if you would view that to be accurate or not. If you buy from a different producer, one specific project's number would not be accurate for you.
Well, that wasn't my question. For that specific project, that would be the best source of information, that vendor's actual sales. Would you agree with that?
Could you rephrase the question?
Okay. So I'll try to put it into a concrete term. So let's say Arkansas Lithium and Lanxess moved in, built their industrial scale plant at the Lanxess South unit and they sold, you lost me, lithium carbonate from that project for a month, and they provided you a spreadsheet of all their sales and you could look at them. Would that be more accurate to determine the sales price in that unit, or would you say that your index from around the world would be more accurate?
The fast markets index that we're talking about is for the US and Canada. So I think that would
Not my
accurately
question.
reflect that price.
That's not my question. So just answer my question. What would the best true number be to determine what the sales price is out of that specific project, the numbers that came from that project or your index?
The actual transactions would reflect that specific project.
Thank you.
You're past the witness, Mr. Perkins.
Yes, pass the witness.
Yep. Mr. Pilkington, any? Mr.
I
Howard?
do have a redirect, just very briefly.
Sure thing.
Grace, well, you called it input, but the data points that Fast Markets uses, the parties that provide that data to you, is that data publicly disclosed, or each of these parties providing it to you subject to a confidentiality agreement?
Yes, it's discrete information.
Okay. So in this case, when Mr. Perkins says, well, all of the applicants are providing you with pricing data, they're not publicly disclosing the pricing data. They're providing it to you pursuant to a confidentiality agreement. Is that accurate?
You don't need a confidentiality agreement legally, but yes, it's confidential information. We guarantee it.
I'll pass the witness.
Thank you, sir. Mr. Hickey?
You may have gone over this, but could you reiterate one more time, approximately how many transactions have you monitored in the last 12 months and that reflect this index?
For the second quarter of 2024, we collected 55 inputs, and it's been over 50 inputs per quarter, at least for the last year. It's, I believe, close to 70 in some quarters. So that's about a minimum of 4 inputs per week, because this is a weekly assessment.
Okay. Thank you very much.
Thank you, Mr. Hickey. Ms. Strobel, Mr. Perkins? Spoke at them. Commissioners, any questions?
I want to expand on Mr. Hickey's question just a little bit to make sure I understand this. Is it correct that you do not publish a price for lithium, the element?
Correct.
Okay. And so it's lithium carbonate, or as you called it, I believe it was technical grade lithium carbonate. Do you understand there to be a conversion for lithium, the element, to lithium carbonate?
We don't use it.
Okay. So, but you do not, what was the other one you said other than carbonate that y'all publish?
Hydroxide.
Hydroxide. Thank you.
Any other commissioners?
When you say this, what kind of weight do you use for the lithium? You use a ton?
We assess in kilograms.
Okay, thank you.
Any other commissioners? If not, based on the line of questions from the commission, any follow-up from council? If not, Mr. Daly or Mr. Honey, your next witness.
Oh, I'm sorry. It's Henry. Someone will have to give Henry the chair. Approaching is Mr. Henry Landry.
Good afternoon, commissioners, ladies and gentlemen. The next variable.
Henry, let me ask you how you are employed.
Yes, pardon me. Yes, I'm employed by Tetra Technologies. I am a vice president in their chemicals division. I've been with the company for approximately 14 years. Prior to that was general manager of a spodumene mine or a lithium mining organization.
Sir, would you please kind of just state your name again for the record and spell it?
Henry Landry.
Landry.
Yes.
All right, thank you, sir.
Thank you.
I'm sorry, Mr. Daly, go ahead.
Henry, during your tenure at Tetra, have you actually been the person in charge of the plant that produced the three salts that was the subject of the prior application?
Yes, that is the case.
Okay. If you will, please, please explain the derivation of the 1.82% that is contained within the royalty proposal.
Yes, thank you. So the rate of 1.82% is not an accident. It is a rate derived and agreed to by this very committee. Back in 2007, the Lanxess Westfield data, pardon me for the mic here, Westfield data was extrapolated backwards to determine that the per acre fee at that time, coupled with all of the other information from the units, such as the barrels of production, the concentration of the brine, et cetera, that you could back into an effective royalty rate per ton of bromine. And that effective royalty rate was derived to be 1.82%. Subsequent to that, we took the market prices of the three additional substance salts, all chloride salts, metal chloride salts, similar to the lithium chloride metal salt, and applied this 1.82% to come up with a per barrel amount that was effectively charged for the royalty. So the effective royalty rate on bromine in 2006 was 1.82%, and that was applied to these three additional substances at that time, having been deemed fair and equitable. Subsequent to that, and we can move to the next slide, please, which really shows this slide here. I kind of spoke for both slides at once, but this slide here shows the $3.10 a barrel that the 1.82% equated to when applied to the pricing of those three incremental salts. And then each year, that price was indexed on the consumer price index, unlike what we're doing here, which is tying lithium to the market in real time through the index. Next slide, please. Here, we demonstrate a few of the elements of that equation. We show what the average royalty rate per net brine acre was at the time. The average value per net brine acre is derived from the amount of bromine that was produced on that Westfield in that year and what the value of that bromine was. So essentially, each acre of the Westfield was generating $2,205 worth of value in 2006. That 1.82 was then applied, was derived from that calculation and then applied to the $3.10 value of salts to come up with a 5.65 cent royalty on salts. So on the bromine, as you know, the 1.82%, you can take that back to $1 per acre. On the salts, it was paid on a per barrel amount. And of course, we're utilizing the same 1.82, but suggesting that fair and equitable is better represented by applying that to an index, to a live index. Additionally, we asked ourselves, was this 2007 calculation an anomaly that was unfair to the landowner or unfair to business at that time? So we took the Westfield data across 2006 all the way to 23, assumed that yield and acreage were the same, but took the fluctuation in bromine price into consideration. And you can see the values there in the table. You've got a 10-year average of 194, a 5-year average of 168, a 23-year end was at 164. We didn't pull the high number. We didn't pull the low number. We didn't have a scientific reason for pulling any of those numbers. The only real scientific reason we felt we had was the precedent set previously by the state of Arkansas in 2007. What we did further to this is benchmarked that 1.82 globally to make sure that it was competitive across a multitude of markets. And my colleague Remy here is going to take us through that benchmarking exercise following the slide.
Hold on a second, sorry. Mr. Daly, does that conclude your presentation from this witness?
To ask one summary question. Looking at the box on what I see to be the upper right-hand portion of the slide, does that, in your mind, validate that the methodology of calculation has held true all these years?
That would be our determination.
That's
Thank you, Mr. Daly. Mr. Hickey?
I'm not sure I actually have a question for this witness. Are you, hello, good afternoon. Are you here to testify about what y'all did at Tetra, the salt plant, and what's your understanding of the methodology and how that applies to that here today? Is that correct?
Yes, Mr. Hickey. I believe it's clear that the commission is aware of this previously used methodology, but because it's the methodology that we're proposing is utilized again for this one incremental salt, we wanted to take a moment to review it.
Okay. So I guess my question is on this 1.82%, as a bromine royalty, why is that not demonstrative as the current in lieu rate of royalty for the bromine being too low?
That would be a very speculative answer to give. I'm not sure that I could comment on that.
Okay, I'll reserve my questions for others that may be able to address that. Thank you for your time, sir.
Thank you.
Thank you, Mr. Hickey. Mr. Silva? Mr. Perkins?
Thank you, Judge. Mr. Landry, I'm trying to get straight here. So how long have you been with Tetra?
Approximately 14 years.
Okay, and the salts application was in 2007 before your time there. Is that right?
Yes, that is correct. The determination was made prior to me joining Tetra, but after I joined Tetra, the El Dorado facility was reporting to me, so these royalties were paid off of production that I was responsible for.
Okay, thanks. What do you know what price what they're saying today the price is for lithium carbonate or lithium hydroxide or lithium carbonate equivalents, however you want to say it?
Yes, I'm aware of that price.
Can you tell me what it is? Tell the commission what it is.
Yes, we just seen Ms. Asinov's presentation. US right now is in the approximate $12 per kilogram or $12,000 per metric ton.
And what is the value today of bromine?
Spot market is difficult. I'm not sure that I would say out loud in this venue without getting into competitively sensitive information.
Okay, but you want the commission to simply adopt the same methodology they used for bromine to determination of a fair and equitable royalty for lithium, but you don't even know, can't even say what the value of bromine is today.
I can say what the value of bromine is. The Intratech spot actually shows it in short of $2 a pound range.
So about 1/6 the value of lithium carbonate equivalent today, based on the numbers you said.
I'll trust your math on that. Thank you.
Well, 6 times 2 is 12. So That was pretty easy. Okay. That's all I have.
Thank you, Mr. Perkins. Respect. Mr. Daly, any follow-up?
No, sir.
Commissioners, any questions? Mr. Wolford?
Looking at the current slide, you said that it was calculated based on the value of bromine throughout that cycle. Is that correct?
That is correct.
So are you talking about the in lieu of royalty that's paid or the actual value per pound of
The in lieu of royalty.
Okay.
Yes.
So the in lieu of in the 2007 application was $41, if I remember correctly.
Yes, $40.10.
And earlier today, it's been testified to that the current in lieu of is $65.
That is correct.
So were this to be escalated from the original hearing to today, that ratio of 65 divided by 41 would be the increase in the royalty, would it not?
Yes, the 2023 number we see up there at 1.64. The 2024 number we don't have because we have an incomplete data set.
It looks to me, I mean, this is just off the top of my head, but 65 is be about a time and a half of 41. So we should have a time and a half increase in the royalty.
Yeah, there's an interesting nuance with the way the bromine price is related to the in lieu of percentage. So if bromine prices fall, the effective royalty rate increases because you're essentially, well, if you do the math on it, you'll see that it increases. So it's sort of an inverse relationship between the price of bromine and the effective royalty rate. So the higher the price of bromine goes, or pardon me, the lower the price of bromine goes, the lower the effective royalty rate. That's correct.
As I read the order, basically the royalty rate was set at 1.82 and then would escalate from there, but it didn't seem to include any value of bromine. It was just using the producer's price index.
Correct. That is correct.
And if we're using the in lieu of as an indicator of the price index, we're up 1.5 times.
Yes, we are on the per acre, indeed.
So the royalty would go up by a time and a half based on the order that was issued in 2007, not taking into account any change in value of the bromine.
Not correct, if you don't take into account the change in the price of bromine.
And the price of bromine was not factored into that order.
That is correct.
Okay, thank you.
Yep.
Commissioner?
This may not be the appropriate time. You may be able to answer this question, but it relates to the matter. Do you know, was this 2007 application, was it contested or was there any competing evidence as to what was to be paid?
I don't recall. I wasn't at that particular hearing, but in the transcript, I don't recall any other testimony. I do have a copy of the transcript here, though, if we want to look through the.
Okay, thank you.
And for the record, that transcript is part of the record. That has been incorporated by reference, Commissioner Stacks. Based on, I'm sorry, Commissioners, any other questions? All right, based on a lot of questions from the Commission, any follow-up from Council?
None for me.
All right, Mr. Daly, next witness.
Back to Mr. Loazo.
Yes, sir.
First of all, before you start, let me ask you a question that follows up one of Mr. Perkins' questions. Does it make any difference whether or not lithium's price is higher or lower than bromine?
No.
I'm not certain who you're asking that question of, Mr. Daly. There are three individuals up there. Who's?
I was asking Mr.
Oh, I'm sorry, sir.
Mr. Lazo.
Okay, can you answer that?
The answer was no.
Please.
That relationship between lithium and bromine has absolutely nothing to do with anything, does it?
No, the idea that looking at the individual value of all of the others and then saying, well, lithium is worth more. Instead, again, as we looked at that value or that worth more aspect of how lithium relates to potentially other things like salts or bromines or any other type of product, is one that's then represented by the actual market or price under which you assess a royalty. So the lithium specific value is directly represented in our royalty construct by the market price that is brought forward, and the others become irrelevant.
The higher the royalty, the higher the index on lithium, the greater the dollars of the royalty. Is that the answer?
That's correct. Were there to be a doubling in the lithium index market price, the mineral owner would be compensated twice over.
All right.
All right, hold on, Mr. Daly. Are you moving on to another witness?
No. Now I want to ask Mr. Lazo to provide some information about lithium royalties globally and in this country.
Well, let me ask, based on your line of questions from that witness, counsel, any questions? All right. All right, thank you. All right, next witness, Mr. Daly.
Mr. Lazo.
Okay, please proceed.
Please explain the benchmark data that the applicants have obtained.
And sir, would you be so kind as to spell your name?
So I'm going to start again.
I'm sorry.
We already have it, and then when I pass over to our additional witness following me, we'll provide that.
All right. I thought you had already passed over to the next witness.
That would be myself to begin. So I'm going to begin with a high-level overview of benchmarking, and then I will defer to my expert witness to the left here, Dr. Robert Urlagen, to go into specific analysis and opinions of the study.
I understood. Now I'm on the same page with you. All right, please proceed.
Thank you, Judge Moulton. So as mentioned previously, and as evident through the line of questioning, the question does arise when we look to the fair and equitable basis that this commission has established beforehand, which is the equivalent value of a substance when referenced to its end product values and in demonstrated through royalties. That is where the 1.82 comes from. It's this commission's view of how to look at that same equivalency I discussed beforehand. But it's important to recognize, just as many of the lines of query goes, is that appropriate for lithium? And how does that contextualize for lithium? So to contextualize that and to provide a reference and a review of lithium-specific benchmarking, we feel that that is a prudent context for the commission to have. I'd like to start by highlighting that around the world, there exist, as we highlighted, a variety of different development constructs, fiscal regimes, countries, products, projects, and other areas for the development and production of lithium that exists both today in producing established markets or non-market economies, as well as potential emerging economies and locations such as Arkansas and many other potential future competitors and locations. All of those have some aspect of unique construct. And so when attempting to review and look at those, one must provide some form of normalization and analysis methodology to bring in a level of equivalency or concept to that. What my colleague in a minute will cover is the details of a study associated with that, but I'd just like to highlight a few simple aspects of that study. The first is that they're the two largest established lithium producing economies, as we mentioned, Argentina and Australia. When considering what their royalty constructs and systems would look like on an LCE equivalent basis, and when looking across a large range of historical spot market pricing throughout the lithium markets and their median, Argentina's net effective royalty is a 1.7% royalty. Australia's net effective royalty is a 2.3% royalty. Chile has been highlighted in others as an outlier. Chile is a non-market economy in which access and participation is severely restricted, and the governments themselves and their entities participate and invest in the projects themselves. And China sits under a variety of similar types of complexities as a non-market economy and the way its investments in projects and royalty and fiscal systems are determined. Arkansas, and when we look to the 1.82 and recognize that new projects that develop this resource will always pay and compensate the mineral owner $65 per acre for the production of brine, and then subsequently an additional royalty of 1.82 for the extraction of lithium. I'd just like to provide the context that as an example of that, if one were to look at the SWA Greenfield potential PFS project, that is an equivalent of a 2.5% royalty in combination. And so you can see throughout those range of royalties of Arkansas, 1.82 to 2.5, which will change depending on ultimate acreage sizes. Arkansas and our proposed royalty construct sits well in line with producers such as Argentina and Australia, which provide the majority of established lithium markets production. Next slide, please. But it's important not to just look at a few. While those two are the predominant aspect of producers and development, both now and forecasted into the future, there are a variety of other jurisdictions that also exist. Whether those are established and actually producing locations such as Nevada, many provinces in Canada, Zimbabwe in Africa, other South American locations like Brazil, or as well many other emerging markets that are attempting to look at what development opportunities could look like in the consideration of a lithium industry and lithium production, such as the Czech Republic, California, other aspects of Canada like Ontario, Saskatchewan, Serbia. You can clearly see two things. One, there's a clear aggravation and focus of what fair and what exists looks like within industries today. And I'd like to highlight, upon our review of numerous of the objections and alternatives that have presented, where they fall within a relative condition of that. Next slide, please. So when you look to establish lithium producing markets, and as the EY study has summarized, and which my colleague will discuss here and further from his opinion, a couple of comments that are made that recognize that Argentina, Australia, Zimbabwe account for over 72% of major lithium developments since 2022 in established lithium producing markets. And as you can see, Arkansas positions itself within the relative range of those established areas. At this point in time, I'd like to hand it over to my colleague, Dr. Bobby Logan, to provide his expert testimony in further detail.
Let me see if council has any questions for you based on that presentation.
I do not. This next witness is literally a continuation of Mr. Loazo's, and I would suggest that when we're done, opposing counsel and the commissioners can ask questions to either or both of them. If that proceeds.
It just makes it a little bit messier. Let me just ask, do you have any questions at this point? We'll go ahead and go with your alternative, Mr. Daly, then. And when they do ask questions, if you could be specific in terms of the witness that you're directing them to, I'd appreciate it. And so would everybody.
Sure.
Included the court reporter, I know. All right, go ahead, Mr. Daly.
This is Mr. Robert Ialogan, and I have already gave it the correct spelling of his name to the court reporter, which she pointed out she never would have guessed.
I know it's appreciated, Mr. Daly.
Bob, please state your name and how you are employed.
Of course. My name is Robert Francis Ilagan, Ylagan.
And did you previously provide me with a summary of your credentials, which I've pre-filed or filed this morning, that is, as Exhibit I?
I have provided that.
If I haven't already done so, Judge Moulton, I suggest that Dr. Ialogan is, in fact, an expert in economics
previously recognized in another docket?
No, no,
Okay.
based on his resume presented today.
I don't have it in front of me, Mr. Daly, but I will take it with a grain of salt in order to
Well,
expedite it. that
I'd
he
be
has
happy
the
to provide
requisite-
you with another copy.
He has the requisite education and experience to be
Yeah.
qualified as an expert. So I will deem him an expert for this proceeding.
All right. Bob, if you will continue, Mr. Loazo's testimony with respect to the benchmark of global royalties and make reference to a study that from which much of the data came.
Thank you, Tom. I'm not going to provide you any new information. What I'm going to try to provide to you is the detail that underpin what Mr. Loazo provided. It is underpinned by a study that's done by Ernst & Young. We as ExxonMobil, as part of our natural due diligence process through business development, work with consultants and outside counsel and outside agents to effectively do benchmarking studies that allow us to understand what the market is, what's relevant, and what competition may look like, especially in competitive commodity markets, for example, within oil and gas, as well as other commodities. Okay. We routinely work with folks like EY, who I will refer to Ernst & Young as EY at this point. This is a recently published report. We had worked with them in full transparency previously, looking at broader lithium fiscal regimes. The information was somewhat compelling, and we encouraged them to publish it publicly. They worked on it specifically on their own, using their own internal resources and knowledge base, and then subsequently published this report. Okay.
And Bob, is the full study previously introduced as Exhibit G?
Yes, and in fact, what I'm going to show you now are some excerpts from that full study that you have a copy of in your exhibits. Okay, so you have a full copy of, it's approximately a 50-page document. So it is pretty extensive, but what we're going to try to do right now is kind of hit some highlights that underpin what Mr. Loazo had just presented in terms of appropriate benchmarking and the details behind such. Okay. Could I get the next slide, please? What EY did is a very nice little piece of work in which part of when we look at benchmarking, there has to be a little bit of a screening to get appropriate comparables. What they had done is taken existing producers of lithium, and as Mr. Loazo mentioned in the lithium overview, there's a variety of different ways of producing lithium and its derivatives. Could be mining, could be evaporation, could be direct lithium extraction. Those that are existing producers were already pulled into the analysis of, because they are existing businesses that are subjected to royalties. What was also looked at were emerging locations and emerging jurisdictions, but with that were the demonstration of additional investment was being moved forward. The second filter that was then looked at was the overall materiality and the endowment that was possible within that jurisdiction. And then subsequently, the third level was the availability of data. Okay, so by doing that, we've they have high graded the number of jurisdictions to look at. And in terms of that is somewhere in the order of, low double digits. Okay. What was also recognized was there's a variety of non-market jurisdictions, otherwise known as kind of nationalized jurisdictions. Mr. Loazo already mentioned Chile. China is another example of a nationalized institution where, for strategic reasons, things like lithium can be deemed as a strategic asset and specific controls be placed upon that business development. And in fact, in some cases, it restricts foreign direct investment, okay, or compromise as such, due to the nature of the controls that are placed on such strategic assets. If I can move to the next slide. The summary of this, the executive summary, and this would be page 5 of the broader report, but as I mentioned, I've provided you certain excerpts. This is the executive summary that EY provided. The salient points here are that in the yellow box, as has been mentioned, because of the nature of the different types of developments, mining versus evaporation, direct lithium extraction from brines, and likewise, because of the nature of the products that are produced out of those different technologies, there has to be some form of an adjustment to get some equilibration or common point, which we've determined as, we meaning the co-applicants, have felt that the technical grade lithium carbonate equivalent that we've been speaking to is that first liquid point of sale. And it's a commonality that exists between all the different developments that you can get to. That's the basis of the royalty comparison in terms of applying the different royalties and the way that they're applied or distributed given the different types of developments. So the royalties that we are quoting in this report, or not we, but Ernst & Young, that they're providing are effectively that technical grade lithium carbonate equivalent and the royalty that would be effective to that value, okay? In producing jurisdictions, the average of those jurisdictions, which we'll see some detail in a minute, is 2.1%. If you look at the weighted average of those, as we'll see, it's about 2.2%. So these are active producers that have ongoing operations, are subjected to an average of approximately 2.1% in terms of that royalty. In emerging jurisdictions in which production may or may not have occurred, but investment is moving forward, the average is about 2.6%, one of which is the Arkansas jurisdiction, using the 1.82%, okay? As we mentioned previously, the nationalized jurisdictions are really not applicable. What we're trying to do with this benchmarking is get the right comparables so that we can look at, and scrutinize the rates that are being applied and how well the proposed rate based on precedent actually feathers into that supply-demand balance that these other jurisdictions actually are a part of as well. The critical piece is, on an investment basis, the ability for Arkansas to compete, it would have to compete on that global supply basis. It would have to displace something that's already in the supply curve. Okay. Next slide. This is a slide from the EY study. I believe it's slide 15. But what it shows is a series of, on the left-hand side, we have the effective royalty rate based on the technical grade lithium carbonate equivalent, and the royalty rate that would be used against that. And on the left-hand side of the purple bars are the producers, active production of lithium derivatives. Okay, they're ranked by actual amounts of production into the supply curve. Okay, so Australia, for example, is a substantial supplier. It's on the far left. Manitoba, Canada is a relatively small supplier. It's on the far right of those purples. Okay, so that's the range of the producers. And you can see that the range there it varies. It goes less than 2.1% all the way down to 0.9 and 1.7 for Argentina, as Mr. Loazo mentioned. But it can be as high as, in Zimbabwe's case, as 3.3. So there is a range, admittedly. That said, the average, for context, is 2.1. When we look at the emerging in the pink bars as the next tranche, you can see that if you look at those bars, the average there is also in around 2.6%. Recall, these were screened out for a variety of reasons: materiality, investments moving forward, as well as some form of data availability. There are some that are high, 5%, for example, in Serbia and Croatia, or I'm sorry, and Utah. What we'll see there is those jurisdictions are smaller and less investment, if any, is moving forward. Okay, and you can see the investment there in terms of numbers of recent projects is also shown underneath the yellow text there that says ranked by number of notable projects. Okay. Likewise, we've already spoken about Chile and other emerging markets. Those are not terribly comparable due to the strategic nature and the level of nationalized control on those jurisdictions, and quite honestly, the ability to be an investment alternative. If we can move to the next slide. This is a busy page. This is page, I believe, 18. All this is trying to show is combine that analysis of the effective royalty rates based on technical grade lithium carbonate equivalent, and that the price that's being used in all of these is a 7-year average of the Fastmark data that Ms. Asanov already provided. So it's taking their data, average over the past seven years, which is the liquidity of their data, and using a $14,000 per ton basis. Okay, and that's the derivative of all of these rates. What we can see is Western Australia, Argentina, and Zimbabwe are the ones in which active, reasonable amount levels of investments are moving forward. The bars try to capture some level of price volatility, looking at what happens with a range of prices. But the critical piece here is that it's a function of the royalties, the effective royalties, and the resource quality that determines the level of investment that's moving forward and is present today. Western Australia, Argentina are key examples of that. Clearly, they have an endowment and a high level of resource quality, and they put royalties into a window that promotes investment. Okay. I'll stop there. My hope is that what I've tried to provide you is the details that reinforce the statements of Mr. Loazo. And the fact is that Arkansas, with the in lieu royalty, in addition to the proposed 1.82, at the price levels that we've normalized to, with a $14,000 per ton, comes up with about a 2.5% royalty, and that is very consistent with global benchmarks, both of producers as well as emerging jurisdictions where investment is moving forward, one of which is Arkansas.
Bob, were you present this morning when Mr. Perkins made an opening statement?
I was.
And did he show a slide with some numbers on it?
Are you referring to can you say more, please?
Yeah, is it possible to put that slide back up? That's a fair question. Is it possible to put that slide back up? I want the one that has the numbers, the 10%, the 20%,
Are you referring to the slide that had different royalty rates that were proposed by, which had, I think, 12.5% based on the previous Krauss study, 10% based off of the SWA, 20% based off of, 10% based off existing leases, and 20% based off of SWA, and then 6 to 40% based off of Chile. Is that the slide?
Hold on a second. So I don't know whether or not electronically we can switch from one PowerPoint to another.
There it is.
All right.
Well,
If you could hold on just for a minute, Mr. Daly.
all right.
Oops.
I think we went one too far, too.
I think it's the second to last one. That's it.
That one.
Yeah.
That's the one, right, Mr. Daly?
Yes. Please comment.
So when I looked at this, and I've read the expert testimony from, but it's been a little while, but what I do recall is both the 12.5% and the 20% are based off of project economics, or effectively a discounted cash flow model. And what those are referring to is the resilience to a certain level of profitability or return that an investor, in this example, SLI, would achieve. The issue that the issue that is not captured here is the uncertainty of a variety of different things within a project development. Okay. This is a single deterministic outlook that is being referenced in terms of what the returns could potentially look like. If I recall correctly, the base price, as an example, in these calculations that justified the 12.5 and 20 is 30,000 per ton. And I believe, as I mentioned just recently, the 7-year median based on Fast Market's own data for lithium carbonate equivalent is effectively 14,000. Less than half of what is presented in terms of a price basis for these two justifications. In addition, the current spot market price, as Grace mentioned, is even lower than the 14. So what this is not capturing is the uncertainty that exists because of a single deterministic basis. It's also not capturing technical uncertainty in terms of the deliverability of the subsurface to provide those levels of concentrations consistently. It's not capturing project execution risk, as well as cost, schedule, variety of different project management and execution risks are not captured with a single case. When they did look at sensitivities, typically they were at the high side values, looking at higher prices. In some cases, they did look at some lower prices at minus 20%. However, most of the cases looked at growing prices from 30,000 and upward, and yet current prices and median prices are at about 14,000. So when I look at these numbers, I pause, quite honestly, because I don't think they capture from one single economic case the appropriate level of uncertainty that exists in a very new market. Okay, these are new technologies. These are challenging. These are, commercialization issues can become problematic. But I think, based on the presence of these co-applicants, there is potential for profitable business development here, and that's why we're all here.
In your opinion, can Saltworks and the other co-applicant commercially extract lithium, profitably extract lithium?
I think to answer that in full is to say that it will depend, just as we've shown, it will depend on the technical and the commercial criteria that is available. So if the technical quality is high and the commercial costs are lower, it will certainly lend to a much more higher likelihood of a profitable outcome.
Do you anticipate that Saltworth Works and the other co-applicants will ultimately extract lithium at a profit?
I think that's the reason we're all here. There is a business
Dependent upon the royalty.
There is a business opportunity. We have to get the right commercial framework, the right legal framework, the right contractual frameworks in place to enable that level of investment. These are substantial investments. These are risky investments, and they should be priced accordingly.
Anything else? Pass the witness.
Am I right to ask the question and pass the witness to Mr. Perkins, since they addressed him directly, and then follow up after that, if that's okay, Judge?
Thank you, Mr. Hickey. Mr. Stovall, any questions? All right, Mr. Perkins. And if you could be so kind as to identify who you were directing your questions to.
I will definitely do that, Your Honor.
Thank you, sir. Please proceed.
I'm going to start in reverse order, and I have some questions for Dr. Ilagan. Did I say that correctly?
Well done.
Thank you.
Thank you.
First of all, you showed the chart with emerging jurisdictions, and you had Arkansas there. You assumed 1.82%, which is sort of a self-fulfilling prophecy, right? I mean, you're saying, well, that's our number from Arkansas because that's what we assume it is, even though we don't know. And then you're using that to predict that that's what it ought to be.
I will say, okay, this is a bit of my own admission is I said it's really Ernst & Young.
But you're here testifying about it, right?
I am testifying to their report and the data within their report that underpins Mr. Loazo's testimony.
And what's your expertise in, Dr. Ilagan?
I have a PhD in geology. For the past 25 years, I've been in the commercial side. I've been a subject matter expert for the company in both in economics as well as fiscal analysis, and I'm currently the subject matter expert for all of commercial.
Okay, so I mean, you are nevertheless the witness they've put forth to present this information. In the chart for Arkansas, then there was a sort of a blank dashed line and had 2.5% at the top, and I saw 2.5% in a number of places on Mr. I'm just going to say Remy. I'm sorry, Mr. Remy's analysis as well. So where does that 2.5% come from? I think I know, but I want you to say it.
Absolutely. It's on a greenfield project for lithium. What would be required would be the in lieu royalty payment, in addition to whatever additional substances payment would be subject to. So that would be the 1.82 plus the in lieu royalty at a specific price, because you have to do it at a specific price because that's a fixed amount as $1 per acre.
Okay, that's what I thought. But okay. You understand, don't you, that the in lieu of royalty relates to bromine, it has nothing to do with lithium.
It has to do with brine, if I'm not mistaken. So any extracted brine.
Okay, but we're talking about lithium today. I mean, the lithium royalty rate you're proposing is 1.82%, but you're presenting it as if it's really 2.5.
That would be the amount that goes to the royalty owner, if I'm not mistaken.
So, I mean, they're entitled to be paid for bromine. What the statute says they're entitled to be paid for bromine. It's irrelevant when we're talking about the lithium royalty rate that we're here to try to establish today, correct?
The interpretation of statute is not my subject matter expertise. I defer to law. and our lawyers and our attorneys to make that interpretation.
Gotcha. Okay, are you prepared did you come armed with a project economic projections for Exxon's proposed units?
No.
Okay, you took pot shots at our use of the standard lithium feasibility studies, but you understand that's the only economic information that anyone has provided to us, and the 5 applicants here today didn't provide any. You understand that?
If that is the case, then yes.
And the $30,000 assumption on the lithium value was determined by Standard Lithium, not us. You understand that, don't you?
That is an assumption of a value in a deterministic case that it was presented to the public.
And
whether or not that represents reality or a forecast is not my area of expertise. And that is actually Standard Lithium's kind of question to probably answer.
Precisely, but you were saying that it was really inappropriate to look at that because it assumes a $30,000 value for lithium. First of all, we don't know what the lithium value is going to be tomorrow or next year or 20 or 30 years from now, do we?
Excellent point. Just like today, it's 14,000 or 12,000. Probably not representative of the 30 that's there. That is a publicly available data point. It is a representation of what an economic outcome is. That's all it is. But I'm not sure it characterizes what I would say a full project analysis.
And to your knowledge, no one has provided you with a full project analysis for any of the projects.
I'm not at liberty to say that because I'm not in the lithium business within ExxonMobil. I am employed as a subject matter expert here with an expertise in fiscal and economic analysis.
With regard to the hearing here today, the issue we're here in front of this commission, asking them to make a decision, are you aware of any project-specific economic information that is intended to be produced to this commission so that they can make a decision about a specific project?
I'm not sure I understand the question.
Okay, I'll try one more time. Do you have any project-specific economic forecasts for any of the clients that are here today and the applicants?
We will not, I know for, go ahead.
I need to clarify the question and perhaps object because he asked 2 different questions. The first time he asked, do you have any to present today? The second time he asked, does it exist? If I understand it, that's 2 different questions. Which is the question?
All right, well, let's ask them both. First, do they exist?
That I object to. And the reason why I object is well documented in the record of the pretrial conference hearing. On advice of counsel, we are told that if we were to reveal unpublished internal documents of any of the co-applicants, we would very likely be violating federal antitrust laws. And for that reason, on advice of antitrust counsel, I'm instructing the witnesses not to answer. Now, if the question is, did you bring any with you? He can certainly answer that.
Well, first, the question was, do they exist? I did not ask you to reveal it, Mr. Daly. I just want to know, does it exist?
I agree. I'm going to over your objection. That's apples and oranges to what we were discussing in the pre-hearing. Can you answer that question, sir? Does it exist?
I'll defer to to Mr. Loazo as the business line representative.
Mr. Lazo, can you answer that question?
Yes.
That's what I figured the answer was going to be. Mr. Perkins?
Now, the second question, is anyone going to present any such project-specific economic information here today at this hearing for any of the 5 applicants?
We do not intend to disclose any proprietary, confidential, or commercially sensitive information for this process.
All right. I guess I'm going to go back to Mr. Ilagan. He may not know the answer to this, and then we'll pivot if we need to. How much did Exxon pay for the galvanic lease acreage in South Arkansas?
Again, I'll echo my response. We're not going to discuss any proprietary, confidential, or commercially sensitive information.
So that's not public information?
No, it is not.
Okay. Well, that's all I have for Mr. Ilagan. He doesn't know very much to answer questions. So I have a couple of questions for Remy. Remy, I apologize. I just don't want to butcher your name. I'm not trying to be.
It's Loiseau.
Critical minerals production in the U.S. is an important national security issue. Would you agree with that?
I'm not going to make speculations around political considerations.
Okay. Do you believe, based on your knowledge in the industry, that a domestic source of lithium would be valued more highly than a source from China or Australia or Argentina?
I would defer to things like markets and indices to evaluate how various things are valued in various locations.
How many of the projects, this is for either one of you, that you ran all your data from, involve direct lithium extraction from underground brine?
From deep brine resources, there are no existing deep brine lithium projects today.
So every single project that you have used up here from around the world, none of them are like what we're talking about in South Arkansas.
They all lead to the ultimate products and potential views of markets for which lithium is utilized. As I mentioned in my earlier testimony, lithium occurs in a variety of different resources in its natural form, whether that be in ocean waters, brines, hard rocks. So every one of these projects contains lithium in one of those forms.
You both indicated that the example from Chile where Albemarle was paying a sliding scale of 6.8% to 40% royalty, you both predictably said that's an outlier. It's a government regulated industry in Chile, and I understand that. But do you think Albemarle entered into that contract to go broke?
I'm not going to speculate on any of their company's investment decisions.
Is it your understanding that in business, most companies enter into contracts that they believe they will make money from?
That is certainly the intent, but as we've highlighted, there are a variety of areas of uncertainty in any business, and that is the risk-reward equation and determination that any company must individually consider as far as its investment potential.
Absolutely. Pass the witness.
Mr. Hickey?
Thank you, Judge. Good afternoon. Y'all are entertaining our questions, and we appreciate that. I've got several that I'm going to try to parse through and work through here. I guess my first question for y'all is, okay, good. This table's up on the slideshow here. Are either of you aware that the mineral estate in every single one of these countries of the United States is owned by the Crown in old nomenclature or by the government?
Who are you directing that question to, Mr. Hickey? I'm sorry.
Okay, so we'll start with Dr. Robb. Are you aware of that?
The EY study will show in the backup as to who is the owner. In many cases, it is the government. In very few cases, is it a private ownership.
Mr. Loiseau, are you aware that all of these countries listed up here on this screen right here, that the state government owns the mineral estate and not private landowners?
I'm aware that that is true for the majority and represents where the lithium industry and the development of resources exist in the global supply today.
Okay. I have a follow-up for Mr. Loiseau first. Are any of the exercise taxes that have been stacked on top of these royalties that go into the same pocket of these governments included in these royalty rates?
No, EY's study focused on the royalty paid for the mineral to the mineral owners.
Are you aware that oftentimes exercise taxes are also stacked on top of that after the mineral has been extracted?
Every fiscal regime, when you consider the totality of it, whether it's both the royalty constructs, potential taxes, and others, has a variety of different levers that exist, yes.
Okay. Okay. Well, I'm glad that you got back up, and Mr. Loiseau, and testified a little bit more about this LCE. And I've got some follow-up questions on that. I don't know if it would be beneficial to have your original slideshow up right now, but I'm going to try to follow this and correct me if I'm wrong. Okay, so you previously discussed that 0.04% of a barrel of brine contains lithium. Is that accurate?
As an average approximation for a representation of a Smackover barrel, that's correct.
And how is that calculated?
That is based off the molecular weight contributions of the various products.
Okay. How is the 18.8% of the LCE that the lithium is in calculated? Is that by volume? Is that by value?
Again, that is by the contribution of the molecular weight of that product, of that element or that compound into the overarching compound.
So it's by value, is that correct? Or volume, I'm sorry.
It's by mass.
It's by mass. Thank you, sir. Okay, so the other 81.2% of the substances in the LCE, are there market values for that?
Not for all of them in their various forms.
Are there values for some of those?
Given that they need to be acquired in some instances or created in others, sometimes yes, sometimes no.
Have your groups or the co-applicants prepared a survey of those market values of the additional substances inside this LCE?
As I mentioned in my earlier testimony, when looking at an overarching specialty product, when you're trying to consider value, as I believe you're attempting to do here, it is not just the value of the components within it. It is also all of the additional things that it takes to create that product, whether it's the costs of various technologies and processing and equipment, whether it's the value and know-how and capabilities that an organization represents and brings to the table, whether it's the market access and other considerations that come to intellectual property. All of those come into consideration in developing specialty products. Simplistically, what you represent with the LCE is, as we highlighted, when trying to understand a mineral and its proportionate share of an ultimate product, that is what LCE represents.
Well, I'm glad you talked about some of these other costs that go into this. The co-applicants have continually argued that they come to Arkansas because of the legal framework. But have you seen anywhere in the world the infrastructure that we have in South Arkansas to recycle this brine and pull it up out of the ground, recycle it to the plants, and then put it back into the injection wells?
If you're referring to the existing brine production fields, yes, there are brine production fields all over the world.
What I'm asking is, have you seen an infrastructure with the pipeline systems that we have today to recycle across a field the size that we have?
I'm not sure what your question is.
Okay, let me rephrase. Is there anywhere in the United States or even the world, and I think I know the answer to this because you said there's no deep brine operations in play right now, but have you ever seen, or has any of the co-applicants ever seen, the amount of infrastructure that is already in place as the co-applicants are stepping in to produce this lithium?
So I'll speak specifically for Saltworks. The projects that we're considering and in the locations we're considering, no such infrastructure exists today.
Thank you. Let's see here. How are y'all, I think you touched on this a little bit, but how exactly are you calculating this 1.82%? And there's kind of a follow-up with that. You know, earlier y'all stated, okay, 1.82%, and that's based off of the SALT project. But then we saw a survey here that the average based off of this Ernst & Young study is 2.1 or 2.6% on average. So why aren't y'all offering up to pay 2.1 or 2.6%?
I think it's important when considering things and the concept of fair and equitability that we're here in front of a commission to determine that factor. So in the absence of an implicit interpretation by ourselves, we defer to the commission's own analysis and definition of fair and equitable, whether that be through the statutes that exist with Arkansas and the existing constructs within it, or as well their prior decisions and orders to such effect.
Okay, so let's go back to the 1.82%. And I suppose that was earlier testimony stated that that was based off of the average value per net brine acre. And but I think we all know that's based on the value of the bromine at the time. That's why y'all use that comparison. Have y'all done that same calculation today? And if so, what's the result?
Again, you're proceeding beyond portions of my own related testimony in this line of query, but on the slide, I have a good memory and I can reflect that the 2023 year end, I believe, was 1.64.
So what is the average value per net brine acre today?
I don't have that answer in front of me today.
Do you know how that would be calculated? How would one calculate the average value per net brine mineral acre?
Value associated with what?
With what, I'm sorry?
That was the question. Your question is incomplete. You just asked her.
Oh, so it must have cut off. I said, how would one calculate the average value of the brine per net brine mineral acre?
There are a variety of different methodologies to utilize that. What prior testimony has highlighted is one of those methodologies.
So I guess this is my last line of questions. So it appears that you all are adding the 1.82% together with the in lieu of royalty to arrive at the 2.5%. Is that correct?
Again, as my colleague testified, we are not doing that. This is part of an independent study that has assessed what compensation must be provided to a royalty mineral owner for the production of lithium. And since in Arkansas, that requires both the payment of a brine royalty as well as an additional substances royalty for any production of lithium projects, they've represented the two scenarios and the ranges that could represent.
So I think from what I understand, it would be fair to state that really what you all are offering is a 1.82% on the lithium carbonate equivalent. And then it appears to me that in conjunction with that, you've added the brine net brine royalty in lieu of royalty to that to arrive at this 2.5%. Is that right?
The study that EY has prepared implicitly looks at the total compensation to a mineral owner under a variety of scenarios in Arkansas from a proposed construct.
Okay. So under that scenario, if we arrived at this 1.82% and then we'd called it a 2.5%, essentially we no longer have a royalty for bromine. Isn't that correct?
Again, I'll leave it to my counsel to interpret Arkansas statute, but my understanding is that the $65 per acre is paid for brine production independent of any extraction.
Thank you, sir.
Thank you, Mr. Hickey. Staley, any follow-up?
Not on this subject.
All right.
I have more questions for Mr. Loiseau to complete our presentation, but
all right. I know, so you have Mr. Card next. Are you moving on to a different topic or?
I think we're just going to let Mr. Loazo give the very short testimony and save that time.
All right, before you do that, based on all that questioning, commissioners, do you have any questions for either of these witnesses? Commissioner Wolford?
I'm going to address this to Mr. Yerlogan. I get it? Great. Did you take a look? I'm going to distinguish between the term that you used, developed. Is it related to lithium extraction, to how we commonly use developed when we think of developed nations? Does that distinction make sense?
I think so.
Yeah. So in their study, did you take a look at within developed nations what the average royalty was? And so I'd be, thinking Australia, Canada, nations such as that.
To my knowledge of the EY study is the extent of what they've looked at is the producers versus emerging. Within those groups, the OECD, for example, if we want to call it a developed country, can be determined. But I don't believe within the EY study that was explicitly done. It would be an additional overlay.
But so we could just take the numbers that exist there and average those if we were of a mind to then.
And as I mentioned, the screening that was done for producers was simply if production is occurring based on their data, they were brought into the fold of analysis. On the emerging side, there were some other criteria that were established: materiality, investability, or current investments, as well as data availability.
Follow-up question to some of the discussion earlier relating to the in lieu of royalty. We're dealing with several different groups of royalty owners. Some are already receiving that royalty. Saltworks is still, their royalty owners have yet to receive the in lieu of and the lithium royalty. So we have two different distinct groups. So why would it make sense to add those together since one group is already receiving it?
I'm not going to interpret statute and how that's applied. I'll leave that to a legal interpretation as well as potentially a commission interpretation.
Okay, thank you.
Thank you.
Any other commissioners? Commissioner Thomas?
Looking at the list of countries and states that are producing lithium or potentially could do so, it seems to me that Arkansas is a desirable location to produce lithium. And before we pass on, Doctor, you've given a lot of impressive empirical data. Was any calculation given to the fact that Arkansas has a more desirable regulatory structure and the fact that in order to get a royalty set, you only have to come to the Oil and Gas Commission?
I'm sorry. You want to answer that? I'm going to defer to our business line representative, if that's okay.
So as I mentioned in actually my opening, it is Arkansas's regulations and establishment of its regulatory precedent, as well as existing framework, that certainly creates an opportunity for attention or focus, as well as the resource potential that's highlighted, whether that's from recent USGS studies or other areas that exist there. So it's that vein, as you highlight, that does create an opportunity for focus or consideration within an investment analysis.
But you wouldn't have a specific number to apply to that.
No, and that's why we are here today. As we evaluate the opportunity for potential developments and projects, it's clear to us that lithium can be profitably extracted. We understand a variety of things around resources, project developments, markets, and other areas which we've talked about throughout today. And that question has no doubt in our mind. But whether or not, it can attract investment is an entirely different discussion and point. And so what we're here to do today is to recognize that while it can be attraction, without knowledge and understanding of the fiscal framework or the royalty system simplistically, the ability to consider for investment or progress further work, whether that be engineering, project development, infrastructure development, drilling of wells, or other areas beyond a level at which has already been considered to date, would likely not proceed.
Well, the reason that I've brought that up now, and it may not be proper, but to the applicants and to your counsel, before this hearing is over, there are some questions that I have that Mr. Perkins alluded to in his opening statement. This body is always interested in highest and best terms. And the reason that we are is the data that is presented here, although very extensive and technical, is not unlike the data that we receive in an integration or unitization. It's just that those things are more familiar to us because of our course of business. And I noticed, Mr. Daly, in your motion to quash the subject about out-of-state royalty. And the reason, and I don't know if that's appropriate or not, that's for y'all to decide. But as a commissioner, the only thing I have to ensure is that someone in Columbia County, Arkansas, is being equally compensated to someone in Bowie or Cass County, Texas, or in Miller County, Arkansas. It's irrelevant. So I want us to be prepared to address that. That's why we're trying to establish whether or not this state offers a benefit that may not be present in another state. I hope I've been clear on that. Thank you for your great answer.
Remy. So
Yes,
just
sir.
from a curiosity standpoint, it costs $600,000+ to move the rig 10 times from y'all's statement.
I'm assuming that's an
Yeah.
approximation on your behalf.
Well, I mean, okay. So anyway, that's what we were told. And you drill 10 wells with the mindset we're going to plug 8 of them after we test the porosity and perm of them wells. Can you tell me, at the extreme expense of doing that, why would you have the mine preset to plug 8 of them before you ever drilled them, knowing you were going to plug them and just test the porosity and perm? If you were serious about developing this acreage, if you saw what you wanted, why wouldn't you set pipe through the intermediate, have it behind pipe, and hold your lease?
All right, I'm going to try to read into your question and help me if I help answer it. I believe what you're asking is, one, why would we make investments even up front and the lack of uncertainty of a significant magnitude? And two, in an appraisal type program, what might be an execution philosophy consideration within that versus development? And I think those are two distinct differentiations. In early project development of any type, and from my experience across industry and a variety of areas, including oil and gas, resource uncertainty is a big focus. And so when you look to the existing data sets, yes, there are existing data sets and some of them right here, but an important aspect of any project development is characterizing and understanding the subsurface uncertainty and the opportunity that allows you to afford potential optimizations of development plans. And this commission's role, and ours as a prudent developer, is to ensure, the best resource development potential possible. And so to us, data is valuable to help afford that opportunity. And prior to having that data, the ability to optimize, to put wells in the correct location, to deal with the production injection interactions, right? would be either risky or unknown. And so an appraisal program to that effect helps support that evaluation so that in a development phase, potentially in the future, wells may be positioned in the most optimal location for project development.
Okay, so I'm not gonna let y'all hook that easy. So you drill a well and you collect the data and it's what you want to see. And it's in your lease and you're planning on moving forward. Why would you not complete that well? Or run the long string in it
There's a
to produce
significant
it?
incremental cost to completing a well.
I mean, just running the, I mean, I understand contrary to what was said earlier, I understand the people up here that are in the industry, we count our money different. Y'all do. I mean, I understand you have the money to do what you want to do, but that just troubled me. Not a wasteful guy. And it was, I didn't understand that. And I still don't. From an economic standpoint, if you saw what you liked, it was so much more economical to you, the shareholders, royalty owners, everybody, to go ahead and set pipe.
So I would disagree with that interpretation. There's a variety of factors that goes into an ultimate economic decision of how a total development plan, well beyond just the well and its completion. So in accessing and determining things for the value of data, that is the focus of an appraisal plan and subsequent development opportunities, and the optimizations and with the value opportunity of that is entirely different. And that's how we, in the prudence of our business and experience, develop projects.
So okay, that's all I'm gonna get. I got you.
My counsel has advised me that I should probably offer you an additional even context to those wells as well. Those wells are not optimized for development production, even in their base design, whether that be sizing, again, whether exactly they're completed, what you're accessing. So there's just even another development consideration. We're focused on achieving value, data and information to subsequently support that. And the wells are optimized from their design just around that factor.
So they would just drill for it.
Can we go ahead and go off the record for 10 minutes? All right. Oh, you're just standing? Oh, I thought you were running, Commissioner. Apologize. I thought you were giving me the high sign there. I'm sorry, sir.
We're happy to.
All right, Commissioner Phillips, you had a follow-up question?
So all right. So you're saying you didn't, from the start, you didn't drill the wellbore diameter big enough to run what you would need to run to produce
for the majority of wells, and until you understand the resource that you find down there, and again, to optimize that, that was not a planned perspective.
Okay. Thank you.
Question? All right, any other commissioners? Based on the line of questions from the commission, any follow-up from council? All right, we are going to take a 10-minute break. We're going to go ahead and go off the record. We will be back in at 3:10. We are off the record. All right, folks, could you please take your seats? All right, we're back on the record. Mr. Daly, you were in the middle of your presentation, your next witness.
Mr. Loazo again.
Yes, sir.
Let's get back to the slide that we need to be on. And
Next slide. Next slide, please.
there we go. All right. Mr. Loazo, the one thing we haven't covered in this part of the presentation is how that royalty will be divided among the various owners. Can you explain that with reference to the requirements of the Bryan Act?
Yes, I can. So if you could go to the next slide. So the final part of the formula certainly recognizes that there are numerous mineral owners that would contribute to an ultimate production of lithium and development of which. And so to be consistent with statute and the development of brine and how it is allocated, and thereby the mineral that is extracted from that brine, like lithium, we propose to do a similar per acre allocation to be in common standing with statute and how payments are made today. An example is provided there simply to help highlight that when there are a variety of owners in an example producing area or unit as discussed, that allocation will be based off of their overall acreage's contribution to the total development and payments made proportionally from the totality of a development back to each individual mineral owner.
So this is an example based on a hypothetical 33,000 acre unit.
That's correct. So just to provide the simple math and awareness of folks, in an example such as a 33,000 acre unit, which is an approximation for many types of developing areas for large scale brine fields, as I mentioned beforehand, an owner that has 1 acre, in a sense, contributes 0.003% of the overall royalty allocation. An owner that might have 100 acres would be entitled to 0.3% of the overall allocation.
In other words, you take the net mineral acreage of each owner and divide it by the total acres in the unit.
That's correct, in the unit of producing area.
With any luck, that you total those numbers and you get 100%.
That will be math, yes.
Yes. All right. Proceed, if you will, with wrapping up your testimony.
So if we could proceed to the next slide. And the next slide. One more slide, please. Thank you. So I just want to provide some illustrative examples for consideration that help provide a range of scenarios or opportunities that may exist in the development of brine fields for the purposes of lithium extraction as an additional substance. As we've highlighted today, there are a variety of factors in our overarching equation, whether that be quantity and its representation of the resource and its quality and production and volumes, price and the representation of markets and valuation, and allocation, which we just discussed, a net mineral owner's percentage within that ultimate development and production and associated brine and lithium contribution. So these examples provide just a simplistic view of a variety of scenarios based off a range of potential projects and resources represented in 2 cases. Whether those are potentially higher quality resources, like a 26,400 ton per year example project, like the SWA project that has been discussed here before. Or the Links of South project is another example of just another lower quality mineral resource consideration where project development might consider something in the range of 5,400 tons per year of ultimate lithium carbonate equivalent development. What's that? Let me bring it a little closer. Is that good? Maybe my voice is just getting a little hoarser at the end of the day. So the two market scenarios there at the time of our application just represented the lows and highs across the fast market index over the past 2 years, just to provide, again, a view of different pricing scenarios and opportunities that exist for mineral owners' participation with the direct market connection, as well as a representation of the range of uncertainties and other scenarios that exist. And as we talked about earlier, how that's been applied to some of the other analyses that's been done when looking at those summaries. The 1.82% royalty rate is applied. The mineral owner allocation is applied. I've provided 2 examples here on the right-hand side for these various scenarios. One is just to provide an approximation for a mineral owner that may have more than 1 acre, a standard quarter section of 160 acres, and what that might equate to from an annual payment in these variety of scenarios. The second right-handmost column, to help provide context for any mineral owner on their known acreage basis of mineral rights, equates that to the dollars per acre that would be paid on a royalty equivalency on an annual basis. It's worth noting that these numbers are the additional lithium royalty that would be paid in addition to the brine royalty of $65 an acre that is required by statute for the production of any brine. So the takeaways are simplistically to offer a view of exactly what we've tried to listen to mineral owners and their requests and determinations in a variety of scenarios. One, that the quantities and the quality of their resource be directly proportional to the royalties that are ultimately paid. Simplistic to say, better quality resource, higher volumes of production would directly equate to increased royalties for a mineral owner. As well, with the direct connection to markets, as we've discussed, should markets and the variety of potential lithium products, as represented by a lithium carbonate, increase in value, mineral owners will receive a direct proportionate increase in their overall resource and their royalty payments. And finally, as I said, the allocation, the mineral owner will directly receive the allocation contribution based off of their production and participation or acreage contributed or mineral acreage contributed in an overall development.
Pass the witness.
I think I've got one more slide to wrap it up, and then
Sorry.
So I would just want to bring it back to a summary of everything that we've discussed today, whether by myself or a variety of other witnesses and testimonials brought on here. We're here today to establish the basis for a fair and equitable royalty compensation. And I've highlighted the many challenges that exist within that, but also the many considerations that have been taken into consideration by our proposals. We brought that forward. And so you see the formula again, and as I highlighted, each of its elements we discussed in isolation, but it is the totality of that construct what considers and brings together the overarching proposal and our view of a fair and equitable royalty. On the fair side, it is transparent. It clearly highlights exactly the minerals that will be produced and the products made from it and their overall quantity and contribution into a royalty payment. It is broadly applicable and consistently broadly applicable when considering the value of lithium as an additional substance and the ability for any mineral owner who has lithium producing from within their areas to have a consistent basis for the royalty payments for the extraction of lithium. It is market dynamic. It connects mineral owners to the upside potentials and the downside risks associated with market development on a proportionate basis. It's reasonable within a range of global benchmarking. You've seen a variety of examples and scenarios of those. And as we said, our proposal focuses on its base value on being consistent with Arkansas statutes and prior AOGC orders, but to be fair, requires a reasonableness check, and that is what we've completed. On the equitable side, being consistent with Arkansas statutes and AOGC orders provides equitability for a variety of minerals and resource development scenarios, whether that be lithium or others as well, and how they're considered. It clearly differentiates between the difference between a substance and specialty product values. And though the formula itself provides value from a specialty products construct on both its markets and its products produced, it balances the contributions and risk borne and the value additions brought by developers in addition to the value brought by the mineral and the substance. It is my belief that this offers and meets the intent and definition of Arkansas statutes for fair and equitable royalty and consideration for the extraction of additional substances from brine, and in this instance, lithium. Thank you for your time today.
Thank you, Mr. Daly. Do you pass? Pass the witness? Yes. All right, Mr. Hickey?
Yes, sir. I have a few questions. Thank you. Can we backtrack 2 slides, please? 3 slides, sorry. Yeah, okay. So, I had your name written down earlier. Luazu, Mr. Luazu, how do you define the production area or the unit?
Those would. Mike, thank you. So those, as I've highlighted, are either producing areas as recognized by this commission or units as recognized by this commission. And we've provided information of those within the application.
Okay, could you fast forward to that last slide, please? Okay. Do you think it's reasonable to describe this as fair because it's transparent when the commission has not been provided the information to make a decision as to whether or not any royalty paid would be fair?
We provided a proposal just as highlighted here, and the transparency of that proposal and all of its elements and the information consideration and how it would be provided, I believe is very fair.
I know we've gone over this several times, but all of the cost data has not been provided to the commission, correct?
That is correct. We have not provided proprietary, confidential, or competitively sensitive information.
Mr. Daly may have an issue with this one, but I'm going to go ahead and ask it. Reasonable within the range of the global benchmarking. What about the local municipalities? What about the smack over formation as well? Is it reasonable? Is it a reasonable rate within this formation?
It's our view that yes, and that is the basis of our proposal.
Where's the evidence of that?
My objection is I don't understand what he's talking about.
The third bullet point next to fair. Reasonable within the range of global benchmarking.
Yeah.
So my question is, let's bring this back home a little bit. Is it reasonable within the geological formation of the Smackover Brine Formation? And I believe your witness, I don't want to speak for you. Will you answer that question again?
Your question is merely speculative, and I'm not sure I understand what you're asking.
What I am asking is it your client's position that this is a reasonable rate based off of the Smackover Formation?
If you're asking if we view that our proposal is reasonable and thereby fair, yes.
No, sir. What I'm asking you is whether or not the percentage basis that you all have proposed here today is reasonable within the Smackover Lime Formation.
So as this proposal would be applicable to resource development or potential developments in the Smackover Formation as an example, then yes, I believe that it is fair and reasonable for that development, and that's why we have proposed it.
Have you provided evidence as to whether or not it's within any type of range within the Smackover Lime Formation?
You're asking me about a geologic formation. Mm-hmm. So the relevance of that and the connection does not make any sense, sir.
Oh, really? Because I thought the original application lined up royalty rates based off of the formation in these 4 counties, the reference counties.
The application simply referenced where lithium presided within the variety of potential leases and development resource that exist in Arkansas.
Okay, let's move on. Consistent with the Arkansas statutes and AOGC orders. Is it truly consistent? Do you believe that it's consistent with the statutes?
I do.
Okay. What about the statute that requires that you all start profitably extracting this and show your numbers to the commission. And then the commission should sit down and net that back, describe that it's, determine that it's been profitably extracted. And then based off of that information, determine what is fair and equitable. What about that?
Statute doesn't.
I'm not going to answer legal interpretation questions, but the statute asks, can lithium be profitably extracted? And as I've made testimony before, it is our view that lithium can be profitably extracted and royalties will be paid when that happens.
So let's finish that off a little bit. It says that determination will be based off of the cost netted against the value of that additional substance at the time, correct?
I'd require that you read the specific statute and the section of relevance.
We've done this earlier today. I can do it again. Whether or not any substance is extracted profitably shall be determined by the commission on the basis of the value at the time of extraction without interest after deducting all cost of producing and recovering the same.
That is a correct quote from the statute.
Yes, sir, it is. So is that consistent with the statute? What you all are asking?
I'm going to object. He's trying to get a legal interpretation of the statute out of a lay witness. If you'd like for me to answer the question, I'll be happy to answer the question.
Also, Mr. Hickey, I think you've asked it, even of this witness, a few times. I understand you're not getting the answer that you want, but
Judge, he has it on a bullet point up here that's consistent with the statute. I mean,
his testimony is it is. That you're not going to change that, I don't think, Mr. Hickey.
Okay. No further questions. Thank you, Judge.
Thank you, Mr. Hickey. Mr. Perkins.
Yes, thank you. Can we go maybe one slide forward, I think? Yes. So I see here you have listed higher quality and high price, et cetera, lower quality and high price. What is your metric of quality?
The metric of quality here relates to the overall quantity and acreage required to produce a lithium product.
Okay, I didn't follow you. It's the overall acreage, did you say?
That's correct.
So what constitutes high quality?
A development that has the opportunity to produce increased levels of lithium and ultimate products.
You're kind of fading out there, sir. Sorry. Did you repeat that again?
I said a project that has the opportunity to produce increased levels and quantities of lithium on a per acre basis.
Okay, so you're not referring to the content of lithium in the brine in a particular project versus another.
That is represented within the quantity that is ultimately produced.
But that would be another metric of quality of the project, right?
That is another representation of the ultimate lithium that exists within a brine. Yes.
Would you agree, Mr. Loiseau, that the economics underlying the determination of a fair and equitable royalty will vary from one brine producing unit to another?
No, I do not.
Are you aware that's what the application said for Standard Lithium last year that was signed by Mr. Honey?
I am aware of prior applications, yes.
So you just disagree with it?
I'm not here to speculate or comment on other people's.
No, you're here to testify for Saltworks, as I understand it. So I'm asking you as the representative of Saltworks, do you think that every brine unit is equally profitable as another?
I think the value of the resource within it and those units is directly equivalent to the value of the resource that is ultimately contributed into that development.
Mr. Honey goes on and says each brine producing unit has its own unique characteristics and should be considered on its own merits without this application in order being treated as precedent. But I suppose you disagree with that too.
I would require broader context for that.
Okay. Saltworks doesn't have any units. correct?
We are a participant in the Evergreen unit.
Okay. Granted, that's, you are a participant in that unit. So the 33,000 acres or so, or I don't, strike the acreage because I'm not sure how much it is. The large area where Exxon has been, I'm sorry, Saltworks has been most active in leasing and has a controlling interest outside the Evergreen unit that you entered into with Tetra. All of that is ununitized area, is that correct?
That's correct at this time.
And in the, I think it's Exhibit F7 that Mr. Daly added to the application after Judge Moulton issued his opinion, you've just listed pages and pages of sections. Is that correct?
We've identified sections in which we hold leases.
And I have a couple of questions about that. First of all, how did you notify the unleased mineral owners in those sections?
We've notified all of those through which we've asked for this determination, which is those that hold leases for us.
I'm sorry, I couldn't hear you. Did you?
I said we've notified all of our lessors.
All of your lessors. So all of those people who own minerals in all of those sections, some 400,000 or so acres altogether, who are not leased, didn't receive any notice of this proceeding today, at least not from you.
Not from us directly, no.
Well, I think that's a problem. And we've talked about Albemarle. Albemarle has a long history, as the commission has observed, and I'm respecting your approach to that. But all of this ununitized, newly leased area by Saltworks, where there's no unit and never has been a unit, I don't see how that can be included in this application, given the interpretation of the statute that you've adopted from Judge Moulton.
So our request here is to set a fair and equitable basis for the extraction of medicinal substances for those areas as we've identified. A unit application would take into the other considerations that you bring forward at that point in time.
I understand. I understand what you want to do. That's all I have.
Ms. Pilkington? Mr. Daly, any follow-up?
I think, subject to rebuttal, we're finished.
All right. Since you rest, let's take care of a couple of other housekeeping matters. In terms of the objection and the objection letters that have been sent, my understanding is they are continuing to filter in even today. Ms. Pilkington, would you be so kind as to sort of give me a thumbnail sketch and the commission about how many objections that we are certain we've received? And I need to go ahead and incorporate those into the record by reference, but just give the commission a heads up on where we're at with letters.
It's coincidental.
And before you get into that, I believe I skipped over the commission this last section. So we'll just back off for a second. I know that Mr. Daly rested, and I think that was my clue to kind of move on. But commissioners, do you have any questions based on the very last part of the presentation? Commissioner Wolford?
So
as to the allocation percentages in existing units, a royalty owner, or will a royalty owner see any change in their decimal as to an existing unit?
Into their proportionate allocation percentage?
Correct.
No, there would be no change. It would be
Okay.
consistent with Brian.
This is a question, I think, for Mr. Daly. When we deal with Strohacker, the 1955 date covers brine at that point. So all subsequently decided minerals are covered under that Strohacker definition of brine.
There is one case of the Arkansas Court of Appeals which so indicates. It was not appealed to the Supreme Court, so I suppose there is this remote possibility. But I can tell you that since literally since the 1960s, the brine industry has developed on the assumption that a reservation or conveyance of minerals generically only included brine if it was post 1955. And if you read the historical papers like Bill Wynn's, he tells you exactly the date that they found it.
Yeah, something like June 1st of 1955 or
Yeah.
something like that.
Yeah, and I think we've gone back to January 1 for convenience. But yeah, I'm very confident. Nothing in Arkansas law is absolutely certain until the Arkansas Supreme Court so says. And I suppose that court could then change their mind later. But I think that there's a lot of confidence in that date. And let me also say that that's something altogether different in Texas. In Texas, there is great uncertainty, if you read their papers, as to whether brine belongs to the mineral owner or to the surface owner. A lot of confusion going on down there that we don't have here.
And the reason for my question was that a mineral owner is an existing mineral royalty owner in an existing unit would not expect any change due to Strohacker either. So even if there was even due to the fact that this is another extracted substance.
Absolutely right. And that's what happened in the West unit while the salt plant was in operation. They just simply got a second check.
Okay. Thank you. Any other commissioners? Mr. Chairman?
Remy, do you not have any financial numbers to give to us so we can make a judgment call on this or a call?
It depends on your definition of financial numbers, Jerry.
Just put yourself in our shoes. We have nothing to go on right now except some of y'all's testimony and slides. No real physical numbers have been given to us.
So I believe, as one of the commissioners says, a significant amount of information and context has been provided, including a significant amount of analysis of benchmarking and other relevant aspects. And it's my view that those offer a more appropriate basis when considering mineral rights versus the profitability and business of entire value chains and specialty chemical products, which do not have directly anything to do with the mineral itself.
I got another question for you then. But do y'all have a test pilot plant?
We've run a variety of tests and opportunities in this area. Yes.
How did you come up with the 18% of the tonnage?
That's that stoichiometric chemical conversion that's consistent in all of chemistry.
Have you run it on the Arkansas?
So that would be consistent for any brine, any resource, and any basis.
Thank you, sir.
Any other Commissioner Phillips?
Hello. Oh, so when
you drill the wells, don't smile. When you drill the wells, was the data that you received, I know y'all have some new technology to test the porosity in the perm and the water, bring samples without casing the well through that zone. Is that correct?
We have a variety of technologies and data collection methodologies that we've applied.
So we're not asking you any money numbers, but was you completely satisfied with what you saw?
I would say that our overall appraisal program confirmed a variety of assumptions and considerations within a reasonable range as we were considering for our evaluations.
All right. So, and I know that you studied the whole Smackover formation across from East Texas all the way through Arkansas and Louisiana. Is that a fair statement?
Certainly our teams and our specialists and geologists and other areas have a.
So you're familiar and have a general understanding.
I'm familiar,
Right.
generally familiar.
Where is the sweet spot?
There are a variety of those, as you
Which
know.
state?
There's not sufficient data to make.
Who has the highest permeability and porosity that you've seen? You've looked at 3 states. Who's got the highest perm and porosity and will give you the most fluid?
That would require an extensive data analysis that I don't know off the top of my head.
In your opinion?
Again,
have
a geologic opinion would not be something I'm an expert on.
So is it safe to say that the South Arkansas region does have some of the higher porosity and perm of the stuff that you've looked at?
I think there's a wide range of that across all of Arkansas and across all a variety of states. As a carbonate, I'm sure you're very familiar that there's a lot of diversity within those types of resources, and that diversity represents itself across the state and across the formation.
All right, so I couldn't hear you talking too fast and getting away from the mic, but is the South Arkansas, the Columbia County, Union County, Miller County, any of them concentrations better? The porosity, the perm, the thickness, the concentrate than East Texas?
So from publicly available data that's been presented, I think that would be a better question for those that have represented that publicly available data, such as Standard Lithium, on data from those sets.
Okay.
To maybe your question to concentrations, concentration specifically, there are significantly higher concentrations that have been found within Texas.
Do you have any operation or any desire, anything going on in the East Texas part? Are you strictly looking at Arkansas right now, currently?
As I've highlighted in my introduction, ExxonMobil is a large corporation that has a variety of.
But you would know if y'all were pursuing.
That's correct.
I mean, come on, you would know that.
Yes, we have a variety of opportunities that we are always exploring and pursuing in the development of our businesses.
Yeah. So I know you're a big company, but you're in a specific department. So do y'all have anything on the table pursuing anything in Texas or Louisiana, or are you just concentrating on Arkansas right now?
So as I mentioned, we're a large company and we have a variety of exploratory opportunities, but discussing anything further about that would be considered confidential or proprietary information.
Even just that y'all have anything. So do you have any royalty set in Texas?
Again, discussing the
That's public information.
So
if you have royalty set in Texas, that's public. That's not proprietary.
Saltworks does not currently hold any leases in Texas.
That was sorry. Okay. So it just seems safe to say that this is kind of where you want to be or need to be, or we wouldn't be here, basically.
I think that's a correct interpretation. As I mentioned at the beginning, Arkansas is a current area of focus. That's why we're here today. We have a wide variety of areas of focus and a broad business and as a large company. But it is both the resource and the regulatory precedents and frameworks that have created the current focus for Arkansas.
Okay. Any other commissioners? Commissioner Thomas?
To the applicant's counsel, or maybe to Mr. Card with Albemarle briefly, having not been around at the time that the statute was adopted, both. If hypothetically, if a mineral owner owned all the minerals in a 40-acre tract, and by analysis, they identified 4 feet of porosity on 40 acres, be 160. If their neighbor, by analysis, had 40 net feet of porosity, that'd be 1,600 net acre feet. Is there any part of the statute that makes allowance for the track factor?
No, it doesn't. And specifically, it dictates that distribution within a unit be on a surface acre basis. That is the statute.
Thank you. Thank you very much. I wanted to put that on the record.
Any other commissioners? If not, follow up from council based on the line of questions from the commission. Anyone? Mr. Perkins, you have one or two?
Yes, I have a couple questions. First, I'm sorry for this, but I'm wondering if we could try to go back early in the presentation when Mr. Loasso was talking about the 18.8% of the value of lithium carbonate, the lithium in the lithium carbonate. And there were some mathematical computations there because the commissioner, I think Chairman Langley asked about that. That's it. So I understand that. And the 18.8% that you show in lithium carbonate for the content of lithium, that's simply based on the atomic weight comparison, correct?
That's correct.
And so you have in lithium carbonate, what you have two lithium atoms, 1 carbon atom, 3 oxygen atoms, correct?
That's correct.
And the atomic weight isn't in any units. It's simply it's a reference point for comparative mass of different atoms and molecules. Is that accurate?
It provides a mass comparison, as you highlighted.
Yes. So it doesn't have anything to do with the value of those within that compound. For example, you wouldn't say that the 1 carbon atom in lithium carbonate is comparable in value to the lithium, or the oxygen would be comparable to lithium in terms of value. Do you agree with that?
Merely highlight what portion of an ultimate product is represented by the lithium.
Well, you are highlighting that, but then you multiply it to say equivalent royalty, 9.68% lithium. So you're using that relationship to create the impression that somehow your 1.82% is really 9.68%, and we should all be really happy with that. And my point is the relative atomic weights of the atoms in lithium carbonate have nothing to do with value. Is that correct?
What they highlight is the contribution of that sustenance to the ultimate products and its buildup and makeup.
And so it has no direct relationship to the value of lithium, though, correct?
You're going to need to be more specific in your question.
I don't know how to be more specific. So the fact that it has 18.8% of the molecular weight in a molecule of lithium carbonate doesn't mean that it's 18.8% of the value of lithium carbonate.
What we're showing here is just an equivalency. It's an illustrative example, as you highlight, to understand the difference between a royalty and a rate of equivalency of whether it were applied on a product or whether it were applied on the substance within that product and its contribution.
And you can't make lithium carbonate without lithium, right?
That's correct.
And you're not buying leases to mine carbon or oxygen, are you?
That is correct, that the other constituents of lithium carbonate did not come from the brine itself here.
That's all I have. Oh, wait, no, that's not all I have. Another question on, was it? Well, I'm sorry. That's all I have, I guess, because I can't remember what I had.
I've been there myself.
Yeah, here it is. So
Okay.
I'd like to, if we could have the cooperation of our audio-visual people, I would like to put up a map from our presentation that I want to ask Mr. Loiseau about. There we go. And zoom in on that multi-state. There you go. So there was a question, and I apologize now, I forget who was asking about the sweet spot.
That was Commissioner Phillips, I believe.
Thank you. Commissioner Phillips, you asked a question about the sweet spot, and I'm following up on that with Mr. Loiseau. I assume, Mr. Loiseau, you have seen and reviewed carefully the recent U.S. Geological Survey article that this slide comes from, where they studied the lithium content in the brine and the Smackover. Would that be correct?
I'm generally familiar with its high-level summaries.
And if you look at this map, assuming it's accurate, it's not anything I created, U.S. Geological Survey and our state geologist, Scott Osbrooks, was part of that study. Would you agree with me that there appears to be a concentration of high content lithium in that Southwest Arkansas area that we're here today to talk about?
Yes, from the data points represented, that's what it would show.
Thank you. I pass the witness.
Mr. Hickey?
Yes, sir. I'd like to follow up on Commissioner Phillips' line of questioning with regard to East Texas leasing. So is it correct that you stated that SWA does not have royalty rates set via leases in East Texas?
I represent Saltworks.
Oh, okay. Saltworks. Is that what you just testified to?
I said it does not currently hold.
Okay. What about your affiliated entities with your parents?
So as I've mentioned, there are a variety of things that we view as relevant, confidential, proprietary, and competitive sensitive information, and I'm not going to disclose those here.
Okay, well, you opened up the door when Commissioner Phillips asked that, and you said that you did not have any leases over in East Texas. So I'm just wondering if you can state that there are leases held by your affiliates or your parent.
I'm here to represent Saltworks as part of this application, and that's what I'm speaking to.
Okay, I think I asked the question.
Thank you, Mr. Hickey. All right, follow up, Mr. Daly, Mr. Honey. Ms. Clegg, I've been ignoring you all day. Anything that you would like to add before I believe you're ready to rest? All right, Ms. Daly, are you ready to rest? Do you rest? Subject to rebuttal, correct? All right. Ms. Pipkinton, we were getting into the objection letters where I cut you off because I leapfrogged ahead of the commission. So.
Can you hear me?
Yes, we can.
All right.
All right. How many do we have, sir?
Right now on the website, we just looked at it while we went to this other part, approximately 114 written objections on our website right now. We received more this morning that are not on the website that we provided the court reporter. We can give you a more accurate number in the morning if you would like.
All right. Well, we'll go ahead and get an accurate number, but just for belt and suspenders, I'm going to go ahead and make certain that all of those objection letters are part of the record. And if they're filtering in throughout the day and even the day tomorrow, before I shut the evidentiary part of the record to a close, they'll be included as part of the record, whatever written objections do we receive, or even written support, whatever the letters are for and against.
For clarification, I think some of these are duplicates. We've not gone through that. And some of these letters are in support of the application, some are objections.
Correct. Okay. So whatever the context of the letters are, whether they are support or against, they'll be included in the record.
Thank you.
All right, thank you. Mr. Perkins, Mr. Hickey, who goes first? I know you don't have any witnesses, do you, Mr. Hickey?
No, sir, I do not.
Okay. Well, I'm going to focus in on Mr. Perkins then. Mr. Perkins, are your witnesses available?
I believe they are.
Are you ready to proceed, or do you need a minute or two to gather yourself?
It would be greatly helpful to have 5 minutes if we could, just to organize and things, and then we'll need to introduce exhibits.
All right. How much time do you need?
5 minutes.
5 minutes? All right. We'll go ahead and go off the record for 5 minutes. Give Mr. Perkins an opportunity to get everything situated, and then we'll come back on the record and get started with his presentation. We are off the record. All right, Commissioners, you ready to proceed? Folks, can you resume your seats, please? All right, we're back on the record. Mr. Perkins, are you ready?
I'm ready, Your Honor.
All right, please proceed.
Thank you. First, I'd like to begin with the introduction of exhibits. We didn't do that at the beginning for the South Arkansas Minerals Association. Attached to the application were the following: Exhibit A, which was a composite exhibit with multiple lease forms, 1, 2, 3, 4, 5 brine lease forms from Folsom Point Energy with a 10% lithium royalty rate. Exhibit B is a standard lithium pre-feasibility study for Southwest Arkansas project dated September 18, 2023. Exhibit C was a standard lithium valuation model sensitivity analysis table that was attached to the application as well. And then we have, also within the application, we made the request to incorporate by reference all applications, exhibits, and testimony in docket number 083-2023-10. You may have already done that. I don't recall, but just for safety, I'm mentioning it.
I think I did, but again, just to make certain, that docket is incorporated by reference.
And then there are a few additional exhibits that have been provided to each of the commissioners and the court reporter and opposing counsel. Those include the carbon credits article that was on the big screen in our opening statement, a lease example, oil, gas, and brine sourced minerals lease prepared by Gulf Atlantic Resources LLC. A lease example, two lease examples. These are mining leases from Texas, from the state of Texas for brine production. The first is mining lease M-119170 for West Texas Brine Research LLC. And the second is mining lease M-120526 for Encore Permian Development LLC. Next, we have the Tetra Technologies Inc. Form 10K from 2023. A consent order, no, I'm sorry, not introducing that. An excerpt from the SEC technical report summary for Albemarle Corporation pre-feasibility study for Chile from Form 10K 2021 that was referenced in the opening statement. Would ask that all those exhibits be admitted to the record.
Motion is granted. Those exhibits are made part of the record. Mr. Perkins, does the court reporter have copies of all?
Yes.
Okay, thank you.
All right. I'm going to begin with witness Robert Reynolds and would ask that he be sworn.
You swear affirm the testimony about to give in this hearing is going to be the truth, the whole truth, and nothing but the truth?
I do.
Thank you, sir.
Mr. Reynolds, we'll have to swap the microphone back and forth here. But would you just state your name for the record, tell the commissioners what you do for a living, what your experience and background is. We'll start with that.
Okay. My name is Robert Reynolds. I'm a resident of El Dorado. I am a oil and gas well drilling engineer. I've worked here 45 years. My credentials have been accepted by the Arkansas Oil and Gas Commission in order number 070A-2009-01. I am a professional engineer, Arkansas license number 15179. I'm a certified petroleum engineer by the Society of Petroleum Engineers, number 3297473. My work in the last 45 years has been engineering and management, contract drilling and well operations in what is referred to as the Upper Gulf Coast province, geological province, Tertiary, Cretaceous, and Jurassic, found in South Arkansas, North Louisiana, Northeast Texas, and in the Black Warrior Basin Paleozoic of Northeast Mississippi and Northwest Alabama. I have tallied 2,096 oil, gas, saltwater disposal, water flood, brine supply, brine disposal, and industrial wells. I've been involved with the well design and economics, supervision of drilling, completion, and well operations, permitting of wells and regulatory compliance, supervision of coring and drill stem testing, electric well log analysis and casing point evaluation, water flood design and implementation, field-wide development and unitization project management, supervision of workovers, recompletions, and stimulations, deviation control drilling, directional drilling, and horizontal drilling, and drilling under hydrogen sulfide conditions.
Thank you, Mr. Reynolds. Tell the commission how you're associated with the South Arkansas Minerals Association, what that association's, what their goal is, what their purpose is, and how it came to be, if you can do that.
Certainly. I joined the association when it was formed back in 2017. I was not the founder. I simply joined because I have minerals. My wife has minerals. Our children has minerals. My family has been in Union County for 192 years, 4 years prior to statehood. And I have cousins in this room. Our common ancestors were born over 200 years ago. I hope that we stay here another 192 years. Look forward to that. But I do have a deep and abiding interest in private property and in the property that all people acquire as private citizens. Anyway, how did I become the president of South Arkansas Minerals? The founder became ill and last year called me and asked me if I would serve in that capacity. And he had previously arranged for a unanimous approval of the members. So I've been drafted.
Thank you, Rob. We're going to go through some leases first. There were 5 brine leases from Folsom Point Energy that were attached to the application. Have you had an opportunity to review those?
Yes, sir. I have reviewed them.
And how did we come to be in possession of those?
Well, there was not intentional publicity, but people who I had met over the years called me and said, we'd like to talk to you about this. We've got something here new. We've never heard of this. I want to know what's going on. And then there's other people who were involved in the founding of our company years ago. They also called us. They're interested. What's going on here? And those some mineral owners who were solicited for the leases would gladly send us a copy. Some of them would say, well, redact my name. I don't want to be involved in any controversy, and that's okay. So we can do that too. But we try to answer questions that mineral owners have.
Can you summarize for the commissioners with regard to lithium royalty, what the Folsom Point Energy leases that were attached to the application provide for?
Yes, sir. Folsom Point Energy leases that I have read offered a royalty of 10% of revenue with no deductions, or the royalty rate established by the Arkansas Oil and Gas Commission, whichever number was greater.
Thank you. Let's see, Christina, can you hand me the Gulf Atlantic Resources lease? Yes. So we're in the process of people providing leases to us. Did you come on possession of this lease form prepared by Gulf Atlantic Resources LLC that's for lands just across the border in Texas?
Yes, sir, I did. In the case of Gulf Atlantic Resources LLC, their lease was two parts. They correctly recognized that there's a difference between oil and gas minerals and brine minerals in Arkansas, and they put two separate parts to their lease. The oil royalty is 1/4 in very much the conventional manner of oil royalties. And the brine royalty, however, is expressed as a fraction, 1/10. However, that 1/10 has what I would consider substantial deductions. And those deductions include such things without limitation: flow line, pipeline, rail spur connection, all gathering and transportation costs, all extraction, filtration, separation, dehydration, processing, manufacturing, acid or gas plant processing costs, initial and recurring sorbent costs, costs associated with compression and of the reinjection of tail brine back into the reservoir, plant operational overhead and depreciation, and or any other expense incurred or determined or deemed reasonably necessary to process, refine, and market said refined and marketable brine sourced minerals.
So this lease form, based on the correspondence that came with it to the Bohuslavs, indicated that this company was leasing for ExxonMobil. Is that correct?
Yes, sir.
So in their application, the counsel for the Big Five have made a big deal out of saying we could never base a lease on proceeds less all the deductions, because if we did that, in order to account to those royalty owners, we would have to divulge all sorts of trade secret information. But this royalty provision that came from Exxon, in fact, is based on 1/10 of the proceeds derived from the sale, first of all. Is that correct?
Yes, sir.
And then, as you read, the unbelievably exhaustive list of deductions would require that they would have to account for those as well. Is that right?
That's correct.
All right, thank you. Let's see. Let's look at the two Texas mining leases. Do you have us first M119170, a lease from the state of Texas to the West Texas Brine Research LLC?
Yes, sir.
Have you reviewed that lease?
I have. That was interesting. The state of Texas, as you may know, has vast lands that we don't have similar setup in Arkansas. But the state of Texas, when they made this particular lease to a company called West Texas Brine Research LLC, told them 10% royalty of the market value at the mine. They then gave a brief definition of market value at the mine, but not less than 6.25% of the value of minerals produced.
And the second example, mining lease, M120526 for Encore Permian Development LLC. Is it similar?
Yes, sir. Best I can tell, the terms are identical. 10% royalty, market value at the mine, but in no case less than 6.25.
And even though the title on this indicates that it's a mining lease, the content of the lease itself makes clear that it is for the production of subterranean brine for the extraction of its constituents. Is that accurate?
Yes, sir, it is.
You have the SEC report there.
Okay.
Next, I want to direct your attention to a Form 10K that was filed by Tetra Technologies in 2023. Do you have that available?
Yes, sir.
And this particular SEC report, you have it highlighted? Well, anyway.
Yeah.
And this is just an excerpt of it, but there's a section on page 27 called bromine and lithium resources. Is that correct?
Yes, sir.
And did this report disclose their transaction with Standard Lithium whereby they were contractually going to transfer their interests that's known as the SWA project to Standard Lithium?
Yes, sir. Tetra Technologies incorporated in this filing Form 10K with the United States Securities and Exchange Commission said that Tetra would be receiving a 2.5% overriding royalty from Standard Lithium Limited.
And is that overriding royalty with or without cost deductions?
I did not detect any deductions. It was the cost based on gross lithium revenues.
You reviewed the two feasibility reports that have been introduced into evidence, one last December and again by reference today, and then the additional one on the SWA project, both from Standard Lithium. Is that right?
Yes, sir.
And there were several points made earlier today about the fact that in their analysis, they assumed a base case value of lithium carbonate equivalents at $30,000 a ton. Is that right?
That was the basis of those calculations of those reports. Yes, sir.
To your knowledge, has Standard Lithium published any sort of retraction or amendment or correction of those reports that were filed with the Canadian Securities Agency?
No, sir.
And finally, I have a question for you about this article. It's a press release from Standard Lithium. Are you familiar with that?
Yes, sir.
What is the significance, in your opinion, of this particular report that talks about their arrangement between Arkansas Lithium and Lanxess with regard to the South Unit project?
This is a February 2022 press release by Standard Lithium, who is the parent company of Arkansas Lithium, that they had made a commercial arrangement with Lanxess, where the pilot plant is located at Lanxess South Unit here near El Dorado. And in this contract, Standard Lithium gives Lanxess the right to acquire some or all of the lithium carbonate takeoff produced at the commercial plant at a price of market minus up to 20% to be agreed by Lanxess and Standard Lithium, and taking into consideration several key commercial agreements. That sounds like a 20% discount to me. Product.
Right. You have seen sorry, Commissioner Walford wants to ask a question, so we're going to let him do that.
Sure.
Have the Folsom lease, is it in one of the other packages?
The Folsom leases were attached to our application, so you should have that.
Buried somewhere in the package?
Yes. I'm sorry, our objection. Old habits die hard.
And then the second thing, it was the Standard Lithium piece also in the original objection that you just testified to?
No, that's one we just handed out to you, Commissioner.
Okay.
It looks like this has a big
Got it. Okay.
headline on it. It's a press release from Standard Lithium.
Got it. Thank you.
So you saw in my opening the benchmarks that we believe are better guides for the commission to go by. Those would be the 12.5% royalty that was recommended by Eric Kraus, the expert economist, in the hearing last year. The 10% rate, the highest and best being offered in the area so far as we know. And then the third being, what was the third one? Hang on. The 20% royalty based on the sensitivity analysis that we provided with our objection to in this proceeding based on the SWA project economics for Standard Lithium. And then although I have to admit, I don't think it's that relevant, but they did. So we included the 6.8 to 40% sliding scale that Albemarle's actually paying in royalties in Chile. Are you in agreement that those are better benchmarks than the information that has nothing to do with any of the units as presented by the applicants today?
Yes, sir.
Pass the witness.
Mr. Honey, Mr. Daly, Mr. Honey. Please proceed.
It'll be me, Judge. Good afternoon, Mr. Reynolds. I guess let's start with the only Arkansas leases, the 5 Folsom Point brine leases. I remember in when we were doing the Fayetteville Shale, we had some integration proceedings where a party who was being integrated didn't like the terms they were being offered, the highest and best terms. And so they executed a lease to themselves for a high royalty and then tried to insist that the royalty they created by leasing to themselves was the highest and best royalty, and that should be the integration terms. And the commission, and I think Mr. Perkins may have been the one who fought that battle and won, said, no, these, we're not going to consider an outlier lease as establishing the highest and best terms. We're looking for, I don't know what the correct word would be, but we're not going to let an unusual lease drive the bus. Do you remember that from the Fayetteville sale proceedings?
I do not remember that episode, no, sir.
Yeah. Well, I guess where I'm headed with that is, these 5 Folsom Point leases, are these, we don't know at this point whether they're just outliers and they're taken by somebody who doesn't understand and doesn't realize that they'll never get anywhere with a 10% lease and won't have anybody to sell them to ultimately, and they'll get integrated and have to either release the lease or eat the difference, or whether that's actually indicative of some kind of market price. We just don't know, do we?
Mr. Honey, I don't know what you don't know.
I agree. That's my only point.
Before we move on, I'd like to respond to that because he really misstated the application, and I was the attorney for Southwestern Energy on that. It was and the Killam and Hurd families were unhappy with the royalty rates being offered. They leased it. They leased their minerals to themselves for 25%. And then they went non-consent and said, you have to pay our royalty. And the commission, under the rules, was able to say that was unreasonable. That's not what the Folsom Point leases are. There's no evidence or information that would indicate they are in fact the mineral owners leasing to themselves.
Gentlemen, you're arguing with one another at this point, and this is an examination of Mr. Reynolds. So, Mr. Honey, do you have questions?
Judge, you're aware of the fact that, for example, the Lanxess South, Central, and West units, those are all leased. You're aware of that? And
Yes, sir.
Yeah. And you're aware of the fact that those leases say that the royalty on additional substances will be whatever the Oil and Gas Commission says the royalty will be.
I don't know about the historical Michigan Chemical, Great Lakes Chemical Corporation, Chemtura Corporation, the modern day brine unit expansion leases, when requested by mineral owner, will have language to that effect. Any additional minerals, or in some cases specifically lithium, will be the royalty established by the Oil and Gas Commission. I've seen those leases.
Yeah. Well, I guess my point is, Mr. Commissioner Thomas was asking for highest and best lease terms, but the reality is in Arkansas, there is no such thing because the leases say, with very rare exceptions, all say the royalty will be whatever the commission says it is. So there aren't any highest and best terms to be found.
That's to be determined.
Okay. I just was provided with the Texas leases right before we got back on the record. I don't know where they are located. Have you made an effort to determine where these leases are located and to what extent they even have a chance of ever being developed?
West Central Texas, I'm not familiar with the prospect there.
I don't think there's anything else I want to ask you. Thank you very much, Mr. Reynolds.
Thank you, Mr. Honey. Mr. Perkins?
Just a short follow-up on the Texas leases. Can you tell the commission how many acres those comprise?
Yes, sir. It was a surprisingly large block, 2 blocks of acreage. One was 19,080 acres. And the other 4,160 acres.
Thank you.
Mr. Honey?
Hello, young Mr. Daly just was doing a little looking on those Texas leases. He's indicating to me that the counties that are recited, Cass and Culberson County, are in far west Texas. Not even, pardon me? Or Reeves and Culberson are in far west Texas, all the way out towards El Paso, and they're not in the Smackover. Were you aware of that?
No, sir.
No further questions.
Mr. Perkins? Commissioners, any questions?
Thanks, man.
Director has a question.
Thank you. Looking at the Folsom lease and reading through that, where it talks about the 10%. It talks about 10% lithium, lithium compounds, calcium chloride, sodium chloride, magnesium chloride, or other chemical constituent of the brine is extracted from the brine. Is lithium chloride produced from the brine?
Okay, go.
Lithium chloride would be the material that is extracted from the brine.
So that would be the lithium compound that's referred to in the lease. Is lithium carbonate extracted from the brine?
No, sir.
So the 10% would only apply to those constituents in the brine, not what you make from the brine.
I'm sorry, I didn't understand the question.
The 10% royalty would only pertain to those constituents you extract from the brine, not what you make with those constituents after production.
I don't know that I would explain it that way. This is what the Folsom Point Energy lease says. Lessor shall be entitled to a 10% royalty, which shall be due to the lessor on the commercial extraction and sales of the extracted minerals, calculated as the percentage of the amount the lessee receives as fair and reasonable proceeds from the sale to a bona fide third party in an arm's length transaction for the gross production and extraction of the minerals, whether or not the point of sale is on or off the leased premises, at the well, at the point the mineral is processed in a plant for the extraction of minerals and made into a marketable product. The lessee shall be deemed not to own the plant.
Director, did you get your question answered?
Yes.
All right. Any other commissioners? Commissioner Wolford, I thought I saw your hand up at one point.
Mr. Reynolds. Yeah, Mr. Reynolds.
Yes.
You were here earlier as as Big Five, as it's been referred to by your table, presented their royalty. One of the aspects that Mr. Perkins brought up was the use of the atomic weight. as an indicator of an effective royalty rate. Do you have an opinion as to that as an appropriate metric?
No, sir, it's not an appropriate metric. I believe 18.8%. Mr. Perkins, do you have my notes on that?
1 second.
On white ruled paper. The wrong sheet right there. Mr. Walter, while Mr. Perkins is looking for that little note, I'm going to refer to the periodic table of the elements. There's a concept called atomic weight. Back in the old days, they now refer to it as atomic mass to represent the relative mass or weight of one element compared to another. And in the case of lithium, the basis is hydrogen. Back in the old days, they made hydrogen as the standard of 1.0. In the modern day, with all the electron business, we have discovered that hydrogen is actually 1.0079. The atomic weight or mass of lithium is 6.941. The atomic weight of carbon is 12.011. And the atomic weight of oxygen is 15.9994. I remember as a kid, it was just simply 16, but that's close enough. But we've seen today a slide and an assertion that the value of lithium as 18.8% of the value of a lithium carbonate is based on the atomic weight of lithium as a portion of the atomic weight of lithium carbonate. I believe that is not correct. Lithium carbonate is composed of 2 lithium atoms, 1 carbon atom, and 3 oxygen atoms. Doing the math on that, 2 lithium atoms with an atomic weight of 6.941 gives us 13.882. 1 carbon atom, 12.011. Oxygen, 3 of them at 15.9994 gives us 49.9982. The total atomic mass of lithium carbonate is 73.8912. Percentage-wise, lithium is 18.8% of the atomic mass, carbon is 16.3% of the atomic mass, and oxygen is 65% of the atomic mass of lithium carbonate. In my opinion, the value of lithium in lithium carbonate is not accurately represented by the atomic weight of lithium as a percentage of the atomic weight of lithium carbonate. To me, it would be kind of like having a bag or a bottle or whatever, and in there we've got a little dab of lithium, and we've got a peanut, and we've got an orange. They all have different mass, but they have vastly different respective values. And that's what we have used. Stoichiometric measures that don't represent value. And then to convert that, to divide the 1.82% proposed royalty by the decimal 0.188 for the 18% of lithium and call that 9 or 10% royalty on lithium is not correct.
As we refer to the leases, have you done an analysis of the different potential deductions that can be made on each lease and how that might, or is there any way to make that analysis?
Happily, most of the leases that I have seen in Arkansas do not have what I consider to be unreasonable deductions. I know y'all have been exposed to unreasonable productions, especially in the Fayetteville Shale area. And I'm aware of that, and but it has not been an issue. One issue that I am concerned about in many of the leases that I see in Arkansas is that lessee may use lessor's fresh water. In fact, many of them say unlimited fresh water, except for water from lessor's well. And some homes have domestic wells and some are served by rural water associations and don't have them anymore. I was concerned about those terms that have nothing to do with bonus or rental or royalty or what products are produced. When I see that, I know that proper attention has not been paid to the freshwater resource, nor to the ownership of that freshwater resource. I think that's more associated with the surface owner. It's not something for the mineral owner, if those are severed minerals, to grant to the lessee.
As you weigh the various leases that have been presented today, as was noted earlier, we have ownership in wells out in Reeves County, so it's kind of the heart of the more recent Permian play, and I'm just not aware of the smackover being existent out there. And perhaps there are other formations that they're looking at that do have a lithium concentration that they have found in the interim. However, are there leases that you give more weight to because of their proximity and so forth?
Well, the Texas lease with the 10% with a bunch of deductions, including, in my opinion, what would be a double dip. They have capital construction costs and list depreciation as one of the deductions. Depreciation is a creation of the federal and state income tax codes, which allow you over time to expense capital equipment, and deducting that amount from royalty proceeds would, well, you've already deducted the capital layout in the first place. And depreciation itself is a non-cash expenditure for purposes of calculating one's federal income tax liability. It has nothing to do with the cost of operation or the revenue. It's an artificial creation of the tax code.
Yeah, I think just trying to head to a closing point. Your application or your objection states that you desire the application to be denied. And would you provide just kind of your basis for the denial of the application?
Sure. So, as I think we've explained in a number of places, but we believe, and we sincerely believe, that the statute intends for the setting of a royalty on additional substances to be on a specific unit by unit basis. just like the Arkansas Lithium and Lanxess application that you saw last year, where they come in, they present actual economic information about the project that is specific to that project. And at that time, we all agreed on that. Even their counsel said every project is different. And that is why we don't believe that a one-size-fits-all royalty rate is appropriate. But, this commission has determined various different information about unitized areas hundreds and hundreds of times during its existence. It's never been based on, some benchmark from other countries. It's tell us about this project, provide some financial information that will give us the knowledge that we need in order to determine what is fair and reasonable. We did our best to do that based on the information we had on the two standard lithium projects. And they want to say, oh, those studies are no good, but they haven't provided anything else. And it's particularly emphasized in the areas where, for example, Saltworks owns thousands of acres of leases, and there's interspersed with other leaseholds and unleased acreage, and they want you to set the royalty for those sections. We don't even know if there'll ever be a brine unit in those locations. And for sure, we don't know anything about the economics because they've absolutely refused to give you any of that information. That's the reason we've asked for it to be denied, because we don't think they've provided the information. I mean, you yourself, Commissioner Walford, at the end of the hearing in December, with all the information we did have on the feasibility analysis for that project, didn't believe that the commission should go forward to make a decision because there was one document that had been discussed that apparently had some economic terms to it between Arkansas Lithium and Lanxess. And without that, you didn't feel that you could make that decision. And we're light years from that today. They are saying, we're not going to give you any information about any of these units. And still, we want you to set this royalty because we really need it.
The royalty as proposed?
Is what based on?
Is your objection also related on the?
Sure. I mean, we believe that that's completely unfair and unequitable because the information that we do have indicates that these projects will be quite profitable. And Arkansas is the best place to do them. We have the regulatory process. We have the sweet spot, I believe, of lithium concentrations. But instead of providing the economics, which perhaps wouldn't look good for them. I mean, they went through that whole process last year, and then when it came down to disclosing that one document, they just withdrew their application.
Any other commissioners? Commissioner Stacks?
Mr. Reynolds, just a couple of things. Going back to the Folsom Point energy lease that you mentioned. I know Mr. Honey spoke to it a little, but you're not aware of whether that entity would be affiliated or relating to any of the applicants or any other operator.
No, so they're not affiliated with these landowners.
Okay. The other question, you stated that was 10% royalty with no deduction. Do you believe that how that language is written, that requires or would require the end market product for 10% to be paid of that?
I think it would be, this is my opinion, is the first marketable product. And then I know that I'm aware of other uses of lithium far beyond what we've seen illustrated here today. It's a very useful material in special alloys, in corrosion resistance, oxygen scavenging in steel and copper. And that's a whole nother thing. But lithium carbonate equivalent, as Fast Markets explained. That's the first thing they can get a handle on, and they know what the price is.
And so do you believe that that would be paid 10% of 100% of what's received for that? In other words, it wouldn't be reduced by that, the mass of lithium as you so greatly detailed earlier.
Yes, sir, that's correct.
Okay, thank you.
Any other commissioners? Follow up from council? Mr. Perkins? Mr. Honey? All right, Mr. Reynolds, thank you very much for your testimony. Commissioners, we are, oh, Mr. Hickey, did I pass you by?
Yes, sir. I'd like to ask a couple follow-ups to Commissioner Reynolds.
Well, theoretically, you and Mr. Perkins are on the same side. I didn't let the other side double in terms of direct. Any objection from council?
I think we've plowed this ground pretty thoroughly, and I do.
Yeah, I mean, the way that's why I asked you if you had any witnesses. I mean, this is basically objectioner's case in chief. So having both of you ask questions of the same witness is a little bit far afield, and I'm just gonna ask you not to, Mr. Hickey. I think Mr. Perkins covered it as well as the commission. And I don't think it's fair to the other side for you to double up on one witness like that. If you have your own witness, no problem. All right, with that, commissioners, is it time to take a recess for the day? Mr. Perkins?
Well, I'll just say I only have one more witness. She won't take very long. We won't be introducing any documents. If you'd like to take her, probably 15 minutes max.
If that's the case, is that the prerogative of the commission? Press ahead. All right, and then we'll do deliberations tomorrow. All right, go ahead. Call your next witness, please, Mr. Perkins. I'm sure there would be. If we can get through his case today and take up your rebuttal in the morning, Mr. Daly, that'd be perfect.
Elizabeth Anderson. We let Elizabeth take the seat.
Anderson, would you be so kind? You swear affirm the testimony you're about to give in this hearing is going to be the truth, the whole truth, and nothing but the truth.
Yes.
Thank you.
Elizabeth, would you introduce yourself to the commission and tell them about your background and how you're employed?
Yes, thank you very much. And first and foremost, I want to thank the commissioners here today. It's been a long day and it's very warm, and your public services state of Arkansas does not go unnoticed. I'm a lifelong resident of Arkansas. My family has been part of the state's business community for 5 generations. We operate several land management companies with over 20,000 acres of mineral and surface ownership in Columbia, Union, and Lafayette counties. In addition, I represent majority ownership of Farmers Bank and Trust, the largest financial institution in Southwest Arkansas, founded in Magnolia 118 years ago. I'm the 5th generation employee of the bank. 2 of my great-great-grandfathers started the bank. Just in this past 5 years, Farmers Bank and the Farmers Bank Foundation have had an economic impact of $5 million in Columbia, Lafayette, and Miller counties. My family has been deeply committed to the economic development of Southwest Arkansas and to the well-being of the mineral owners who continue to live, contribute, and pay taxes in our great state. That's who I am.
So I just want to ask you your perspective. I read through a number of the objections. There are a few comments that were submitted to the commission in support of the application here by the applicants today, and notably from local economic development agencies and so forth. And I would like you to tell the commission your perspective on that from both a landowner, a member of the community, and as part of Farmers Bank.
So it's really important to my family and to the businesses that we run that this opportunity is not shut down. If you think about the state of Arkansas, there's been lots of economic development in Northwest Arkansas, Northeast Arkansas, Central Arkansas, but you move past Saline County and you move south and there's just nothing. And this is a once in a lifetime opportunity to provide an economic development for this part of our state. And my hope is that it's this part of the state. It's not Texas, it's not Louisiana. My hope is that these people will want to move here and live here, raise their families here, take them to school here, get involved in the community here. It's really important that we provide that opportunity. But at the same time, as a mineral owner, and I'm going to use a little bit of an elementary example. Say you grew a watermelon in your backyard, and with that one watermelon, you could feed the entire world. But somebody wanted to come and take your watermelon for only $1.82. But you grew that watermelon. It's yours. It's in your backyard. You grew up around it. You managed it. You took care of it. So why wouldn't you want a fair and equitable price for that one watermelon that's in your backyard? These minerals are on property that 5 generations of my family have been a part on. We grew up on these properties. We've had homes on these properties. So it's really crucial that we set a fair and equitable rate that meets the needs and wants of the mineral owners, but yet creates an economic impact for the 5 companies. But yet we have no value on lithium. It seems like every time we talk about the financial aspects of what's it going to cost, what's it going to cost the 5 companies, they kind of shut down and they don't give you any answers. So, but we're here in Arkansas. So the value of lithium must be greater than we all can see, because otherwise we wouldn't be sitting here today. They would be in Texas or Alabama. But they have chosen to invest in Arkansas and build infrastructure in Arkansas and make improvements to Arkansas. So at the same time, let's meet a reasonable rate where we can all be happy and contribute.
Thank you, Elizabeth. Just one more question. So in the long run, when the drilling rigs go back to out of state where they came from, and the pipeline welders are gone, what will be the source long-term of real monetary benefit to the local community? Is it how much money the companies make, or the amount of royalties that go to the landowners?
Well, as you probably know, the amount of money that goes to the landowners is going to be the lasting impression in the state of Arkansas. I have a lot of respect for these big 5 companies. They've come in and they've done wonderful things for Southwest Arkansas. They've made donations to nonprofits that have never received large donations. They've really stepped up their game. But at the end of the day, the majority of them are going to fly home to Houston, and they don't live here. We live here. We pay our taxes here. This is our home in the state of Arkansas. And so I hope you as commissioners will remember the state of Arkansas as well.
Thank you, Elizabeth. Pass the witness.
Thank you, Mr. Perkins. Mr. Honey, Mr. Daly, any questions? Commissioners, any questions? If not, thank you, ma'am, for your testimony.
Thank you for not asking hard questions.
Thank you, Elizabeth.
All right, Mr. Perkins, do you rest at this point?
I rest.
You rest. Mr. Daly, you're going to have some rebuttal. We'll go ahead and go off the record. I guess I need to inquire, do the commissioners need to pack all their stuff up? Can we leave stuff behind? Will this place be locked up? We can leave it behind? Commissioners, what time do you want to convene tomorrow morning? 9 o'clock? All right, we're off the record. We will reconvene here back tomorrow morning at 9 a.m. Thank you all. We're off the record.